Greenwald. I'm pleased to chair the first panel this morning, which is on the transformation of American law firms from the fraternal to business model. And this will be followed by a second panel on transformation continued. So we will continue. We have a very distinguished panel here with us this morning, and we'll get right to it. And our first speaker is Stephen Flanders, who's an independent scholar. His topic for this morning will be Pathways to the Mainstream from the History of the New York County Lawyers Association. And Steve is a polymath, I understand, and he has just published a book called Celebrating the Courthouse, which is about court architecture, with an introduction by Justice Stephen Breyer. So, Stephen?
Thank you very much. It's a pleasure to be here, and I want to begin both by expressing some surprise at being here, and by thanking Mark and Suzanne, whom I don't see, but I'll thank you. Oh, there she is. That's right. This has been an extraordinary event. Being neither Jewish nor a lawyer, I've been asked by several people what I'm doing here, but the short answer is, anytime Mark Galander tells me that I want to do something, I do it, and he's always right, as indeed he was in this instance. This has been a great pleasure, and I want to, again, to thank the many organizers of this excellent event. So I approach the subject of this conference and of this paper with some diffidence, but there may be advantages to the perspective of a relative outsider. In the course of my research for a projected centennial history of the New York County Lawyers Association, which Fordham will bring out next year, I've been often struck by the degree that perceptions of outsiders of New York's once closed legal establishment seem unidimensional. Often, indeed, characterizations I encounter seem closer to the realm of caricature than to the sort of nuanced description that almost any corner of New York's complex social history deserves. This is anything but surprising. If doors are closed, a perspective from outside the door is not ideal for figuring out what's going on the other side of the door. A notable example appears in Norman Dawson's characterization of Justice John Marshall Harlan, for whom he served as a law clerk at the Supreme Court. Early in Harlan's career on the court, when he was fresh from a career as a lion of the New York bar, Harlan's biographer quotes Professor Dawson at length near the start of an epilogue. Not a New Yorker himself, professor and biographer Tinsley Yarbrough relies on Dawson to set the stage for him. Harlan was part of the establishment, as close to an upper-class justice as we've had since Charles Evans Hughes. Dawson then goes on, in rather obvious ways, to characterize Harlan as the quintessential Wall Street lawyer, which he certainly was, at least for his own generation, thereby leaving the plain impression that the conservative instincts of his mentor, they don't want to rock the boat, he says, faithfully reflected the class of such as Harlan and Hughes, presumably old New Yorkers. Of course, it's anything but surprising that Harlan, seen from the perspective of a law clerk, seemed a quintessential representative of New York's upper-class establishment. Harlan's world of white shoe law firms and clubs, most probably closed to Jews at the time, must certainly have seemed a thing apart. But that said, Dawson's view can be made sense of only if we regard his characterization as a bit of legalistic sophistry. Hughes and Harlan were the closest we've had, perhaps, but they actually weren't very close at all. To begin with Hughes, his father had arrived in the New World only 6 years before his birth, entirely with resources, relatives, or connections. By the time his only child was born, Reverend David Charles Hughes had secured a couple of modest posts with country churches in Glens Falls and Sandy Hill, now Hudson Falls, New York. Eventually, with several stops along the way, he found his way to Great Jones Street, a few blocks from here, and then to Green Point across the East River and not yet part of the city. Charles Evans Hughes was indeed a sort of dynastic figure, but only because he helped to found the dynasty. His name comes down to us, of course, via the firm of Hughes, Hubbard & Reed, and via his son, Charles Evans Hughes, Jr. I've been asked, by the way, if there's another father-son pairing that have served as presidents of major bar associations as those two did of county lawyers, and I don't know of any. Harlan, yes, was a Wall Street lawyer, but as we shall see, he shared with most of that breed of the generations preceding the fact that he only became a New Yorker once attracted here as an exciting place to practice law. In this, he follows people like Emory Buckner, who, his partner, who came here after Harvard Law School. Buckner was, as you may know, from Iowa via rural Nebraska. He only came here because Felix Frankfurter suggested it, his lifelong friend. Harlan's illustrious grandfather was, of course, a Kentuckian, where he had served as Attorney General, as unsuccessful candidate for governor, and as unsuccessful aspirant for various cabinet posts in Washington before his appointment to the Supreme Court. John Maynard Harlan, son of one justice and the father of the other, was a Chicago lawyer of some prominence but highly uneven professional success. The family's finances were, most of the time, precarious. So it seems a bit of a stretch to describe the younger Justice Harlan as upper class at all. In any case, he certainly was not a representative of old money New York. I press this distinction because mixed histories of this kind seem to have been the norm, not the exception, at least until recently. The best frame of reference that I can come up with for today in honor of the season is Tim McCarver, whose career might in a way resemble that of John W. Davis. Tim McCarver, as you may know, grew up in Memphis, Tennessee, made it big in St. Louis. When he retired as a ball player, he came to New York to start a new career. He is at this time broadcasting his 17th straight World Series, a record, and he's been described by no less an authority than Roger Angell of The New Yorker as the preeminent sportscaster of our day. So John W. Davis could be called the Tim McCarver of the legal world, and that this is a far more typical kind of a history. It struck me as I came in this morning that a real measure of the disconnect between old money New York and white shoe law firm practice is the complete absence, near complete, of Dutch names in the white shoe firms. Where is the firm of Beekman, Van Wyck, Roosevelt, and Vanderbilt? There is no such firm, and those names don't show up in the names of any of the firms. And I can't, off the top of my head, since this only occurred to me this morning, I haven't had a chance to look this up, but I can't think of a Dutch name in any of the old New York firms, in their names, I mean. Which is not to say that there were no members of those families who practiced law at all. Franklin Delano Roosevelt was a member of the New York County Lawyers Association, but only for 7 years before he was elected president and made an honorary member, and he didn't have much to do with the outfit. And of course, he barely practiced law at all. Among the dozens of notable lawyers who helped found the New York County Lawyers Association, or important in its early years, hardly any were natives of New York. Moreover, most of those few were Jewish. And even there, many of the most important among Jewish founders were born in some faraway small city in America. Hardly any, notably, were born outside the United States. More typical were George Gordon Battle, who was born in rural North Carolina, Joseph H. Choate of Salem, Massachusetts, John Kirkland Clark of Springfield, Massachusetts, and so on through the alphabet to Archibald R. Watson of Holly Springs, Mississippi. County Lawyers numbers among its early presidents and other major figures 3 major party nominees for President of the United States, the aforementioned Charles Evans Hughes of Glens Falls, or Alton B. Parker of Cortland and Esopus, New York, and John W. Davis of Clarksburg, West Virginia, who actually represented that state in the U.S. House of Representatives, among other notable offices, before coming to New York and helping to found the law firm that still carries his name. There are only 2 exceptions to this pattern in the population I am drawn into through the history of county lawyers: the political opponents Samuel Seabury and Charles S. Whitman. The latter was from a prominent family of politically active New York lawyers and Republicans and had the charmed history that goes with the class. Seabury, though there's never much indication of money, was from an old New York family as well. One of NYCLA's most important presidents, He was from a family of Episcopal churchmen that went back to 17th century New York. What all of this suggests, by way of prelude, is that New York's legal establishment early in the 20th century was, in a peculiar sense that seems to hold no longer, more open than many would imagine at the very time that most large firm practice was closed to Jews, to women, for the most part to Catholics, and most emphatically to blacks. Yet noticeably open it was. The architect and dean, Robert A.N. Stern, found himself quoting Mark Twain, probably unwittingly. In Boston, they ask, "How much does he know?" In New York, "How much is he worth?" In Philadelphia, "Who were his parents?" Someone, someday, should undertake a comparative social history at some level, exploring how this came to be and how a joke that seemed apt in the 19th century still has a bit of resonance in the 21st. But the law is surely the most sociable of the professions, and thereby the one in which social connections, or the lack thereof, will always matter more than in other lines of work. As the age of the modern corporate law firm dawned, along with the 20th century, it was difficult, not impossible, but surely difficult, for Jewish lawyers to find employment except in Jewish firms or on their own. And that wasn't the only problem. The New York County Lawyers Association was founded in 1908 specifically to open the doors of the life of the law in New York to Jews and to other minorities and to women. This was a remarkable event several times over. It was precipitated by the searing experience of Judge David Leventritt, 1845 to 1926, as he endeavored to establish and extend a distinguished judicial career, following a notable career at the bar. Like so many of those I've mentioned, he was not a native New Yorker, though he came closer than most. Born in Winnsboro, South Carolina, he moved here with his parents in 1854 as he approached his 10th birthday. Elected to the Supreme Court of New York County, he resigned in April 1908 to return to private practice. Largely, this was in response to the bruising effort he had to undertake to attain and attend a judicial career in the face of action by the Judiciary Committee of the Association of the Bar of the City of New York, which found him unfit for judicial service on grounds widely believed to reflect anti-Semitism and nothing more. According to the memorial by Louis Marshall, published by NYCLA following his death, so universal was the respect paid to him that, after he had been on the bench for 7 years, the very men who, when he was a candidate for office, opposed him, took it upon themselves to initiate a movement which resulted in expunging this adverse action from the records of the association and commending his judicial conduct in the most laudatory terms. The portrait of Charles Strauss that hangs prominently on the wall of the second-floor lounge in the Home of Law of County Lawyers refers to him as the founder. This might seem a bit surprising because his name appears on the founding certificate of incorporation of 1908, along with lots of other names. And moreover, whilst Strauss served as secretary from 1908 through 1914, he was not elected president until 1921, when he replaced Charles Evans Hughes upon the latter's appointment as Secretary of State in the Harding and eventually the Coolidge administrations. Though he became a vice president after his tenure as secretary was over, until 1921, Strauss's name is not otherwise distinguishable in the NYCLA firmament from those of a galaxy of legal stars whose names live on in the names of famous firms. We find notables such as Paul B. Cravath, Louis Delafield, John Dillon, Harry Hubbard, Rastus Ransom, Samuel Untermeyer, and Charles S. Whitman, among others who are identified with major law firms, Columbia Law Dean George W. Kirschway, Court of Appeals Chief Judge and Democratic presidential candidate Alton B. Parker, Legal Aid Society President and Guiding Spirit Arthur von Briesen, and so on. Strauss, on paper, is only one of many. Review of early records of NYCLA in combination with a remarkable bit of oral history that takes us back nearly a full century confirms that Strauss may deservedly be known as founder. This is true in the important sense that without Strauss, the founding events would not have taken place. The oral history in question is from a fellow named James Spitzer, who is nearing 100 years of age and was a protege of Strauss. Knew him beginning when at the age of 12, around 1920, is that before 1920, and recently dissolved the successor firm of Spitzer and Feldman, he remembers Strauss's first-person accounts of the founding of the New York County Lawyers Association intensely, and everything that he has said to me, I've been able to, not everything, but everything that I have been able to check has been correct. So I do have a genuine first-person account, almost, of something that occurred almost 100 years ago. Though Strauss remained somewhat in the shadows for a time of the distinguished colleagues at the bar he brought in to help add luster to his project, his guidance and support were essential as NYCLA grew in only a few years to become the largest local association of lawyers in the world. I asked Mark about this once. Maybe there's something in India that's bigger. We can't think of anything. We know from many contemporary declarations that there was general agreement among the founding generation that Strauss was the founder. For a single example, when Strauss died in 1934, beside a lengthy and respectful Times obituary appears a paid death notice from NYCLA, signed by Charles A. Boston, about whom you're about to hear more, association president at the time and one who had been active almost at the creation, expressing the profound regret of the officers and staff concerning the death of, quote, our founder, singular. And that's in 1934. Charles Strauss was too skilled a lawyer to permit his brainchild to seem like a straightforward personal creation. A mission it was, nonetheless, for this distinguished practitioner. He was determined that New York was to have a bar association that was open to all who met the rigorous standards for admission to the bar. It was he who convened the initial meeting of legal notables in the basement of the old Knickerbocker Hotel, at which the course was set, and the co-founders meeting met later in Carnegie Hall. These were hardly a collection of the shunned and the excluded pressing their noses against the glass as they tried to gain admission to the inner circle. Of the initial 30 officers and directors, 17 were members of the city bar. And as matters unfolded over NYCLA's early decades, one might wonder if any bar association could lay claim to such a distinguished roster. Two major party nominees for president, a U.S. president's brother, a chief justice, and so on. This was Strauss's personal accomplishment in significant degree. Later accounts of the founding years by Charles Boston, J. Noble Hayes, and John Brooks Leavitt, participants in the early deliberations, all emphasized Strauss's capacity to draw the luminaries of the bar into this project, and that's something on which Mr. Spitzer is quite voluble. Strauss appointed a committee of 25 that speedily grew to 150, which circulated all New York lawyers on the possible need for a new and more open lawyers' association. Over 3,000 responded. The new association got off to a rousing start. Within a year, actual membership was nearly twice that of the city bar, which had been in existence for almost 40 years. A great deal of pent-up energy seemed to drive the new committees right from the start. In particular, the Committee on Ethics, about which you're to hear more in a moment, made a mark immediately. Strauss was I'll mention, perhaps because you will not, that the opinions of the committee, of those committees, the committees related to unlawful practice and ethics, became central to the curriculum of many law schools, and they were praised and quoted at length by Harvard Law Dean Roscoe Pound. Strauss was central to the direction and affairs of the growing association until his death in 1934, and I guess I will skip over his quote since I am a little short of time. It is my conviction, not yet provable, but I think demonstrably probable, that the New York County Lawyers Association played a significant part in the process by which Jewish lawyers in New York joined New York's legal establishment. This was a slow but steady process that doubtless is better illuminated by others. It began before County Lawyers was founded and continued for many decades, at least through the 1960s, but perhaps the process remains uncompleted today. Henry W. Taft, one of those who served as president of both associations, declared that in 1882, 31 of City Bar's membership had been Jews, or somewhat under 5%, a figure that by 1939 had increased to about 11%. I refer to City Bar's membership practices on this point as a triumph of tokenism. Evidently, there were Jewish members from the very start or shortly thereafter, few or none of whom were recent immigrants of Eastern European origin, yet this minority was unable or unwilling to forestall the kind of anti-Semitic action that led to the establishment of county lawyers. Mr. Leventrit himself provides a notable example not only of efforts leading to the chamber chairmanship of NYCLA's Judiciary Committee, but also on various bodies related to lawyer misconduct. Seemingly as a consequence, the appellate division appointed him to chair the Committee on Character and Fitness, where he served for many years. While this might today seem a rather specialized, demanding, and even thankless task, it must have seemed striking in the second decade of the century, a time when restrictions were common in everything from law school admission to real estate and club membership for a Jew to preside over the process of admission to this most sociable of professions. I'll skip over Julius Henry Cohen because you're about to hear more about him. Another early example is Max Stoyer, probably the best-known New York trial lawyer of his day, who served for many years on NYCLA's Judiciary Committee when it was chaired by Charles C. Burlingham. Others who served at that time were George Wickersham, William Breed, George Medallia, Alton Parker, and so on. Without multiplying the list unduly, I note finally the contributions of pioneer Carolyn Klein Simon, 1901-1993, who worked tirelessly on countless NYCLA initiatives before and after she achieved numerous firsts for political women in New York around mid-century. Probably she's best remembered today for her advice to young women on how to get along in a man's world. Look like a girl, act like a lady, think like a man, and work like a dog. NYCLA's establishment was a remarkable achievement that I believe was of considerable importance, not measurable, but considerable, in the integration of Jews into New York's legal mainstream. And I guess I will skip to the end of my remarks by providing you, in closing, with two ironies about county lawyers and its place in this process. Ironically, a topic that I leave for others for another day, it appears that the New York bar has become more insular at the very time that it is becoming more open. It seems certain, though I cannot demonstrate this today, that a far higher proportion of top New York lawyers today are lifelong New Yorkers than was true 100 years ago. Once again, many of those today are, of course, Jewish. And I will share with you another irony. For many years, NYCLA had an informal yet ironclad practice by which the presidency alternated between a Jew, a Catholic, and a Protestant, sort of like the beloved New York tradition of the balanced ticket in Board of Estimate days. But the balanced ticket, being designed to appeal to voting constituencies, was a tolerable reflection of ethnic voting power. It is probable that Jews amounted to close to 3/4 of NYCLA's membership around 1960, which, since at that time Martin Mayer declared on reasonable authority that Jews were 60% of the New York bar. 3/4 of the membership get only 1/3 of the presidencies. Few quota-bound prep schools or Ivy League universities are likely to have insisted on so drastic a disproportion. When Daniel Draper, invited by Boris Kostelanetz to join NYCLA, expressed surprise to his staffer at his rapid rise on his route to the ultimate presidency, he was told, "There aren't very many of you around." At the time, he had no idea what the "you" in question referred to, but he figured it out. Thank you.
Thank you, Steve, for a fascinating look at the County Lawyers Association and its history. Our next speaker is Samuel Levine, professor of Pepperdine University School of Law. His topic today is Rediscovering Julius Henry Cohn and the Origins of the Business Profession Dichotomy. Professor Levine has written on Jewish legal theory and American constitutional theory and American legal practice through a perspective of Jewish law, ethics, and tradition.
Thank you, Steve. And thank you, Steve. I'm looking forward to seeing the book. And thank you, Suzanne, and the planning committee for organizing such a wonderful conference and for inviting me to participate. Can you hear?
Got to get in a little closer.
Okay.
A little bit closer.
Since at least the earliest years of the 20th century, prominent segments of the legal community have accepted and adopted the assertion that the law is no longer a learned profession, it has become a business. In response, the past century saw repeated and sustained professionalism movements aimed at promoting an ideal of professionalism in legal practice. Each of these movements was confronted by various forms of criticism and opposition on both descriptive and normative grounds. The prevailing division among leaders of the practicing bar and the legal academy alike has produced, in the words of one scholar, a perennial debate. To many of its critics, early 20th century legal professionalism was characterized by, if not premised upon, numerous vices, including anti-Semitism, nativism, classism, economic protectionism, and general elitism. My article, which is published, and I think you have before you, considers the discourse and underlying attitudes of early 20th century legal professionalism through a close analysis of Julius Henry Cohen's 1916 book, aptly titled The Law, Business, or Profession. I suggest that although Cohen shared and relied upon many of the concerns of his contemporaries over the commercialization of legal practice, he offered a unique vision of professionalism, one that eschews notions of bias and self-interest in favor of intellectual honesty and a sincere concern for the good of society. The part of the article I want to focus on in the context of this conference, drawing in part on what we talked about yesterday and what Steve talked about, contrasts Cohen's rhetoric and underlying approach to professionalism against the often anti-Semitic, nativist, and classist attitudes expressed by leaders of the organized bar in discussions of professional misconduct and bar admission standards. Other parts of the article, which I don't expect to focus on right now, consider Cohen's support for stricter standards in legal education and prevention of the unauthorized practice of law, in spite of his rejection of the kind of economic protectionism that often accompanied called by others for higher standards, and Cohen's ability to promote law as a profession and not a business without engaging in the elitism popular among segments of the legal community of his time. In his study of elite lawyers of the 20th century, Gerald Auerbach develops a thesis that in the early part of the century, although lawyers spoke the language of professionalism, their vocabulary often masked hostility toward those who threatened the hegemony of Anglo-Saxon Protestant culture. Based on the rhetoric of leaders of the organized bar who called for stricter educational and admission standards, Auerbach argues that professionalism and xenophobia were mutually reinforcing, finding expression in anti-urbanism, anti-Semitism, and nativism. While some have disputed Auerbach's assessment of both the prevalence and influence of these attitudes, there appears to be broad historical support for Robert Stevens' finding that, quote, wherever one looks in the literature of the period, the establishment expressed concern about the background of those who were alleged to be demeaning to the bar. Auerbach's documentation of anti-Semitic and nativist rhetoric underlying early 20th century calls for professionalism provides a helpful setting for a consideration of Julius Cohen's unique approach. In support of the thesis captured in his title, that law has become a business rather than a profession, Cohen dedicated most of the first half of the book to a critique of the standards of training and education required for admission to the bar in the United States. However, a careful reading of Cohen's extensive argument reveals an apparent absence of any form of bias on the basis of class, ethnicity, or country of origin. Instead, in formulating both the substance and language of his argument, Cohen consistently relied on an intellectually honest analysis of the issues rather than vituperation and innuendo. Cohen maintained his own rhetorical integrity while at the same time allying himself with and relying on leaders of the legal establishment whose public statements reflect the kind of prejudice noted by Auerbach and others. One of the most prominent figures in Cohen's book, mentioned by Steve, is Charles A. Boston, who at the time the book was published was chairman of the Standing Committee on Professional Ethics of the New York County Lawyers Association. Boston first appears in the book's opening pages as one of two individuals Cohen acknowledges for the inspiration and leadership in work that makes the natural occasion for this book. Elsewhere in the book, Cohen describes the unique circumstances of his close relationship with Boston as part of what he describes a group of lawyers who met socially to discuss among themselves the practical questions that come under their observation where the application of principles of ethics to actual situations become necessary or advisable. Cohen refers to the group, with a capital G, a self-consciously elitist group in its membership. It was small in number, and the identity was to be kept entirely private and confidential. Writing with apparent pride, Cohen notes that while the group has been together for 8 solid years, the identity of its membership is still known to but a few. Cohen considers Boston largely responsible for the development in this country of a new and vital interest in the ethical relationship of the lawyer to his client, to the court, and to the public. In a footnote, Cohen cites numerous speeches and articles by Boston, his friend, on the subject of legal ethics, including a piece in the May 1908 issue of the Greenback. Like Cohen, Boston decries the decline in legal practice from what he calls an honorable profession to a trade. Unlike Cohen, however, Boston resorts to language that portrays not only the kind of masked hostility that Auerbach describes, but actually an open animosity toward groups that, in Boston's view, possess characteristics unworthy of lawyers and were responsible in part for what he called the deterioration of the bar. Boston nostalgically recalls the days when Alabama, for example, was a homogeneous community where the law was an honorable profession and not a trade, and where the practices of many races, and this does not refer to African Americans who weren't really involved in the bar at the time for other reasons, and of commercial craft had not destroyed notions of ethical standards. In an analysis of the conditions in the largest cities, Boston declares that in New York, many men select the practice of law as a business, and some are, I fancy, ignorant of ethical standards. Success, as they define it, is the only standard they know. Boston regrets that the bar is too numerous and too heterogeneous for any central influence. He lists forces working for deterioration, including the ambitious and intellectual capacity of Oriental immigrants, again not referring to the Far East, with no apparent conception of English or Teutonic ideals. The terms that Boston uses clearly are indicative not only of nativism, but of open anti-Semitism, an attitude that was not uncommon among leaders of the organized bar. Just a few years after the appearance of Boston's article, Walter George Smith, in the annual address of the chairman of the section on legal education of the American Bar Association, echoed Boston's sentiments, describing the misfortune resulting from, quote, the mixed character of our population, and again, the steady influx of races that have none of the traditions that centuries have handed on to those who have inherited our ancient ideals of private and public honor. Using many of these same code words, Smith speaks of ambitious youth and voices regret for not having succeeded in keeping undesirable men from the bar by the intellectual test, at least not in larger cities. According to Smith, it is the universal observation that a class of practitioners have come to the bar who are totally lacking in a high professional feeling that has been our tradition, whose objects are purely commercial, but who never fail in any intellectual test that may be applied to them. 2 years later, again addressing the ABA, Smith apparently found it unnecessary to cover his anti-Semitism with even the thinnest veils, dispensing with the code words and plainly stating that, quote, we have in the eastern cities many representatives of the most ancient race, of which we have knowledge, coming up to be admitted to the practice of the bar. They are gifted with a marvelous intellectual ability and great power of concentration. They exercise extreme self-denial in overcoming their environment of poverty. Frequently, it has been my lot to see men of that character who are surprised when informed that they have done anything wrong. Moving from anti-Semitism to a broader form of nativism, Smith adds that, quote, those who come to the bar without the incalculable advantage of having been brought up in the American family life can hardly be taught the ethics of the profession as adequately as we desire. Smith connects these attacks to a more general, quote, truism among us who practice in the larger cities, that there has come a change in the tone of the profession, a lowering of standards, a commercializing. Although Julius Cohen agreed with the assessment, which forms the basis of his book after all, that commercialization of legal practice had reduced law from a profession to a business, Cohen's rhetoric did not betray the biased sensibilities exhibited by his friend and colleague Boston, by Smith, and by many others in the legal establishment, many of whom were likewise his friends and allies in various movements, including George Wickersham, and he refers extensively to an address by Louis Delafield, which likewise contains much of the same language and attitude. Cohen's approach, instead, presents a particularly striking and telling contrast when juxtaposed against one of the most infamous examples of anti-Semitic rhetoric among leaders of the organized bar, many of you may be familiar with, an address to the section of legal education and admission to the bar, presented at the 1929 annual meeting of the ABA. Henry S. Drinker, one of the great legal ethicists of the time, surpassed many of his predecessors in producing an especially virulent combination of classist, nativist, and blatantly anti-Semitic language. Drinker uses many of the same code words describing these fellows that come out of the gutter and are catapulted into the law, who have done the worst things and did not know they were doing wrong. As Drinker saw it, they were merely following the methods their fathers had been using in selling shoestrings and other merchandise, that is, the competitive methods they use in business down in the slums. Drinker concludes that those who did not associate with the American boys were not apt to realize that they were doing anything wrong. Like Smith, Drinker moves from these code words to open anti-Semitism, recalling that during his service on the Grievance Committee in Philadelphia, of the men who came before us who had been guilty of professional abuses, an extraordinarily large proportion were Russian Jew boys. Drinker then proceeds with a lengthy depiction of the Russian Jews, and the other foreign Jews too, who come over to this country, all afire with, again, a tremendous ambition that somebody in their family shall make good. According to Drinker, if they have 4 or 5 boys and 2 or 3 girls, they pick out the one that is the smartest, and they all make a sacrifice to let that boy get an education. Therefore, with a tremendous pressure back of him to succeed, the boy has to make good. The whole family have been sacrificing themselves so he can. As a result, he comes to the bar with no environment at all except that out of which he came. He has not had the chance to absorb the American ideals. Drinker's response is, the moral of this is to give these foreign boys who are being admitted in droves to the bar in Philadelphia, and I'm sure in New York, a chance to absorb American ideals. Drinker concludes that if such a boy had a chance to mix with American boys and to absorb the American boys' idea of fair play, at least he would have known, again, when he was doing something wrong. It's difficult to assess the accuracy, or if accurate at all, the implications of Drinker's statistics or of his sociological analysis, as it is. However, to the extent that such a substantial proportion of lawyers facing professional discipline in Philadelphia may, in fact, have been immigrants, it's likely that a similar phenomenon may have occurred in New York as well. Julius Cohen was on the committee, as you mentioned, on unlawful practice of the law in the New York County Lawyers Association. Undoubtedly, he would have been familiar with these circumstances if they existed in New York. In the course of his book, however, which includes numerous and varied scenarios of disbarment, documented in great detail, Cohen does not mention class, religion, or national origin. Although at one point in the book, Cohen does make reference to the professional abuses of Russian immigrant lawyers, his analysis of the causes of this behavior is decidedly and tellingly different from Drinker's. Unlike Drinker's portrait of Russian immigrants, which may be fairly characterized as impressionistic at best, Cohen offers his own perspective only after careful consideration of the Russian legal system that immigrants experienced prior to their arrival in the United States. Cohen briefly discusses Russian immigrant lawyers in the context of a broad and extensive survey documenting the international prevalence of the notion of the lawyer as an officer of the court. Quoting a study of the Russian legal system, Cohen describes the Russian bar of the late 19th century as, quote, animated by a rapacious, commercial, mercenary spirit. Cohen cites a number of fraudulent practices among the lawyers in Russia, including the use of dishonest means for raising the price of a fee and demanding a large sum for secret purposes. That is to say, for, quote, greasing the palm of influential officials. The old belief that litigation and criminal procedure are a kind of difficult game in which victory must always be on the side of the most dexterous player, irrespective of justice and equity, and that bribery and backdoor influence are indispensable for success, is still deeply rooted in the popular mind. As a result, among the people, especially the uneducated mercantile classes in Russia, there arose a blind, childish faith in the omnipotence of the most celebrated advocates, and some of these, dexterously using their faith for their own ends, have succeeded in amassing large fortunes in an incredibly short space of time. Against this backdrop in particular, Cohen suggests, we begin now to understand why the Russian immigrant, coming during the 80s and 90s direct from their atmosphere of trickery, bribery, professional misconduct, judicial dishonor, and barter and sale of justice for money, upon arrival in America, looked for a similar kind of administration of justice. Cohen concludes that the Russian immigrant of the 1890, 1900, or 1910, who drew upon his home experience for ideals of our profession, was certain to think of all of us as purchasable and purchasable for any kind of service. A close look at Cohen's and Drinker's statements reveals that, again, Cohen did not disagree in principle with many of the claims of those who advanced this nativist brand of professionalism. The substance of Cohen's analysis anticipates and precedes by 13 years Drinker's concern that Russian immigrant lawyers may in fact exhibit a tendency to engage in professional misconduct as a direct result of their exposure to the mores of the Russian legal practice rather to American ideals. At the same time, however, any similarity in substance only highlights further the difference in discourse and the corresponding underlying attitude reflected in Cohen's approach to professionalism. In sharp contrast to Drinker's reliance on anti-Semitic stereotypes and speculation, Cohen makes no reference to religion and avoids anti-immigrant rhetoric. Instead, Cohen offers a nuanced and largely sympathetic portrait of Russian immigrants in an attempt to understand the immigrant experience and its relationship to the practice of law. Of course, it's possible to suggest that Cohen's resistance to anti-Semitic and nativist statements and his apparent rejection of the sentiments underlying their expression resulted from a conscious recognition by Cohen of his own Jewish background, his own Jewish heritage, and a corresponding unwillingness to appeal to prejudice in support of his own arguments. Such a hypothesis, though certainly plausible, may fail to recognize fully the complex variety of Jewish identity, which was mentioned yesterday, in particular as manifested in New York in the early part of the 20th century. To begin with, it's not clear to what extent Cohen actually valued either his Jewish heritage or any connection to the broader Jewish community. Cohen's legal work on some level does echo that of many Jewish lawyers at the time. These lawyers represented often new immigrant groups, unionism, use of arbitration in industrial pursuits, public service. He was involved in many of these areas, which again were representative of many leading Jewish lawyers at the time, and to some degree may have grown out of a sense of Jewish values and responsibility to Jewish communal needs. On the other hand, Cohen himself, later in his memoirs, describes some references to his own Jewish faith, and I think they can be described at best as ambivalent. He does describe repeated instances of working with members of the Jewish community. He shows a knowledge of certain areas of Jewish law, and he includes references to works that are printed in Hebrew, which he apparently cited in an argument before the United States Supreme Court. On the other hand, Cohen writes, quote, "Father always thought that he had made a mistake in adopting the name Cohen instead of the name Garnett. And he thought I should not repeat the error." He also talks about, he doesn't talk about Jewish religious observance per se, but Cohen writes with great relish of the first deviled pig's feet he ate and his first taste of roast suckling pig. And Cohen was clearly self-conscious about the implications of having eaten these foods because he also tells a story about a breakfast between Governor Al Smith and Judge Joseph Proskauer, at which Cohen emphasizes that despite serving as chairman of the American Jewish Committee, Judge Proskauer ordered ham and eggs. He also, on the very first page of his memoirs, Cohen adopts the position of Dr. Felix Adler, who founded the Society for Ethical Culture, and Cohen states that all peoples are God's chosen people, apparently rejecting the notion of any unique role for the Jewish nation that Ruth talked about yesterday. He also emphasizes the influence Dr. Adler had on him and on his work in the New York County Lawyers Association and his lawyering views in general. In addition to questions about Cohen's view of his Jewish heritage, as we talked about yesterday, among the more successful and established Jewish lawyers, it wasn't uncommon to espouse and exemplify the same professional values favored by elite Protestants, as some put it, apparently including at times nativist attitudes directed at Jewish immigrants themselves. Auerbach quotes the remarks of one successful Jewish immigrant lawyer who in 1929 referred to attorneys who could not speak the King's English correctly, who by character, by background, by environment, by education, were unfitted to be lawyers. In light of the presence of these attitudes, even among some Jewish lawyers, the absence of such nativist rhetoric on the part of Cohen, who was born in the United States and enjoyed positions of prominence among the elite legal establishment. He was prominent in such establishments as the Association of the Bar of the City of New York, a much more elite body than the New York County Lawyers Association. His attitudes would appear to take on an even greater significance. Ultimately, though perhaps influenced in part by his own religious background, Cohen's approach to issues of ethnicity and natural origin appeared to be based in profound and fundamental aspects of his unique and more inclusive vision of professionalism. Just to close, and maybe appropriate for this setting, historians have long recognized that any attempt to evaluate the conduct of those who lived earlier through the lens of contemporary sensibilities presents a challenging, if not precarious, proposition. The Talmud reflects this difficulty in considering the biblical reference to Noah, as righteous in his generation, commenting on the apparent superfluity and ambiguity inherent in the phrase, in his generation. The Talmud offers alternative interpretations. Some understand the verse as highlighting Noah's ability to maintain his righteousness despite the wickedness of the generation in which he lived. Conversely, others explain that Noah was righteous only relative to the wickedness that surrounded him, but that his own character would not have been particularly noteworthy, for example, in an age of Abraham, an age of greater moral sensitivity. Among the many notable aspects of the debate, it's interesting to note that even according to the latter position, that Noah was righteous only in his generation but would not have been particularly notable or stood out in Abraham's generation, the Torah nevertheless does not hesitate to praise Noah as righteous, even in a relative sense. In light of the changes that have transpired in the legal profession in the course of the 20th century, corresponding to broader changes in American society as a whole, the rhetoric of the leaders of early 20th century professionalism strikes a discordant and disturbing note. On some level, it seems unfair to expect the organized bar to have overcome completely the anti-Semitism, nativism, classism, economic protectionism, and elitism that were so endemic to the society in which they functioned. Indeed, to the extent that many of these leaders recognized and combated the ethical problems that confronted the legal profession in the early part of the century, perhaps, like Noah, they too should be the subject of praise, if only in relative terms. Nevertheless, despite the possible appeal of such a position, it may be difficult to maintain in the face of the contemporaneous work of Julius Henry Cohen. Cohen embraced and promoted professionalism, but he expressed his views through a mode of discourse largely free of the vices that plagued the rhetoric of so many of his friends and associates among the legal elite. In fact, to the extent that Cohen's rhetoric was not entirely free of such attitudes, perhaps he would serve as a more apt analogy to Noah, as someone who was not particularly righteous, perhaps by current standards, but whose work is deserving of praise when evaluated relative to the society in which he lived. In any event, his articulation of his alternative vision of professionalism may serve as an indictment of the early 20th century legal establishment and its failure to adopt a mode of discourse that would have served the goals of professionalism movement while maintaining its rhetorical integrity. Thank you.
Thank you, Sam, for insight into the wisdom of the early bar leaders of the early 20th century. Our next speaker is Professor Lawrence Mitchell of George Washington University Law School. The topic of his talk will be, with a movie reference, Gentleman's Agreement, the Anti-Semitic Origins of Restrictions on Stockholder Litigation.
Thank you.
Larry, his expertise is in corporate law, and that's part of the reason for this paper.
Right, I'm the odd man out here. Thank you, Mark. Thank you, Suzanne. My offering today is rather modest compared with some of the wonderful and richly woven theoretical and historical insights that we've been privileged to share over the past couple of days. I'm going to take a single, simple, straightforward provision of the New York General Corporations Law, which was enacted in 1944, and try to demonstrate that the motive underlying its passage was deeply anti-Semitic and designed to put a large segment of the New York Jewish bar completely out of business. I will then, if time permits, suggest in a far more tentative way that the lingering shadow of Shylock hovered over Congress's enactment of the 1995 Securities Reform Act, which in its own turn attempted to shut down securities class actions, also the province of the Jewish bar. Lawyers may be, as Mark told us yesterday, the new Jews, but I will argue that a Jewish lawyer, at least in mid-century, was by other lawyers still a Jew. Section 61B of the New York General Corporation Act was passed in March 1944, only 2 weeks after its introduction in the New York State Legislature, and with less than 2 days of debate. The statute required that a derivative suit plaintiff who owned less than 5% of a corporation's stock had to post securities for expenses, including attorney's fees, in an amount of more than $575,000 in 2006 dollars. The statute was the product of a privately and voluntarily undertaken year-long study by the New York Chamber of Commerce, a non-governmental organization composed mostly of members drawn from large corporations and banks. The report was released for the first time together with the introduction of the bill, leaving no opportunity for reflection, refutation, or argument. By any measure of intellectual or scholarly integrity, the report's conclusions regarding the scourge of derivative suits in corporate America and the need to shut them down is so flawed as to question all of its conclusions. What is beyond question is that the business of representing plaintiffs in derivative suits was, as it remains today, largely a Jewish business. In 1944, the business of defending corporations and banking interests was indisputably the business of white Anglo-Saxon Protestants, the very same men who staffed those banks and corporations. Section 61B, enacted in an atmosphere of WASP status panic and heightened American anti-Semitism, was just designed to chase the Jews out. There's no doubt at the time, by the way, that the statute would accomplish this result. The Jewish lawyers representing derivative suit plaintiffs typically either were sole practitioners or worked in firms of 2 or 3 lawyers at the bottom of the legal financial ladder, earning a median annual income of less than $30,000 a year in 2006 dollars. That puts them, I believe, pretty close to the poverty line. In any event, the plaintiffs who owned the stock certainly couldn't finance these suits, and neither could their lawyers. It was only when judges of the New York Court of Appeals reversed lower court rulings and allowed potential plaintiffs to aggregate their stock in order to meet the securities for expense restrictions that the only method of restraining corporate executives' malfeasance was saved. Now, my story, of course, is circumstantial. I couldn't find a document anywhere that reveals an insidious plot to push Jewish lawyers out of business. So a lot of evidence lies in the statistical data. Rather than distract you with slides, and besides, I don't know how to use PowerPoint, I'll summarize the data which I present in far more detail in the paper and tell sort of a more general story from it, although I can't really compete with Sam's anti-Semitism stories, at least in color. So to set the context, in 1944, the year of the statute's enactment, was, interestingly, probably the apex of American anti-Semitism. The apex, of course, because 1944 was the year before European Jewry had been completely wiped out. Polling data show this. We don't know as much about the era before polls were kept, but of course Jews were less a presence in daily American life earlier in the 20th century than they were by the 1940s. And this kind of polling data may have a significant likelihood of underreporting because even then the racist answers were slightly unattractive. So the numbers, which are pretty striking in and of themselves, may be even more striking than they appear. So just for a few statistics, in May 1938, 36% of respondents agreed that Jews had too much power in America. In 1945, 58% of Americans agreed with this statement, despite the fact that the annihilation of European Jewry was then well known. In 1941, Charles Lindbergh gave his famous Des Moines speech for the America First Committee. Lindy, of course, was well-educated. His dad in Congress in 1917 introduced a resolution to impeach the entire Federal Reserve Board as an international Jewish banking conspiracy. So Lindbergh gave his speech and accused three groups of drawing Americans into the war: Jews, the Roosevelt administration, and the British. Later that year, 40% of the survey respondents remembered the accusation against Jews, 31% against the Roosevelt administration, and 21% against the British. In June 1944, 24% of respondents identified Jews as the greatest menace to America, compared with 9% accusing the Japanese and only 6% accusing the Germans. In 1940, 46% of respondents claimed to have heard negative comments about Jews in the preceding 6 months. In 1946, the year after the war ended, still 34% had. There's some more data. I don't want to take too much time with this. One of my favorite is the 1942 survey, who asked high school students who would be their last choice as roommates. We joined with the African Americans, who scored 78%. We came in at 45%. So in any event, I just to wrap this up, and I'm indulging myself a little bit, but the article is just too precious for me not to share. I'd like to talk about a 1955 article in Look magazine entitled "The Position of Jews in America Today." The author, who was actually quite sympathetic to American Jews, could still ask such questions revealing ancient anti-Semitic saws as, why are there so many Jewish organizations? Having presumably not read Tocqueville, and what makes Jews so clannish? He could make such affirmative statements as Jews do tend to be clannish. For centuries, the Jews were misfits. Some Jews tend to be over-aggressive. A great many are hypersensitive in their relations with Gentiles. And perhaps most astonishing of all, and apparently as evidence of this last statement, they seem to have a special exposed nerve that registers every tremor of prejudice like a seismograph. So you see, this is all biological. And what proves our hypersensitivity is let a Gentile use an idiomatic phrase like, he Jewed me down, and every Jew within earshot will mark him as a bigot. We are an oversensitive people. Anyway, so the minimum, anti-Semitism was imminent in the United States and fairly well accepted. And if the title of my paper, Gentleman's Agreement, the wonderful novel, shows the degree of subtle, rather than the kind of crude anti-Semitism that Sam was talking about. We're talking about a much more refined, high-class anti-Semitism. The next phase of my study is the demographics of the New York bar, which relies heavily on the demographics of higher education, in which anti-Semitism played its own distinct role. The first set of data I use are drawn from a study published in 1939 by Melvin Fagan on behalf of the Conference on Jewish Relations, and it was summed up by one Jewish lawyer's comment: "The practice of law is a dignified road to starvation." Slightly more than half of all New York lawyers, in New York City lawyers in 1937 were Jewish. There were 22,000 lawyers. There were about 11,000 Jewish lawyers, of whom about 9,500 practiced in New York County. Law school was a direct determinant of practice status. 66.8% of these Jewish lawyers attended non-elite schools. And in the paper, I go through the income distribution and practice situation of New York lawyers, which I won't overemphasize here. But they demonstrate fairly starkly that Jews were overwhelmingly sole practitioners. Only 11% of Jews reported any kind of corporate practice, and that was almost exclusively close corporation practice. This data is kind of reinforced 20 years later by a 1960 study by sociologist Jerome Carlin, which shows where a lawyer attended law school, which was substantially dependent upon where he attended college, was the principal determinant of his practice status and income. Again, a couple of salient points. 70% of Protestants of high socioeconomic status attended Ivy League or other elite colleges. Only 34% of Jews of high socioeconomic status did. On the low end, 28% of low-status Protestants attended these schools, and only 9% of similarly situated Jews did, leading to the conclusion that a low-status Protestant was almost as likely to attend an Ivy League school as a high-status Jew. Why does this matter? Well, 77% of large firm lawyers attended Ivy League law schools, and only 20% of small firm lawyers and sole practitioners did. And attendance at an Ivy League law school pretty much required attendance at an Ivy League college. But it's not just about law school and college. Race seems to have played an independent role. Only 19% of Jews with a top education were members of large firms, compared with 45% of Protestants. As Carlin notes, a Jewish lawyer who achieved high academic standing, that is, staff of the law review at an Ivy League school, has no better chance of being at a large firm than a Protestant who did not make law review and attended a non-elite school. Well, there's a lot more I could talk about in terms of the data, but I'd like to now turn to the Chamber of Commerce report supporting the Act's passage, which I refer to as the Wood Report after its principal author, Franklin Wood, a founder of the firm of Hawkins, Delafield and Wood. Sam mentioned Louis Delafield before. Wood, among other things, was a member of the Bronxville Board of Zoning for 10 years. In the course of my research, I called the Bronxville town librarian to ask a little bit about history. And after we talked a bit, and I was quite frank with her about why I was calling, she reassured me that things had changed. She said, after all, one of our people is married to a Jewish woman. This was just a couple of years ago. In any event, I examined the Wood Report carefully and note the methodological flaws that lead to conclude that 61B, or that lead it to conclude that 61B, the derivative statute, was the solution to abusive derivative litigation. I can't go over all of them, but suffice it to say, the report doesn't even come close to proving its point. First, a survey of the law review literature from 1900 to 1944 shows only 44 articles, almost all of them student notes, even addressing the concept of derivative suits. The overwhelming majority of those had to do with directors' fiduciary duties and nothing to do with derivative suits at all, and half of them occurred after the 1929 crash, suggesting at least some timeliness. Students were trying to compete to get their notes in the law reviews, too. The most surprising aspect of the Wood Report is it concluded that derivative litigation was uncommonly frequent and uncommonly unsuccessful in comparison with absolutely nothing. It's especially striking when you note that there was comprehensive data on litigation in New York available. the Judicial Council of the United States started compiling and reporting data on litigation only 2 years into the 10-year period covered by the Wood Report. When this data is analyzed, and the Wood Report's analyzed alongside it, it seems clear that derivative litigation in terms of frequency and success was not in absolute numbers dramatically out of step with other kinds of litigation, and in terms of success and damage rates actually fared rather well. Derivative litigation constituted an annual average of 0.29% of all New York State litigation from 1935 to 1942, ranging from 0.22% at the low to a high of 0.41% of all cases brought in the First Department, that is Manhattan, where the Jews practiced. More than half of these involved close corporations, with which the report wasn't concerned at all, leading to 0.12% of all lawsuits as derivative suits. Their success rates weren't so bad, and the paper has a lot of statistics supporting this. No careful reporter or reporter without an agenda would have ignored this easily available information if they were actually trying to write an objective report. Also striking, and this is after Mark's paper yesterday, is that while the report doesn't really discuss the backgrounds of lawyers, it makes a point of identifying plaintiffs and notes with great contempt the large proportion of plaintiffs who were women. It also turns out to be that it's not just women may be the new lawyers, be the new Jews, but of the 32 identified plaintiffs, 21 have obviously Jewish surnames, and another 7 have potentially Jewish surnames, making it 28 out of 32 plaintiffs that are Jewish. So I argue this is anti-Semitism, but simply noting the stratification of the bar and the clustering of Jews at the lower classes, combined with the disingenuous and deeply methodologically flawed report, it doesn't seem enough. So in order to reach my conclusion, I have to take 2 other steps. The first is to demonstrate that Jews, in fact, were the lawyers bringing the derivative suits against WASP corporations defended by WASP firms, and then ask why the defense bar wasn't as concerned with other kinds of litigation. And then the second is to refute some arguments that something else may have been at work. The evidence for the first conclusion, that it was Jews bringing the derivative suits and that the defense bar didn't care about other kinds of litigation, lies in the practice areas in which Jews were engaged. In 1937, the data show that 42% of Jews represented merchants, another 25% a general clientele, and only 11% represented corporations. As I said before, these are mostly closely held corporations. In order to cross-check the statistics and the inferences that I'm drawing, I looked at every derivative suit case decided in the First Department between 1920 and 1944 that had a published opinion. I used the admittedly unscientific but unavoidable technique of identifying ethnicity by surname, a technique that I use rather self-consciously with the knowledge of the fact that Avram Mikhailovich Wasserman was granted the name Abraham Mitchell by a South African immigration official, but it was the best that I had. Of the 74 reported opinions, 65 identify counsel by name, 37 involve Jewish lawyers opposing non-Jewish lawyers, 13 is Jew versus Jew, and 13 involve non-Jewish lawyers on both sides, with 1 representing a substantial mix of ethnicity. So without accounting for the 10 opinions that don't name counsel, 50% of the cases involve Jews against non-Jews, and another 17% of Jews versus Jews. I don't know the ethnicity of the corporate clients, but one can suspect. A total of 67% of the derivative suit cases then were brought by Jewish lawyers. And of these 64, 58% were Jews versus non-Jews, and a total of 78% when you add Jew versus Jew. On either calculation, these numbers seem to provide fairly good evidence for my conclusion that plaintiff's derivative litigation was Jewish business. And as we saw, most Jews didn't represent a corporate clientele, so we can make a fairly good guess as to the ethnicity of the executives that were being sued in the corporations. Combined with all of this, and the particular type of anti-Semitism that pervaded the upper and professional WASP classes, the rhetoric of the Wood Report tells us exactly why derivative suits were considered to be such a significant problem, despite the reality of their relative innocence and the lack of serious public concern with the issue. The reason, of course, is the irritation and vexation felt by WASP lawyers and their clients at having to defend themselves against the annoyingly and decidedly low-life upstart Jews who were demanding an equality which the WASP aristocracy was not willing to grant. Indeed, John Higham illustrates this nicely, and I quote, "And discrimination reflected as it had for 50 years a conjunction of two factors. The great but insecure inequalities of a middle-class society in which men striving for distinction feared inundation, and the urgent pressure which Jews, as an exceptionally ambitious immigrant people, put upon some of the more crowded rungs of the social ladder." Higham goes on describing the discrimination in the period immediately before the Wood Report as a period of status panic, and sees the very success of the Jews as the cause of social anti-Semitism. And he, again, I quote, "Whereas other European groups generally gained respect as assimilation improved their stature, the Jews reaped more and more dislike as they bettered themselves. It is the temerity of the Jews to challenge their betters that led to," and I quote, "the universal revilement of derivative litigation." Now, the second two reasons in defense of the Act, that derivative suits generally were meretricious and that recovery was so de minimis to make them a waste of time, fall on the facts that I've already referred to. There's one other possible argument, I think, that transcends anti-Semitism as an explanation for why derivative suits were viewed as so threatening, an argument that's highlighted by Carlin's conclusions that ethical behavior was a function of bar status. I was interested to listen to Sam. I have a list of Carlin's ethical violations, 90% of which no human being would consider an ethical violation, and some would consider good conduct. And that is to suggest that the animosity was less driven by hatred of Jews than by class difference. But this answer is almost impossible to sustain. First, if that were the case, that the plaintiffs' bar were made up largely of Italian and Irish lawyers, we might have a plausible story, but it wasn't, so we don't. There was, of course, elite discrimination among those groups, against those groups too, but not only did it never come close to reaching the extent of anti-Semitism, but these were ethnic groups that themselves were participants in the widespread anti-Semitism. Moreover, they had their own carefully defined economic roles in the trades, the police, politics, civil service, and shopkeeping, which were never the province of the WASP elite, and therefore there was no competition or fear. Besides, if class were the issue, it ought to have been the case that the lower-class Protestant lawyers fared as badly as the lower-class Jewish lawyers from their matriculation into college until their retirement from law firms, but the evidence that we've examined suggests precisely the opposite. Lower-class Protestants, and particularly academically unsuccessful lower-class Protestants, had almost the same chance to attain elite status as did wealthy and academically successful Jews. Finally, it's worth repeating, as Digby Baltzell notes, that the WASP elite largely defined itself in opposition to Eastern European Jewry to a far greater extent than the negligible notice it took of other ethnic minorities. The class argument falls apart on the facts. Now, just to conclude, anti-Semitism in America is no longer the problem it once was. That's certainly not nearly to the same extent. But the very same attitude towards plaintiffs' lawyers that brought the early legislation about, this attitude of suspicion and mistrust in contrast to implicit faith in corporate America, a faith that seemed unshakable just 7 years or 8 years past the 1929 crash, is the same attitude of distrust towards plaintiffs' lawyers that led Congress in 1995, as part of the Contract with America, to pass alleged securities litigation reform. Legislation that severely restricted the ability of plaintiffs' lawyers to bring securities class actions, which since the 1960s have dwarfed derivative suits as a means of enforcing integrity in corporate management. The 1995 Act, much like the Wood Report, was based on anecdotal testimony and lobbying pressure, not statistical evidence, not even the flawed statistical evidence that the Wood Report purported to have. And it continued the dismantling of the securities laws that began in 1975 in Chief Justice William Rehnquist's only securities law opinion, in which, using a term that appears in none of the briefs, he referred to vexatious litigation. I'm not suggesting that explicit anti-Semitism or even implicit anti-Semitism played a role in the latter developments, but I am suggesting that it provides yet another example of the fact that our social, political, legal attitudes are very much products of a history that becomes repressed over time. Stereotypes persist long after actual prejudice may have abated. It's striking to read the hearings on the 1995 Act and see Senator Phil Gramm, for example, ask Mel Weiss, how do you pronounce that name? In any event, It's a good idea to examine these sources from time to time to remember where our attitudes came from. Perhaps if Congress had been aware of the source of these attitudes in 1995, the act never would have passed. At least it might have led Congress to demand actual empirical evidence of the harm of stockholder suits before passing it. Perhaps had the Supreme Court been conscious of this attitude, its 30-year cutback of securities laws wouldn't have happened, or at least would have been based on sound reasoning, or the briefs. And perhaps the continued enforcement pressure on corporate America of a vibrant plaintiff's bar might have helped limit the kind of damage that we see today. Perhaps not, but thanks to the image of the corporation plaintiff's lawyer that drove the enactment of Section 61B and that has continued to pervade the corporate bar, we'll never know. Thank you.
Thank you, Larry. Very interesting. Our commentator for this panel is Professor Tanina Rostain of New York Law School. Tanina is an expert in legal ethics and the legal profession. Tanina?
Thank you. 2 seconds to get technologically
Sure.
up to date here. Mark, Suzanne, who I know is here somewhere, thank you so much for putting together such a spectacular conference, and it's clearly, having heard your conversations at the beginning and how much thought you put into the different panels and the different themes, it's clearly the fruition of your work is obviously evident here and yesterday and today. And thank you for asking me to be a commentator on this panel. I've been assigned the task of commenting on 3 very interesting papers that address different aspects of relations between Jewish and non-Jewish lawyers in the New York private bar during the first 50 years of the 20th century. If Sam Levine's and Steve Flanders illustrate accomplishments of Jewish lawyers, Jewish success stories during the earlier part of the century, Larry Mitchell's paper tells us how the ruling corporate bar in the early 50s, or actually the mid-40s, enacted purportedly neutral legislation that targeted specifically Jewish lawyers and their clients. Now, the early 20th century was a formative period in the American legal profession, and a lot of people in this room are familiar with the general history, but I think it's worth highlighting some of the moments in the formation of the American bar. And because the early 1900s saw some of the appearance of some of what we associate as the formal characteristics of the American legal profession. First of all, the period was marked by certain standardization of teaching methods and institutionalization of educational requirements. The teaching method, as many of the people in the room are familiar, originated with Christopher Columbus Landell's Socratic method in 1870, and that form of teaching spread to law schools throughout the country in the early 20th century. And in addition to that, states institutionalized educational requirements. One interesting statistic, in the 1890s, there was an estimated 80% of lawyers had not gone to law school. And the preferred mode of training to become a lawyer was apprenticeship. 3 decades later, law school was the mode of entry for almost everybody. So in 3 decades, we went from apprenticeship to a formal education. In the early 20th century, state bars had instituted bar exams as a precondition of being admitted to the bar. And in addition to that, in the 1920s and 1930s, the different state bars had also added character and fitness requirements, which were aimed in particular at immigrant would-be entrants to the bar. Now, during the first half of the century, we also saw the enactment of and the expansion of prohibitions against the unauthorized practice of law. Around the turn of the century, these focused specifically on non-lawyers representing clients in court, by the Great Depression, the definition of practice of law had been expanded significantly. There were active unauthorized practice committees in every state who were busy trying to crack down on unauthorized practice, and among others, they were going after non-lawyers who were doing document preparation, who were giving legal advice. And so we're working under a much more expanded conception of what practice of law was. So those were some of the formal aspects of the professionalization project of the American lawyers. At the same time, in the early 20th century, there was a sea change in the dominant type of practice and the organization of practice and the types of ideals that animated the legal profession. And these transformations, which Mark Galanters described very eloquently in books and articles, involved in particular a switch from a conception of lawyers, of great lawyers, of being individual practitioners who made their reputations by representing clients in court, and who occasionally were engaged in affiliations with other lawyers who were generalists, but who didn't practice in firms. And in fact, the corporate firm came into being in the late 19th century with the system that soon became known as the Cravath system, pioneered by Paul Cravath at Cravath, Swaine and Moore. And under the Cravath system, there's a system of training where Cravath and his firm recruited mostly, almost all, WASP new lawyers from very elite law schools, train them, and in exchange for their hard work and their loyalty and their commitment over a certain period of time, made them partners. So that was an institution that we consider a permanent part of the American legal landscape, and in fact has a history connected with the early 20th century in terms of its organization and training. In addition to that, and this is another piece that was particularly important, I think, as a backdrop to the stories that we heard here, lawyers no longer represented individuals, but in fact the corporate lawyer became the ideal of the elite lawyer, and through firms like the Cravath firms that developed long-standing relationships with corporate clients, which had them on long-term retainers, and who were loyal to clients. The firms and clients were loyal to each other over long periods of time. Example that comes to mind is the decades-long relationship between IBM and Cravath, Swaine and Moore. For a very long time, Cravath was IBM's lawyers, and they did all the work for IBM. So this is into the beginning of the early 20th century, we saw that there was now an alignment between what were considered elite lawyers and corporations, and elite lawyers were seen more and more as aligned with the interests of business. And in fact, this was this alignment was criticized by Louis Brandeis in his wonderful speech, The Opportunity of the Law, which he gave in 1914, and he noted in that speech the increasingly cozy relationship between elite lawyers and corporations, as he observed, quote, instead of holding a position of independence between the wealthy and the people, prepared to curb the excesses of either, able lawyers have, to a large extent, allowed themselves to become adjuncts of great corporations and have neglected the obligation to use their powers for the protection of the people. He goes on to observe that the leading lawyers of the United States have been engaged mainly in supporting the claims of corporations, often in endeavoring to evade or nullify the extremely crude laws by which legislatures sought to regulate the power or curb the excesses of corporations. So, the profession, and one more piece of this background story, the story of professionalization and the shift to elite corporate practice as the ideal is seen in the early history of the Association of the Bar of the City of New York, which was formed in 1970, and as Robert Gordon has written, the ABC NY was formed from a real mix of motives. On the one hand, a powerfully reformist agenda where they're trying to address the excesses of Tammany Hall. On the other hand, elitist, exclusionary attitudes concerned with, among others, or in particular, the lowering of standards because of new Jewish immigrants coming into the bar and becoming lawyers. So this is the backdrop against which I read these papers, and these papers in different ways ask the question, how do Jews fit into this story? And in the early part of the century, as I listen to Sam and Steve's papers, I heard a story of stories of Jewish success. If we start thinking about Steve's story, it's a story about an alternative organization that gets formed, that's committed to principles of equality. It's formed, of course, in response to blatant anti-Semitism in the judicial selection process. It's committed to be open to everyone who meets the high standards of the bar, and it shows an opening, and particularly through collective activity and organized activity in law, where lawyers can not only form Jewish and other lawyers can not only form their own organization. It becomes a very powerful organization, and in fact, it ends up co-opting the most influential members of the New York bar. And so it's a story of success, of space, of movement, of forward-lookingness that is afforded both by who are the lawyers at the time, but also the vision of law that animates the creation of the New York County Bars Association. And it also and Steve's story also undercuts the idea that we have insiders and outsiders, that in fact there's a lot of fluidity between insiders and outsiders, that in fact the people we assume are insiders in fact were once outsiders, and that the outsiders can become insiders. Exhibit 1, the New York County Bar Lawyers Association. So a story of success and of forward motion. Then I think, and I think Sam presents this story in the same light, Julius Henry Cohen, important progressive lawyer in the New York Bar, committed member of the anti-Tammany Hall reform movement, who built his reputation around his great business mediation skills. He's best known, I think, for 2 representations. First, he represented employers during the garment worker strike of 1910-1911, and he brokered the first extremely important collective bargaining agreement between the employers and the garment workers. And then he's also known for his innovative approach to public-private partnerships, and he was the founder, the creator of the New York-New Jersey Port Authority. And having founded the New York-New Jersey Port Authority, he was the general counsel of the authority for a period after that. And so here's a story. Here we have, on the one hand, we had an organization that exemplifies a Jewish success story. Here is a lawyer who exemplifies a Jewish success story, right? He's in the thick of things, representing business, mediating, reconciliation. And yet, as Sam told the story, I actually heard a little bit of a different story, which has to do with the kinds of compromises that he had to make in order to be successful. And where I heard this was in his close relationship with Charles Boston. Okay, so here Sam shows, he quotes Charles Boston. He's clearly, Cohen is clearly very proud that he's part of this inner circle of the group who've been meeting together secretly, talking about ethics. He's very proud to be a member. He's an insider. And he quotes Boston's writings everywhere in his book. And at the same time, he's clearly quoting someone who makes the, overtly nativist, anti-Semitic comments about who should be in the bar and who shouldn't be part of the bar. And so you get a sense, I think, even though Sam didn't emphasize this, of a kind of willingness to put up with a certain amount of that in order to be an insider, in order to be successful. And for me, it resonated a bit with a conversation we had yesterday, reaction to I think it was Willie Forbat's talk, a view that when Jews were part of the civil rights movement, they were particularly concerned about representing African Americans, and being involved in other causes, but were less willing, less comfortable to represent Jews who were being discriminated against. So, question there is, what kind of compromises, what kind of sacrifices, what did someone like Cohen have to put up with in order to pass, to be an insider, to be successful? Okay, so that's now the 5 minutes left. Okay, and here we have, nevertheless, in these two stories, a sort of a story of progression. Things are getting better. Yes, there's overt anti-Semitism in the early 20th century, but their Jews are managing through certain kinds of compromises, through alternative organizations, through the law, which creates this promise of equality, to get power, to shape, to transform practice of law in New York in the early 20th century. Well, boom, then we're now in the 1944, and Larry gives us a very convincing account of what motivated the passage of this anti-derivative lawsuit statute that appears to come out of nowhere in 1944, the New York legislature, and which is to say that it is on shaky foundations, I think is generous. I think Larry's paper is very convincing that the sudden concern in this, with a certain kind of litigation, when that litigation was not meaningfully different from the other kind of litigation, had to be prompted by something else. And I think Larry's paper did a wonderful presentation here, but in his paper too, there was nothing about this kind of litigation that distinguished it from other litigation. It was no less successful than other litigation, and there wasn't actually a lot of it. And yet, what was striking about this litigation is that it involved, for the most part, Jewish lawyers against corporations, represented by Protestant lawyers. And it clearly created a certain kind of threat that was not seen in litigiousness generally, and married with the unbelievably anti-Semitic attitudes that had flourished in 1944, and the evidence of who was where the Jewish bar was in 1944. I think he makes a very compelling case that is the most reasonable, best explanation for why the statute came to be. And though he didn't have time to talk about it, certainly there are. You said there was the shadow of Shylock that was over the 1995 Private Litigation Securities Act enactment. I was thinking there was a shadow of Milberg Weiss. And query the extent to which there's the same. Again, one of the things that happened, of course, is in a way it's easier to address the overt anti-Semitism in the early part of the 20th century, and to prove that it is wrong, much more difficult to deal with the kind of anti-Semitism that the record suggests is circumstantially there, that may very well have been there in the 1995 statute and may be there today in the prosecution of Milberg Weiss, which you didn't talk about, but which raises a similar question. Thank you.
Thank you, Tanina. Suzanne, do we have time for a question or what? Maybe for two questions. So.
Lawyer advertising.
Anybody want to take?
Sure.
Didn't exist in the period that I was talking about, so
Well, advertising was another of the lawyers' practices that Cohen was concerned about and the professionalism movement was concerned about. Absolutely. Advertising is one of those interesting areas where, again, it's not clear. There was sort of this claim of professionalism, and this carried through in Supreme Court cases dealing with advertising, while those who, many kind of saw through this opposition to advertising, the claim was that it's beneath lawyers' professionalism, we're not peddling our wares, and some of the response was, well, you don't need to advertise. Grabowski and Moore doesn't need to put ads in the newspaper to get their clients, and it might have been a form of economic protectionism over the years.
I disagree with you, Mark. At the 1995
Okay. Larry, do you want to?
Yeah,
respond?
I think that's true, and I made the claims I made for the 1995 Act. I admittedly claimed were weaker. The circumstances of its passage were not a lot different. It was paired in the contract with America with a statute that didn't pass, a statute affecting plaintiffs' lawyers more generally. I didn't have time, but I could. In the paper, I have a little public choice story about the way that plaintiffs' lawyers generally are spread throughout the country, and it's not entirely surprising that statute didn't pass, but that plaintiffs' securities lawyers are concentrated in New York and now Los Angeles and are exclusively Jewish, unlike plaintiffs' lawyers generally. So that while it's true that there were efficiencies that the Act purported to aim at, its genesis was a campaign and quite frankly, a Republican congressional campaign against these over-litigious, greedy, fee-grabbing, grubbing lawyers. I'm not suggesting that the Act may not have had beneficial consequences. I think it might have, although it was also aimed directly at Milberg Weiss. But I'm only suggesting that what had been more explicit anti-Semitism has become such a part of the culture of our understanding of what the plaintiff's lawyer is, that it's at least imminent in the debates, in the statutes. And it's true that if you read the congressional debates, while it's not quite as harsh as things used to be, there are some of these flavors of anti-Semitism. The whole reason, by the way, I investigated this topic was after some years of teaching derivative suit opinions, I had been troubled by the language used by courts in those opinions. Like I said, in Blue Chip Stamps, Rehnquist uses vexatious litigation, not in the briefs at all. So I started looking for this, and it didn't take me a lot of digging to find it. So you're right, but I think my point about racism is a little bit more subtle, and that is that even if good things come out of it, it's still there, and it's still a driving force.
Yes.
I'm just curious if anybody writes one like defense laws, business, force laws, business, get over it. Does everybody adopt the trope that used to be upon is now the
Anybody have a
I can't help you.
know about that? Know of such a defense? Same things happen in medicine, by the way. Yes. Russ.
Russ, yeah.
Yes.
Yeah. So, Steve, I guess a couple things. One is, I wonder sort of what you say about sort of both the Swain book about Cravat and the Spiegel book about Wall Street players, that actually, if you look across the spectrum of Wall Street players, that actually their social background is actually quite high. Lots of them people who are registered, people who make or so there's I think it's not quite fair to say that it was a kind of open meritocratic enterprise.
I didn't go that far.
The emphasis was by but I think it's capturing, which Tina's comments suggest a little bit, is that there was a transformation going on at the time between a kind of belief of status-based privilege based on family heritage to one that was based on educational privilege. And of course, these things are overlapping, as we find out over time today, but that the cravat system itself, by a preference for hiring the bright young graduates of legal education, put a kind of educational elite as a kind of motivating, driving force, which eventually brings back to Congress, puts pressure on the exclusion of Jews as Jews begin to move up into high levels of education. So there's this interesting transformation of what counts as elite status and privilege that's going on that started right at the time where the country boys are allowed to come to New York and make good because they have.
Well, I agree with what you said, and I certainly did not mean to suggest that this was an open system in the kind of broad sense that we speak of diversity in various employment contexts today. But I did think that it was I do think that it's a useful corrective to note how open it was in the sense that I referred to. These people came from many different places, and what this reflects, I think, is a point that I did not touch upon, which is simply that New York and the New York economy in the first couple of decades of the 20th century was simply exploding, and that made the whole economy, including the legal economy, the economy of the legal profession, extraordinarily open. This was a period when lots of what are now big firms were founded. And it wasn't that hard to do, apparently, because so many people did it and made good. So, for example, I mentioned Hughes. Hughes, Herbert, and Reed wasn't established until about 1920. This was something that, well, he wasn't an outsider, but this is something that outsiders, by that time, he was a defeated presidential candidate.
Okay, I think we have to wrap it up. So I want to thank the panel for a terrific job, and I think they've set the stage. Thank you. They've set the stage for transformation continue. Anybody have a?
I can't help you.
Know about that? Know of such a defense? Same things happen in medicine, by the way. Yes. Russ.
Russ, yeah.
Yes.
Yeah. So, Steve, I guess a couple of things. One is, I wonder sort of what you say about sort of both the Swain book about cravat and the Spiegel book about Wall Street players that actually, if you look across the spectrum of Wall Street players, that actually their social background is actually quite high. Lots of them people were social registered, people were big flowers, etc. So there's I think it's not quite fair to say that it was a kind of open meritocratic enterprise.
I didn't go that far. But
But I think it's capturing, which Tina's comments suggest a little bit, is that there was a transformation going on at the time between a kind of belief of status-based privilege based on family heritage to one that was based on educational privilege. And of course, these things are overlapping, as we find out over time today, but that the cravat system itself, by a preference for hiring the bright young graduates of legal education, put a kind of educational elite as a kind of motivating, driving force, which eventually brings back to Congress, puts pressure on the exclusion of Jews as Jews begin to move up into high levels of education. So there's this interesting transformation of what counts as elite status and privilege that's going on that started right at the time where the country boys are allowed to come to New York and make good because they have education.
Well, I agree with what you said, and I certainly did not mean to suggest that this was an open system in the kind of broad sense that we speak of diversity in various employment contexts today. But I did think that it was I do think that it's a useful corrective to note how open it was in the sense that I referred to. These people came from many different places, and what this reflects, I think, is a point that I did not touch upon, which is simply that New York and the New York economy in the first couple of decades of the 20th century was simply exploding, and that made the whole economy, including the legal economy, the economy of the legal profession, extraordinarily open. This was a period when lots of what are now big firms were founded. And it wasn't that hard to do, apparently, because so many people did it and made good. So, for example, I mentioned Hughes. Hughes, Hubbard, and Reed wasn't established until about 1920. This was something that, well, he wasn't an outsider, but this is something that outsiders, by that time, he was a defeated presidential candidate.
Okay, I think we have to wrap it up. So I want to thank the panel for a terrific job, and I think they've set the stage. Thank you. They've set the stage for transformation continue.
I'll follow the lawyer's habit of standing to address the court as moderator, and I want to welcome you to the continuation of this morning's session. As Suzanne described before the intermission, we had the historical background of the emergence of Jews in the legal profession at our first session this morning, and we follow that now with speakers, two of the leading contemporary Jewish lawyers in this profession in the United States. They will be followed by two academics delivering papers, and finally by an academic commentator. It's my pleasure to introduce the first of our lawyer speakers, Kenneth Bialkin. And Kenneth has done everything in the Jewish community, in the organized bar, and in the profession. Ken is the former chairman of the Conference of Presidents of Major Jewish Organizations, the leading lay Jewish organization in the country. He has served as president of the American Jewish Historical Society, and he has served as national chairman of the Anti-Defamation League, among his many Jewish activities. His organized bar activities have included the presidency of the New York County Lawyers Association, about which we heard so much in the first panel, and I understand he was formerly chair of the business law section of the American Bar Association. That's the largest section in the American Bar Association. And he is, of course, a leading corporate and transactional lawyer, particularly in the areas of corporate finance, corporate governance, and mergers and acquisitions. And I understand, among other claims to fame, he is Sandy Weil's lawyer. So it's with great pleasure I introduce our first speaker, Kenneth Bialkin.
Thank you. Thank you. I've been asked to speak, I think, largely on an experiential basis. That is, I don't have statistics or broad generalizations that I can support with authority, but I do have more than 50 years of activity. Graduated from law school in 1953, and I'm still at it. My partners think I'm full-time engaged and working for Skadden Arps. I like them to think that. I do a few other things on the side. But I wanted to, let me get right into it. I think in talking about the transformation of American law firms, I think the subject has to be considered in the context of development elsewhere. That is, law practice and law firm existence doesn't exist apart from society and culture in which we exist, particularly, let's say, the post-World War II. World War II changed the world. And barriers began to break down in many places. We all know as Jews that discrimination existed, continues to exist, and will probably continue in one form or another. But the economy has changed rapidly. The growth of societies has been unprecedented. It couldn't and hasn't ever been predicted to be what it is. And we were there, Jews were there, as things were happening. And when we talk about evolution, do look at it and say what happened in business, what happened in the financial and investment world, what happened in academia, what happens in education. And so the breakdown of the barrier to Jewish hiring, I think, is a part of that. My personal existence, I think I'll say a moment about it, because I am now, when I was young, I always thought it would be very nice to be a member of the establishment. I knew there was an establishment out there and maybe I would join it. For some years now, I'm told that I am a member of the establishment, and I keep looking around and wonder where it is. And when you're in the establishment, you learn there is no establishment, except in the eyes and the vision of people who look and generalize and think there is. So I think my own personal experience, I'm a first-generation American. I was born in the Bronx. I didn't grow up in poverty, but I didn't grow up in wealth. I didn't know a lawyer. Nobody in my family knew a lawyer. I've been amused at various times in my practice and meeting young lawyers and even some partners who've come to me at times and assumed, I said, isn't it true that your father was a judge? Well, of course it's not. And I joined the Wilkie firm, which actually was an emanation of the Charles Boston practice, and I moved to Skadden Arps 18 years ago. And so I think I have a basis for a picture. After I became interested in Jewish life, Jewish affairs. I grew up with a Jewish education, but I grew up in the New York City public schools. Did not go to anything except a Hebrew school, which I abjured, where I didn't learn very much. But it was only after law school, where I happened to go to Israel with my wife on a trip because it was cheap, in 1959, when I had been practicing for 6 or 7 years, that I became interested really in Jews, Judaism, and Jewish life when my reading and experience started. When I became a Zionist, which I still am, and when a good part of my non-working life was devoted to the Jewish people. I became active initially in the American Jewish Committee, but moved to the ADL, which was more suited to my personality. I became the national chairman of the ADL in about 1982. I was chairman of the Conference of Presidents of American Jewish Organizations, all the time practicing as well as I could. I became the president of the JCRC, some of you there in the 1990s. I'm still laboring in the vineyard. I'm chairman of the America-Israel Friendship League. I'm president of the American Jewish Historical Society. I'm a member of I don't know how many boards and organizations, and all this time I've devoted my life to the practice of law. I also, for 20 years, lectured as an adjunct professor at NYU, where I taught several generations of students what they know about the securities laws. So I think I have a perch for a picture on the law firm business because I'm now a partner in what is believed by many to be the largest law firm in the world. And I'm a part of that and have been, as I said, for the last 18 years. And I was a co-chairman of a large firm for almost 30 years before that. So I think I have a basis for a picture. When I came to work, as we most know, most firms, the big firms, the elite firms, many of which names are still around today, weren't hiring many Jews. Probably a few of us were hired beginning in the 50s. Most of the Jews that were hired by the elitist firms in the earlier days gravitated toward the tax department. Not so many were in the corporate department. Yet, a known or an unknown truth is that most of the large firms, the elitist firms who are thought of as being part of the establishment, they all had some Jewish partners, believe it or not, going back long before. And it wasn't so well known because they didn't advocate their Jewishness. But Sullivan Cromwell, as we all know, not only today, but had Eustace Seligman, they had Alfred Jaretsky, very prominent people who figured in important developments in the law, and they were there. Simpson Thatcher had Ed Wiesel. There were White and Case, a prototypical white shoe firm, had Colonel Hartfield, who was Jewish. Now, of course, many of these Jews who were in these very, very large firms, and I could go through other firms and find some, they didn't advertise. They almost didn't appear. And the Jews that were hired by most of the major firms in the earlier days when I started and even before, were different than the Jews who exist in firms today. Today, you could go through almost any major elite firm, and you see the halls littered with people wearing kippahs. Our firm and other firms have a daily minyan, where they bench mincha and mariv, and it's a very different thing. But in the older days, the associates were not so visible in their Jewishness. They followed the patterns of some of the partners who practiced law, but there weren't many of us, and there wasn't much Jewish identity, and the partners were not noticeably observant or involved in Jewish organizational life. Things began to change. They began to change, I believe, in the 50s. And I believe the change comes in response to competition. There was tremendous competition for business. There always was, there is now, and there always will be an effort to grow and an effort to prosper. I think the major firms, all of the major firms, almost without exception, but in different points of time, have reached out. And why did they do so? As a previous speaker mentioned, that the elite firms procured lawyers. The stuff of excellence of a law firm depends entirely on the quality of the people they hire and the lawyers who work. A sensible, great law firm with scions of wonderful families and the rich estates in this world would go out of business within a few years if they didn't hire people based entirely on the quality of their education and the excellence of their abilities. And the elite firms in the old days procured their associates from the elite law schools. As we all know, the elite law schools largely themselves practiced discrimination, and there weren't too many Jews in many of the elite law schools. And so I believe that the breakdown of barriers derives from competition and from the recognition that you can't preserve a decent professional organization without hiring the best you can, and that meant to include in the stable of people you hired. And the leading law firms today, some of the older names, have as their senior or managing partners or their important partners Jews. I could go down the list of 10 or 15 of them and identify in each of those firms, not excluding persons sitting at this table, who are Jewish and at the very top of all of the major firms. Then there were Jewish firms, too, at the time. We know the Proskauer firm, the Rosenman firm, some firms whose names are not so well known anymore, the Greenbaum, Wolf and Ernst firm, Moses and Singer, K. Scholler, Struck, I mean, they're both around still. Other Jewish firms that deserve mention, at least in the elitist aspect, I think would be Paul Weiss, which was not strictly speaking a Jewish firm, but had mostly Jews. Today it probably still has mostly Jews, but not because it's a Jewish firm, but because, like most firms, they seek to hire and select the best people that they can find. And other Jewish firms were more specialized, many of them. They were specialized because some of the clients were becoming very rich Jews. As you know, many Jews became very successful in banking, in finance, in real estate, in textile and manufacturing. They tended to hire Jewish lawyers, and Jewish lawyers tended to represent them. And so the great real estate firms, Larry Wien had a firm. Some excellent lawyers who were lawyers went out and who left the law, but people like Larry Tisch and Jerry Speyer, Mort Zuckerman, Harry Helmsley, Sheldon Solo, it could go on and on. People who were lawyers who became successful businessmen, and they would hire lawyers, law firms, and many of them were Jewish. And then, as was earlier said, other Jewish people went into the practice of law and succeeded. And we may have a moment to talk about the subject of the plaintiff's bar versus the defendant's bar, the class action lawsuits, who are in it and who are not in it. The fact is that, yes, the plaintiff's bar is made up largely, at least in New York, of Jewish law firms, but the defendant's bar is also made up largely of Jewish law firms, and the terms of debate and discussion, I think, to some extent, go beyond religious identity. They enter into social attitudes and the opportunity to enter. There's very low barrier to entry. The entry-level barrier to become a plaintiff's lawyer is very low. And so people can get into it, and a lot of them are as excellent as anybody anywhere else in the world, and they prosper and they grow, and the major plaintiff's law firms today happen to be led by Jews. Special mention might be made of two firms who didn't begin as Jewish firms at all, and indeed aren't Jewish firms. One is my firm, Skadden Arps, which began only in 48 or 49. They were not a Jewish firm, but they had the wisdom to hire Joe Flom, a young Jewish boy from Brooklyn, born into poverty and who grew up in poverty, but managed to graduate from the Harvard Law School. And Flom defined the development of what is Skadden today, where we have more than 1,800 lawyers in about 30 countries, and are, I would say, in in the rank of those firms that would be termed elitist or leading. Another firm for which special mention is due, which didn't start out as a Jewish firm, but Wachtell, Lipton, Rosen, and Katz, all Jews, didn't begin as a Jewish firm. They just began as four people who went to NYU and put together a law firm, which today is probably the preeminent merger and acquisition firm in the country. And they have, again, I would say if you looked at their letterhead, mostly Jews, but not because they hire only Jews. It's the competition that defines it. A comment I wanted to make is that the Jewish firms, or the firms where Jews have prospered, and this is of particular interest to me, is how Jewish were the lawyers who joined major firms? Were they active in Jewish life, were in Jewish organizations, and were they Zionists? And I'm sorry to say that I have to say that until relatively recently, quite recently, the Jews who were in the major firms did not involve themselves noticeably in Jewish life, and when they did, they were not involved in the Zionist side of what many of us traditional Jews would regard as Jewish interests. Many of you know that the Jewish community as a whole was very much divided on the subject of Israel until actually 1967. And until that time, there were many Jewish organizations. The American Council on Judaism was a non-Zionist, anti-Zionist. One of the leaders of the Jewish community, Judge Proskauer, a venerable figure, was not active on the pro-Israel side of it. In fact, he led the American Jewish Committee in, I would say, an anti-Zionist movement. Louis Marshall, who was also head of the American Jewish Committee, was on the other side of the Zionist advocacy group in the split in the Jewish community. I don't think that's true anymore, and Jewish lawyers today lead all of the Jewish organizations, or are involved in all the Jewish organizations. And I say conduct themselves, I think, in an extremely honorable way. But I count the social activism as starting mostly with the Civil Rights Revolution, maybe the 1964 Civil Rights Act. The bar associations organized the Lawyers Committee for Equal Rights under law. That was not Jewish, but I would say there were many, many Jewish lawyers and non-Jewish lawyers who took an interest, but many did not. One small vignette. In about 1990 or 89, I had a call from Milton Gould, who was a very prominent, excellent Jewish lawyer, the leader of the Shea and Gould firm, which doesn't exist anymore, but he was probably at the top of certainly the bar, but plus the Jewish bar. He told me that the presiding justice of the appellate division, Tim Murphy, was interested in the Holocaust, that Tim Murphy, not exactly a Jew, but he was the presiding justice, felt that the Holocaust and the events in Germany were the product of the failure of law, the failure of lawyers to advocate the law, the failure of judges to enforce the law, and that the Holocaust would not have happened had the law been observed. And so he wanted to do something. This is the appellate division in New York. If you go up on Madison Avenue at 25th Street, you'll see a beautiful Rococo building. And he felt that the legal profession ought to be identified as being aware of the Holocaust and to show an appreciation, in other words, a memorial for the Holocaust. And he asked some of his friends to organize a group to lead that. And so I had a call from Milton Gould, who was Jewish, and his partner Bill Shea, who was not Jewish, and Dennis McInerney, who was a senior partner at Cahill Gordon and happened to be Tim Murphy's brother-in-law, who told me how interested the judge was in doing this and how he wanted it done. And so we organized a committee to go out and to conduct a competition in New York City for an architectural rendering which would do something at the courthouse. To make a long story short, and I know I'm out of time, to make a long story short, we put a committee together, and we went out to all the law firms to raise the money to make a Holocaust memorial exhibition in New York that was supported by the City of New York, who ran an art competition and for selection of whatever architecture or sculpture we selected. We had a very difficult time raising money from among the big law firms. The number of law firms who gave us any significant amount of money, at that time 5,000 was a significant amount of money, you could be counted on the fingers of one hand. And most of the money that came from to build this came from Tim Murphy, who had connections with various foundations. And I urge you to go up and look at Madison Avenue and 25th Street. The cornerstone of the appellate division has a beautiful soaring marble rendering of Auschwitz and the flames of the ovens, and based entirely on the leadership of a non-Jewish appellate division presiding justice. It was a time not so long ago when it was very difficult to get that kind of support from the Jews who were actively practicing in the big firms. Today, it's 100% different. And so I just want to say my conclusions from the phenomenon about the presence of Jews, for which we're all very grateful, in the major firms, to me, demonstrates that if a society removes the barriers of discrimination and opens the channels of opportunity for education and advancement, Jews can compete in the marketplace of ideas, scholarship, and professional activity. Law is not the only calling where Jews have seized these opportunities. But it seems to me it should not be claimed that Jews have some genetic or cultural secret which affords us an advantage over others. Instead, it speaks well, in my mind, about the prospects for success of those whose history, family structure, cultural and yearning support and nourish the opportunity for learning and are given the opportunity to excel. We are fortunate as Jews that we've had that opportunity in this country, and I'm confident that others who are given that opportunity would give us all a run for our money. Thank you.
Our next speaker, Joseph Schenker of the firm of Sullivan and Cromwell, comes from, I guess we would say there was one quintessential Wall Street law firm, it would be Sullivan and Cromwell. I remember growing up just around the corner from this school on West 11th Street, and family would look out the living room of our apartment house and say, across the street in that brownstone, that's old Mr. Sullivan's house. So I've known the firm for a long time, and it's just so gratifying to have the vice chairman of that firm, our speaker, Joseph Schenker, on this panel. And at least a reliable internet blog says he's the heir apparent to be chairman of that firm. Mr. Schenker is very well known in the real estate industry in particular for the major clients that he's represented, including the New York football Giants. And he's done his share of Tikkun Olam, and he's chairing the Jewish Council on Poverty in New York. And he is a true exemplar of the transformation that's been described on the first panel and now by our first speaker on this panel. Mr. Schenker.
Thank you. We're all true. Well, your parent better be true. I guess I did, when I agreed to do this, I told Suzanne that I'd been permanently cured of any interest in academia from having site-checked her article when I was a second-year student on the Columbia Law Review, and she had written her magnum opus, and it was impossible to decipher her handwriting. And that cured me for doing any papers. I never quite told you how I made up the sites I put in there. But that permanently cured me from ever wanting to write another article. So I did not prepare anything, so I will speak extemporaneously. I'm sorry I didn't realize that this was going to be quite this formal. I would encourage questions during or after or whenever you want. I thought I'd talk a little bit about Sullivan and Cromwell because I think its history parallels some of what you've been talking about over these couple of days, and also a little bit about my experience over the last 25, 26 years as a practicing lawyer and the changes that I've seen. Sullivan and Cromwell actually, as Ken said, started out as a Jewish firm, or at least as an upstart firm. Started in 1879 by Sullivan and Cromwell. Sullivan himself was a little bit of a unusual figure because he represented slave traders in New York. And actually was in jail because he felt that everyone was entitled to a defense and was put into jail for that defense. And the firm published at its 100th anniversary in 1979 a biography of everyone who worked there. And it's actually quite, my wife, who was a paralegal at S&C at the time, worked on it. It was sort of interesting how you could see the history of the firm through those biographies. Sullivan, Cromwell, first associate was a fellow named Isaac Carrillo. And it says nothing was known about his background or he went to after he was an associate. My assumption is he was a Sephardic Jew, but I don't know. But the next managing partner was indeed Albert Turetsky, and then afterwards his son-in-law Eustace Seligman. The clients of the firm were the Jewish investment banks, Lehman Kuhn Loeb at the time, Lehman Brothers Kuhn Loeb, Goldman Sachs, of course, which still is a client, J&W Seligman, probably the first Jewish investment bank. All the people you read about in Birmingham's Our Crowd were Sullivan and Cromwell's clients, as opposed to the firms or Emmett Marvin representing Bank of New York, or Davis Polk in due course with representing J.P. Morgan and ultimately Morgan Stanley and so on. So Sullivan and Cromwell did have a history of Jews, although as a later chairman once told me they were our crowd Jews, Joe. I'm not. And Jewish firms. The firm actually did change quite a bit in terms of the biographies of the people and who joined and became partners, and the associates and partners. Everyone is listed in this book. At the time that John Foster Dulles became chairman, and that was for a relatively long period of time. And it is amazing to think that it is not, he was Secretary of State in the 50s. That doesn't seem even to me that long ago, yet he was someone who never spoke to his sister after she married a Jew. Fact. And in fact, the character of the firm did change during that period, and I suspect, although I haven't done the academic research that you all have done, that was coincident with a fair amount of growth of anti-Semitism at the universities in the United States and quotas on Jews in the Ivy League schools and so on and so forth. And that actually is what happened at the firm, too. In fact, the chairman of the firm, when I joined as a summer associate, William Ward Fauché, also disinherited his daughter when she married a Jew. But what's sort of interesting is Larry Tisch told me the story, that he was the president of the co-op, Mrs. Fauché was president of the co-op board at 1 East 67th Street, and they turned down Joe Flom for an apartment in that building. Joe Flum is Jewish. Harry Helmsley is not Jewish. Okay, I must correct that, by the way. Was not Jewish. But they turned Joe Flum down for an apartment. Ironically, Hank Greenberg of AIG, a very good client of Sullivan and Cromwell, did end up buying that apartment. So all's well that ends well. But that's the sort of, I guess. But that is sort of an interesting history of Sullivan and Cromwell. So I started in Sullivan and Cromwell as a summer associate in 1979, and I actually went there because I wanted to join a club that wouldn't otherwise have me. In fact, most of my contemporaries at law school were looking at Wilkie Farr because you were there, and the clients were Etz Lavud and I think Bank Leumi, the Israeli companies. And since every Orthodox Jewish kid at Columbia Law School in my days' dream was to make Aliyah, they all said, well, the place to go was Wilkie Farr. I actually thought I was going to make Aliyah too, but I wanted to have this graduate finishing school of Sullivan or Cromwell because I figured it would be so shocking in Israel. So I went to Sullivan and Cromwell, and actually what I found was something totally different, to be honest, than what people had warned me about. And in fact, a colleague of mine, and Suzanne, I don't know if you remember Thompson, he was the editor-in-chief of Law Review my year, so he was a good Catholic kid. And he was a summer associate at Sullivan and Cromwell. He said, Joe, I can't believe you're going there. I mean, it's a Nazi firm. That's what he said, quote. I must say that what I found was nothing like that. For sure, and remember, I come from a even slightly different background than you. I'm also a Garmento from Brooklyn or whatever, but I am Orthodox and do not work on Saturdays and have eat kosher and so on and so forth. And that was a little bit of a culture shock to some of the people at Sullivan and Cromwell. And I have great anecdotes of the story of that law school recruits now tell me about of coming to me working on an M&A deal when I was a second or third year associate, and I told the partner in charge it was winter time, and I told him that I'm going to have to leave early on Friday. I could leave at 4. I lived on the Upper West Side, so I figured I'd get home by 4:20, and I could be back at 5:45. But I've got to be out those hours. He had never heard of the concept before, and said, okay. And then he came over to me a little bit later and said, Joe, if you leave a little bit earlier Friday, could you come back a little bit earlier Saturday? And I said, actually, it's a very, very specific 25 hours, and I can't accumulate them to the end of the year either. So there was a little bit of that education. I remember when I became a partner at the firm, the person who was the head of the general practice group, which I was a part of, spoke, and he said that when I was a first-year associate, I hadn't remember that, I left him on Thanksgiving weekend at the printer. It was Friday afternoon. This man was in his late 50s, and we were doing a public offering. In those days, you used to go to the printer to actually print the prospectuses and so on. Happily, that's no longer part of the job. And my mother can never understand why I was always at the printer after sending me to law school. And but I left him there at the printer because it was 4 o'clock again on Friday, and he spent all night at the printer doing my job. And as he pointed out, he didn't hold it against me. And I really have not found that there has been any sort of bar to Jews of whatever level of observance at a firm like Sullivan and Cromwell. And I think the same is true today, pretty much, at all the firms in New York. I think that people do recognize, as Ken said, that this is a business enterprise, that you look for the best talent. Today, Sullivan and Cromwell, like Skadden Arps, has many, many people in the hallways with yarmulkes, with tzitzis hanging outside, with racing stripes, as I call them, showing through their shirts. That's an inside joke for some of you. But with all kinds of people, and the only requirement at all these firms, whether it's Skadden Arps, which I always did think was a Jewish firm, so I stand corrected, because that's what we always say at Sullivan and Cromwell, it's a Jewish uptown firm. I think that the only thing that counts is a commitment to excellence, a commitment to growth as a lawyer, and to doing a good job. And you're absolutely right that over the years, people's levels of Jewish identification has changed. I've seen it at the firm. And I've seen it at Sullivan and Cromwell among older partners who had not really focused on the fact they were Jewish in prior years. But I do think it's a very, very open society today, and it's a matter of just one personal note, a matter of curiosity to me that that in medical schools and hospital residencies, it's actually not quite as open to Sabbath observance today, to Shabbos observance, as it is in the law firms. And that's something that maybe another panel in another school would get Einstein to address. But it is there is no discrimination, overt or covert or implicit that I've seen, at least in my experience, or at least I'm totally insensitive to it. Does anyone have any questions for you? Do you want to go ahead and questions later? I don't know what the...
No, we'll have questions after the commentator.
Thank you.
That's okay.
Sorry? Well, see, the problem is I have a management committee meeting that starts at 12:30, but I told them I'd be late. Hopefully they won't kick me off. I'll still be here. So I'm prepared to stay till 1:45. Okay, thank you. I appreciate that.
I'll ask the question to which I would preface by thinking that the answer is no. This would apply to my firm and the other firm of yours. To what extent, if any, do you think that the presence of statutory law barring discrimination on religious grounds has led into any of the patterns that you described, which I agree with the description? I think the answer is no, but I just wonder because the two did overlap, and we're seeing a lot of litigation in terms of religious discrimination. I just wonder whether law firms were sensitive to that, and did that lead to some of the openness that we're now seeing?
Actually, I think, much as I'd like to say no, Larry's a partner, Cale Gordon, for those of you who don't know. He reminded me of a exchange we had. But I actually think it did have an effect, in fairness. I think that the activities of COLPA, which is an organization I don't think exists anymore, was a Commission on Law and Public Action, was it? It was run by a guy named Dennis Rapps, which brought a lot of the... I'm sorry? Okay, exactly. That brought a lot of the Sabbath observance cases in the 70s, I guess. It was a big spate of them. I think actually probably did sensitize the law firms to the need to be cognizant of non-discrimination against people, leaving on early Friday and not working Saturday. The law firms, as you know, are very, very active on Saturday. And in fact, I started as an M&A lawyer. I went into real estate because we needed to establish a real estate department because it had previously been the province of the Jewish firms, but our non-Jewish clients, the investment banks, were going into real estate, so we had to follow. And I remember people, wondering how was I going to be able to manage, and we were able to manage. And part of the managing is by working very hard the rest of the time, so to try to do as seamless a job as you could. But I'm sorry, that's right. Larry reminds me that we had a call on the NBC, he was representing NBC GE in the Rockefeller Center transaction, the restructuring, and I said to him, some negotiation, I said, "Memanafshach," which is either way, which is a Talmudic Aramaic term, and the problem is that this is something that has no decent English translation that I've found, and in fact, I'm on the board of something called the Masorah Foundation, which is the Art Scroll Publications, and I asked the editors-in-chief at a board meeting, I said, do you have any decent translation of Memanafshach as a Talmudic reasoning concept, which is, well, either way you go, you get to the same result. And damned if you do, damned if you don't. And they sent me they did a computer check. They had 14 different translations that appear throughout the Talmud, none of which were precise. So Larry educated Gary Wendt, and I educated Niarchos and Agnelli as to what it meant. We do. I actually had an associate who I was very close with, who worked with me for many years, who was a playmate of the King of Morocco, very religious. Sunni Muslim, and we have many Muslims today with some with head coverings, just like the kippot, and I don't think there's any. I do think that Muslims today, post 9/11 in New York, have an issue that's unfortunate, and they feel it, and we try to be sensitive to it. But I don't think there's any. To the contrary, there is a desire to do work by the law firms in the Muslim world. I did some of the original Sharia decisions of structures back in the 80s before they developed the body of their own rabbis, and structuring. And I based it actually on the Heter Iska, which is Suzanne knows, teaches Mishpat Ivri, but as you know, the scriptures prohibit the charging of interest for loans. The Quran, similarly, as it's called ribit in the Torah, it's called riba in Sharia, in Islamic law. And in the 80s, as Islamic Islamic institutions started making real estate investments in the United States, Goldman Sachs asked me to structure something based on my Talmudic knowledge, which would work for Islamic law. And we did, a participating mortgage, which was basically a partnership interest as opposed to interest, which is what Israeli banks have. And today there's now a body of Saudi and Pakistani, etc., scholars that do that. And this is something law firms are interested in because it's an important part of the world. Sorry, Suzanne, were you trying to add something, or you had your hand up? Sorry. Okay. Sorry. Go ahead. Look, I'd like to think that the firm is colorblind, gender blind, sexual orientation blind, ethnicity blind. My experience, honestly, has been, relatively that it has. When I became a partner at a relatively young age and a young period of time, and the American lawyer had profiled me, and they interviewed someone who was viewed as the quintessent WASP at the firm, a guy who actually was on the management committee at the time, whose seat ultimately I took, a guy named Bill Willis, William E. Willis. Could you imagine a better name? And they asked him whether Joe's Orthodox Jewishness held him back, which was about as dumb a question as you can ask in the context, because I couldn't do it in kindergarten. But and he said, "Oh, is Joe Jewish?" and I'm sure it was a little bit of a joke. But the reality is that I think up down, I don't think it's had any effect. I think laterally in those relationships among associates and among partners, I don't think it's had any effect. People have to recognize that they can't shirk work. They'll say, "Hey, I'm not working Saturday, I'm shirking work." People carry their burdens, but I actually have not seen it. Oddly enough, on a personal level, I'm actually very, very glad that I am who I am, but I actually think it's helped me in my practice. I mean, I have clients today who assumed I'm smarter than I am because how else did I get there? Sorry. You're saying, are you with which organization? And you're saying that it's harder to find lawyers willing to do pro bono.
Many of the firms, ours does, and I know Sullivan and Cromwell. There are two things you need to know. One, every major firm has a pro bono group, department. The Bar Association and the ethical constraints today require it under the rules of the New York Court of Appeals. Lawyers must, and law firms must, do a certain amount of pro bono work, and that's done. Pro bono work is taken in the way a client would be taken in. If someone brings to the partnership a request to do a pro bono matter, go to whoever's in charge of that, and the firm committee will make a decision as to whether we should be involved in something like that. In most pro bono cases, the firm's name would not appear on pleadings because they're not corporate clients, and we give each lawyer the opportunity of deciding which pro bono matters he or she would like to be in. And so I agree, it's harder to get money out of the firms, but it's not so hard to get pro bono activity out of the firm if you go to the right person in the right firm.
We're going to have to move on to the next speaker. Sure. Sure. We'll have the next three speakers and then resume the question period. And if you need to leave at any point, Joe, we understand the non-Sabbath observance of the ritual of
You have to make it up the rest of the day.
But thanks so much for being flexible and taking some questions now. Our next speaker is Professor Eli Wald. Professor Wald is at the Joseph Sturm College of Law at the University of Denver. He submitted a paper on the rise and transformation of the Jewish law firm. I understand he's also practiced in what I used to think was the Jewish law firm of Paul Weiss. So he brings a combination of practical experience and academic expertise, and his field is legal ethics. So we're particularly pleased that Professor Wald can join us.
Thank you. I'd like to, of course, thank the organizers. I also like to thank the David Berg Foundation, the Fordham Law School, and the Center for Jewish History of sponsoring my research. Professor Wald finds himself in a very peculiar situation. He's following two of the most celebrated Jewish attorneys in our jurisdiction, and he's standing before, or coming to the podium before David Wilkins, his former teacher and mentor, and also before your lunch. So what I'm going to try to do is I'm going to try to summarize the first part of my paper in about 2.5 minutes, and then turn to the second part of the paper, which I think is perhaps more interesting to this forum. The title of the paper that you have, the draft paper that you have in front of you, is The Rise and Fall of the Jewish Law Firm. And in it, I try to explain and account for the remarkable success story of the Jewish law firm in New York between 1945 and 1980. Now, the statistics are in the paper, but let me give you just a few numbers so you can be on board with me, believing that it is indeed a remarkable story. In 1945, the largest Jewish law firm in New York City had less than 10 attorneys. Okay? By the early 1960s, 6 of the largest large law firms in New York City were Jewish. And by the early 1980s, 4 of the largest 10. More than that, in fact, as a group, the Jewish law firms between 1945 and 1980 grew at a rate twice as fast as the old WASP firms. Indeed, a remarkable story. And what I'm going to do with most of my time is share with you 8 unique factors that I've identified in my research that explain the growth of Jewish law firms. Now, there's an ample literature that talks about the rise of large law firms in general. So I'm going to spend maybe about a minute or so summarizing that. But again, I'm going to identify 8 factors that explain not the generic general growth of large law firms, but rather the unique growth, the faster growth of large Jewish law firms in New York City. All right. So with that, let me tell you what's in part 1 that we're not going to talk about. A lot of definitions, but specifically, I explore in part one of the paper what I call the hidden religious identity of the large law firm. And you've heard Ken, so you might ask me what was hidden about it. For practitioners in the early 1950s, it was anything but hidden, right? The religious identity of the large firm was obvious. And what I do in the paper is explain that at least the literature, first the economic literature of the theory of the firm, and then the applied literature of the rise of the large law firm, in fact, does not identify religious identity as a constitutive factor. Right? So there are many factors that we are all familiar with. Right? Somewhat, I think Tanina before already mentioned the Cravath system. Right? So there's this rich body of literature about the large law firm and the theory of the firm. It does not identify religion as an important constitutive factor. So in the paper, I attempt to draw a distinction between what I call the hidden yet robust religious identity of the WASP firm. And to be sure, the WASP firms were WASP not because the majority of their partners and their associates were Protestant. That was true, but that wasn't the majority. That wasn't it. As I argue in the paper, WASP firms actually featured a very rich white shoe culture and also an ideology of professionalism that was at least a part of or product of Protestant values. Right? So it was both the identity of their lawyers and a culture and an ideological commitment. Whereas, as I argue in the first part of the paper, the Jewish law firms that appear after 1945 did not develop a thick Jewish culture comparable to that of the WASP culture. That is, the Jewish law firms were Jewish mostly, but what I call discriminatory default. They were Jewish exactly because the majority of the partners and associates were Jewish. And they did not, okay. So there's that in part one. There's also a lot about, and some of the panels in the participants in the earlier panel talked about the fact that one should be careful when one is engaged in a typological project. And of course, even within the WASP firms, there were many kinds of firms. So there were some of the, if you will, more bluish kind of the blue-collar firms. There were the firms that featured within the WASP universe, firms that feature proud membership in the social registrar, so on and so forth. So I talk a lot about types and topology in part one. And now, having done injustice to myself in those 2 minutes, I want to talk about the unique growth of the Jewish law firm. Now, there is, as I said, a lot of academic literature about the rise of the large law firm, period. Mark Galanter, who is sitting here, is in front, has contributed mainly to about half the story. If you talk about the rise of the large law firm, I can, since I have just a few minutes, distinguish between demand-side explanations and supply-side explanations. And Mark Galanter, in his famous, celebrated seminal Tournament of Lawyers, provides, if you will, part of the supply-side explanation and talks about how organizational features of the firm acted as an internal growth engine. So there's a lot out there in terms of the supply side of why it is that large law firms grew. There's also a lot out there in terms of the demand side. So I'll just throw at you and then refer you back to my paper that the rise of the large law firms has a complex relationship with the rise of large corporate entities that demanded services that the old model of practice, mostly solo practitioners and small firms, could not satisfy. So there is the rise of large corporate clients. There is the explosion not just of corporate law and of administrative law, but of additional bodies of law. There's the risk, what Robert Nelson calls the restructuring of the market for legal services. There is the very unique relationship between elite law schools and elite law firms that earlier panelists have referred to. All of that is, if you will, the traditional scholarship, and here's where my paper begins. And I want to suggest to you 8 factors, right? So the factors that I've summarized flew by right now explain the growth of large law firms, period. But as I've said in my introduction, the large Jewish law firms in New York City after 1945 grew twice as fast as the WASP firms. And what I'm trying to do is explain that unique growth, not the generic growth. I want to share with you 8 factors that I believe explain that remarkable success story of the rise to dominance of the Jewish law firm in New York City. First, size matters. And what I mean by that is, in 1945, the elite corporate bar consists of, relatively speaking, small, large law firms. Right? So when we talk about large law firms in New York in the 1950s, 50 would do, the total number of 50 lawyers does the trick. Not only were the large firms relatively small, but the number of large firms was relatively small. And if you will, the barriers to entry to newcomer firms were, as a consequence, not insurmountable. I'm just tempted to say that Ken suggested that Skadden Arps might be the largest law firm today. I don't think that's the case. There are large law firms with over 3,000 lawyers today. There is an explosion of large law firms, and let me just suggest, David will talk, I think, more about the applications of these factors in other contexts, but let me suggest that if a newcomer law firm, Jewish or otherwise, wanted to emerge in 2006, 50 lawyers would simply not cut it, right? And one office will not do the trick. Okay, so size matters. In other words, it was easier for newcomers coming in 1945 to compete with the existing elite. Second, whereas Mark Galanter's explanation of the tournament of lawyers is celebrated as an account of the engine of growth for law firms, I want to highlight, and I have to consider that I shared it with him before, so I want to highlight a salient feature of his argument. I want to suggest the opposite. The tournament of theory and the Cravath system was a restriction on growth for the WASP firms. In other words, they grew very fast. They could have grown faster and crowd out the newcomers, but they didn't, exactly because of the commitment both to the organizational features of the tournament theory and to Protestant values and visions of professionalism that were embedding white shoe ethos. For example, and I'm talking between 1945 and 1960, no lateral hiring. Now, I'm of course simplifying, very little lateral hiring. Okay? Exclusive recruitment from within the elite law schools. Later on, some of these features are relaxed, and the large WASP firms begin to recruit outside, mostly Harvard, Yale, and Columbia. But initially, again, and the paper goes into much greater detail, the large law firms, the WASP firms between 1945 and 1960, stick to the rules of the game that, in fact, prevent them not from growing, but from growing faster than they did. And the Jewish firms were not restricted by that cultural and religious ethos, and they, in fact, grew faster. So that's 2. 3, protected pockets of Jewish practice. We've heard some references to that before, but many of the large firms in New York City in 1945 all the way to the mid-60s shied away of certain practice arenas, left them, if you will, to prominent Jewish attorneys. And this is not the simplistic story of Paul D. Cravath and his image of what large corporate lawyers do is corporate law as opposed, for example, to litigation. It is not simply that. It's that whole arenas were vacated initially by the large firms. So we're not just talking about litigation. We're talking about aggressive takeover law and defenses to it, real estate, even immigration law. And it's very interesting to denote that it's not just the Jewish law firms were able to occupy this specialized niche. It's more than that. First of all, those specialized protected arenas provided Jewish law firms with access to the kind of clients that otherwise that they did not represent at the time. And moreover, once certain Jewish law firms established a reputation in the protected areas, they crossed over and represented the same corporate elite clients in general corporate law, and in arenas that the large elite law firms would not concede. Right? And Joe Flom was mentioned before. One example that I detail in the article is the, if you will, legendary battles between Joe Flom and Marty Lipton of the Wachtell firm. And that, if you will, protected area as late as 1973 of aggressive takeover law allowed both firms defining, if you will, allowed both firms to grow in a remarkable fashion. All right, so a breather. We talked about size matters, the tournament theories, the restriction on growth, protected Jewish pockets. The list in my article, I list 8 factors. I want to mention here today only 2 more. In the interest of saving time, first, effective discrimination by the large law firms. I think that Ken is absolutely right. History suggests that there were what I call in the paper token Jewish partners at the elite WASP firms early in the 20th century, certainly by 1945. But by and large, the WASP firms effectively discriminate against Jewish lawyers. It's highly documented there's the beginning of a change as early as 1945, but the phenomenon is quite robust until the mid-60s. And the resulting effect is an incredible supply of male Jewish attorneys graduating from elite law schools after 1945 and going where? To the Jewish law firms. 5 minutes, that's perfect. Now, it's interesting to note, by the way, that as a side effect of the decline of discrimination, Jewish law firms, beginning in the mid-60s all the way to the 80s, find it relatively harder to recruit because they no longer benefit from ample supply of initially male, later on female Jewish attorneys graduating from elite law schools and coming to them. By the way, again, I don't have time, but I'll just simply add, it wasn't just at the entry level. Even WASP law firms that actually hired Jewish attorneys in the 40s and the early 50s tended not to promote them. So there's this remarkable phenomenon of effective discrimination by the WASP firms, sending ample Jewish associates to the Jewish firms, and WASP firms subsidizing senior associates for the Jewish firms. They train those associates, and when the associates come for promotion, there's the gentle telephone call to your colleague at the Jewish firm, will you take so-and-so? So effective discrimination actually played a role in the remarkable rise of the Jewish law firms. Finally, and perhaps in terms of importance, I find also only a part element, but I can't avoid a provocation given some of what we've heard in the last 2 days. I call it the flip side of bias. And what is that? Well, we heard a lot about the transformation of ideology. Russ Pierce, I believe it called it in an article, the paradigm shift, right? How the ideology of professionalism changed in the large law firms. It was more waspy, more, we've heard from Sam Levine, based on class, so on and so forth. And here comes Paul D. Cravath initially and talks a lot about merit. And by the time we reach the 21st century, we certainly talk about explicit competition. Well, I mean to suggest that under the old model, the bias against Jewish attorneys, for example, profit maximizers, prevented Jewish lawyers and Jewish law firms from advancing. But under the new model, the explicitly competitive model that Ken talked about, the same bias, the same stereotype, a Jewish attorney will be a profit maximizer, is actually an advantage. It's the flip side of bias. It's the same bias, but the consequences, given the transformation of prevailing ideology at the large firm level, is remarkable for Jewish attorneys and for Jewish firms. And I'll end setting up the stage for my colleague David Wilkins. If you just think about those 8 factors, you might begin to see how when you step outside of our interest in this conference, as in Jews in the legal profession, and begin to think about other minorities, you might begin to see why category-specific law firm or law firms did not come about as on such a grand level as the New York Jewish law firms for other classes and minorities. I dare suggest that if you just think of the flip side of bias factor that I just suggested to you for your consideration, think about the prevailing ideology today and some of the biases and prejudices against other minorities. Right? If the bias, for example, and I'll end with that, against a very otherwise competent female attorney is, by the time she reaches her 6th or 7th year, she's going to want to start a family and maybe have children and take care of them. There is no flip side to that kind of stereotype. it is consistent with the new model of professionalism as it was with the old model of professionalism. And I suggest, just in the conclusion, that the unique combination of the 8 factors that enabled the unique growth of Jewish law firms is unlikely to be repeated in 2006, given the prevailing features of current practice realities. Thank you very much.
Professor Wald has also introduced our next speaker, Professor David Wilkins of the Harvard Law School. He's also director of the Harvard program on the legal profession, and his paper, I'm sure, has the prize-winning title of all the papers submitted. If you can't join them, beat them. Why black law firms in the 1990s could not duplicate the success of Jewish law firms in the 1960s. Professor Wilkins.
Thank you. Well, it's a great pleasure to be here on many dimensions. Actually, Steve Flanders actually stole a little bit of my line when Steve defined himself as the ultimate outsider. I do think you have me on 2 categories, that he says he's not Jewish and he's not a lawyer. I only have one of those. I'll actually get a chance to say more of the fascinating experience that it's been for me to sit here in this conference over the last few days when I get to talk tomorrow, for those of you who are still around. But for now, I want to pick up on my former student Ellie Wall's challenge and talk a little bit about what the experience of black lawyers has to say, what the experience of Jewish lawyers has to say about the experience of black lawyers. But the first thing I have to say is, isn't he great? I'm so proud of him. That was a terrific, and it's a terrific paper on an important area that really, I've been saying for years, has needed to be written about. Look, we've heard a lot about blacks as a subtext here. We've heard a lot about the important role that Jews played in the civil rights movement. We've heard a lot about the relationship between discrimination and opportunity and modes of identity. We've even heard about the transmogrification of stereotypes and the placing of one group for another. I want to talk about all those things, but from the perspective now not so much of the Jewish lawyers, but of the black lawyers. It turns out that all of these features of overlap between the experiences of blacks and Jews have had an important role to play in the area that I've spent a lot of time studying, which is the development of something called a black corporate law bar in the 50 years since Brown versus Board of Education. The role here of Jewish lawyers in the development of the black corporate bar, I think, has been a quite interesting one. I want to take this up particularly in the role, in the experience of black lawyers trying to replicate the experience of Jewish law firms. But first, I think it's important to get some history out on the table. That is, when John W. Davis, who's already been mentioned here before, got up to defend the school board in Brown versus Board of Education, pro bono, mind you, in 1954, he was not, I think, worried about black lawyers coming into his law firm. I don't think actually that was something that ever crossed his mind. In fact, of course, the issue on the table in terms of protecting the integrity of the corporate bar, has already been said here, had to do with the growth of Jewish and other immigrant lawyers in the bar. In fact, some of the leading figures of the bar, like Boston, who actually had quite horrific views when it came to immigrants. Boston was on the advisory committee of the NAACP. Paul Cravath, where there was not a Jewish lawyer, or certainly not a Jewish partner in Cravath until I think the 1960s, Cravath's family started Fisk College. And Cravath himself was very involved in Fisk College. Cravath's brother, actually uncle, started the Fisk Jubilee Singers, one of the very interesting things I've uncovered in the research on this book. Nevertheless, by 1954, there were actually black lawyers who had spent some time in corporate practice. Turns out the great Paul Robeson, the singer and artist, had graduated from Columbia Law School and briefly, very briefly, spent some time in an unnamed Wall Street law firm where he sat in the back room and eventually quit when the stenographer said that she would not take dictation from a nigger. at least according to Robeson's autobiography. In 1947, Barbara Scott Preskel was hired by the law firm which eventually became known as Paletti, Friedkin, Praschker, Feldman, and Gartner. She was a graduate of Yale Law School, and she became, as far as I can tell, after Robeson, the first black associate to work at any New York firm of any size. But the most important person was actually William Coleman, who actually signed the brief at Brown versus Board of Education, who was an associate hired in 1949 at Paul Weiss Rifkin, a law firm that actually is very self-consciously not a Jewish law firm in its formation, though was formed by a Jewish lawyer and a mainstream WASP lawyer who were classmates at Columbia Law School, best friends, and who could not get a job together anywhere, and who therefore decided to start their own law firm and were shortly joined by the grandson of William Lloyd Garrison, the great abolitionist, and dedicated themselves to starting a law firm that was open to everyone. Having said that, even Paul Weiss required a little nudge from Felix Frankfurter to hire Bill Coleman. Bill Coleman only graduated #1 in his class from Harvard Law School and had clerked on the United States Supreme Court and editor at the Harvard Law Review. But in keeping with, I think, something that was said at the first panel, could not get a job in Philadelphia. No law firm in Philadelphia would even interview him, which actually was the same experience that John McCoy of the famous New York lawyer who could not also get a job in Philadelphia, which is why he eventually went to New York. But Felix Frankfurter called people at Paul Weiss and said, I really think you should hire this person. And as Coleman later on said, I think they would have been embarrassed not to hire me at Paul Weiss, given my credentials. And he went to Paul Weiss and actually for several years had a very successful firm, career there. It's not surprising that the first firms to hire black lawyers were predominantly the Jewish firms, not the Wall Street law firms, but rather the Jewish law firms that tended to be on Park Avenue. So Judge Robert Carter, who was the right-hand man to Thurgood Marshall in the whole lead up to Brown, when he left the NAACP Legal Defense Fund in a tiff, actually, in an interesting moment that I will come back to in a second, because Thurgood Marshall had picked a Jewish lawyer to be his successor and not Robert Carter, much to his chagrin, went to become a partner at a law firm, at the Paletti law firm that had hired Barbara Scott Preskel in the 1940s. In fact, he wasn't the first black partner in a law firm. That Carter came in 1968. In 1961, Sam Pierce, who had been the Assistant Secretary to Labor under Eisenhower, was hired at Battle, Fowler, Stokes, and Keel, a law firm that was again on Park Avenue, and one of whose senior partners was Ted Keel, who was a Jewish kid from Brooklyn who had worked his way up to Cornell College and Cornell Law School, eventually becoming a major figure in the Roosevelt administration in labor matters, and had come to become a leading labor lawyer in New York and eventually a partner in this firm. Keel brought in Sam Pierce as, from what I can figure out, is the first black partner at any substantial New York law firm. Pierce went on to a very distinguished career in both private practice and public service, and eventually, significantly, had his name added to Battle Fowler, which eventually became Battle Fowler, Stokes, Keel, and Pierce. But then he went off to work in the Reagan administration, and life worked out less well from there. And if anybody doesn't know the story, I'd be happy to tell it later on. It's a very sad one. But the point of the matter is that there had been from the very beginning a connection between Jewish lawyers and Jewish law firms and the creation of the black corporate bar. But the story's more complicated than that. Because beginning in the 1960s and through the 1970s, a series of tensions developed that actually haven't been mentioned here at this conference between the black and the Jewish community. So Judge Carter, for example, when he was brought into Battle Fowler, he was doing, the Paletti firm was doing labor law. But after the passage of the Civil Rights Act of 1964 and increasingly into the early 1970s until he was actually appointed a federal judge by Richard Nixon, labor law increasingly became anti-discrimination law. And that the practice became representing companies and labor unions, in the Paletti's case, who were charged with discrimination often against black members. In 1978, of course, the Bakke decision happened, and affirmative action becomes a major cleavage between the black community and the Jewish community. Ann Southworth, I think, told me I had her statistics wrong. I think Anna's over there. I can't see her because of this post in the way. Hi, Ann. So how many lawyers was it? It was just one. It was 6% of the sample. But, so one of the lawyers in her conservative sample was working on anti-affirmative action legislation. There's been a lot of debate. I think some of the conflict between the black and the Jewish community was raised over issues of reapportionment. Somebody said in the back here. The point is there became issues that caused tension between these communities which had worked together. One major one I don't have to tell anyone here about, of course, is the Middle East. Where issues involving Israel and the Palestinian conflict became a serious source of cleavage between the black and the Jewish community. And perhaps most significantly, there was a changing of the generation, both the generation of black lawyers and the generation of Jewish lawyers. The original generation of black lawyers moving into large law firms were people who had been grown up in very much the kind of assimilationist tradition. Just remove anti-discrimination and let us in the door. The later generation, my generation, was much more growing up in what might be called the Black Power movement, a movement in which there were many tensions between blacks and Jews. And similarly, the generation of Jews was changing. So when the earliest black lawyers came, the Jews who were there in law firms were oftentimes the ones who had a very sharp memory of discrimination against them. There is a wonderful story, which in the interest of time I won't read you, of one of my interviewees, and a lot of this is based on over 200 lawyers who I've interviewed for a forthcoming book, that came to work. He had been hired at actually a major Jewish law firm. He was given a start. He told them when he'd like to start. He showed up there, and the law firm was closed. Why? Because it was Rosh Hashanah, and no one had told him. So he shows up, and the law firm's closed. But in a wonderful story, one of the senior partners in the firm had come to work that day because he didn't want him to come to the law firm when it was closed. They go out to lunch because the law firm's closed. There's nothing for him to do. And they develop a relationship in which this senior Jewish lawyer becomes a great mentor to this lawyer, this black lawyer, helping him along the way. And I asked him, well, did you ever ask him, why do you think this happened? He said, on the one hand, we had nothing in common. And on the other hand, one day when this senior Jewish lawyer was talking about his own experience coming out of law school and being turned down or not given an interview at Cravath or Sullivan and Cromwell, maybe I shouldn't say, he's gone, Sullivan and Cromwell or some of the other major law firms, that he said, I think he could understand what it was like to be the only outsider in the group. Over time, that generation, which had personally experienced that kind of discrimination in law firms, was replaced by a generation whose memory was of the role of Jewish lawyers in the civil rights movement, of I marched or my father marched with Martin, and that there was less of a recognition of personal discrimination and more of I understand you. And in fact, I not only understand you, but as I'll say in a second, maybe have been there and overcome your problems, creating a tension between the black lawyers and the Jewish lawyers. So it's against this context that black lawyers, beginning in the late 1980s, began to think maybe instead of trying to integrate law firms from the bottom up, maybe we should create competitors. Maybe we should create competitors. Now, it's a sign of the fact that we don't study history very well, and perhaps a sign of the fracturing of the relationship between blacks and Jews, that most of the people who started these black corporate law firms in the late 1980s, early 1990s, did not think of themselves as patterning themselves off of the successful rise and transformation of the Jewish law firm. In fact, when I'd asked them about it, it never occurred to them, actually. Instead, what they saw themselves doing was trying to carve out another path to opportunity. Now, Ellie, I think, has done a brilliant job of charting the reasons why Jewish law firms were able to be successful in the period between 1945 to 1960s, and he's already given you a hint of why the story might be different for black law firms. But let me just say why initially these law firms were successful and how those factors were different than the factors that Ellie suggested were true for the Jewish law firm. So one issue simply that happened was there was a frustration with the pace of change by people who had been successful. That is, the people who started these black corporate law firms actually were primarily partners who had actually succeeded in the large law firms, but felt that they were not able to become significant partners. They weren't able to become, as I wrote in an article, partners with power, people who could command client relationships. And so they were frustrated, not with the sense that they didn't get hired or even that they didn't succeed, but that they couldn't win by the terms of what those organizations were all about. Second, they were, in some sense, encouraged to think that they might be able to succeed on their own by the potential to translate public power into private power. So one of the things that was happening in the 1980s was that blacks were becoming either majorities or significant minorities in many major urban areas, that there were the elections of black mayors in Los Angeles, in Chicago, in Detroit, in Atlanta, eventually here in New York City, and that cities control substantial legal business. And that one of those things those black mayors began doing is insisting that there be black lawyers and other professionals who represented the city in major matters. This created a market for black lawyers in things like the municipal bond business, for example, or representing the city in zoning or land use areas. Some of the black partners had done this work. But they saw as an opportunity that they might be able to do this work cheaper with the same level of effectiveness if they moved into their own institutions without the high level of overhead that many of the large law firms increasingly had. They were also encouraged by a quite remarkable phenomenon, transformation that's happened over the last 30 years, which I sometimes call the browning of the ABA. We have heard that the ABA, we actually haven't heard much about the ABA, but we've heard about the Association of the Bar of the City of New York and other organizations where there was virulent anti-Semitism, virulent nativism that was in all of these organizations. I assure you the ABA, which didn't admit its first black member until 1941, when Brown was beating down its neck, was very much a part of this trend. However, by the 1980s, by a curious combination of many elite lawyers moving out of bar activity, seeing it less and less relevant to their lives, particularly as the growth of corporate law as opposed to litigation, their lives are busier, bar associations seem less important to them, and minority lawyers moving into bar associations, that you begin to have a kind of leadership cadre of black lawyers, particularly, but other minority lawyers moving up in the bar associations and using the bar associations as levers to put pressure on corporations to try to improve their diversity record. and in particular to hire more minority lawyers. In 1989, Dennis Archer, who eventually becomes chair of the president of the ABA in 2004, started something called the Minority Council Demonstration Project, and that project expressly is intended to get more corporations to hire more minority law firms. Because Dennis Archer comes out of a solo practice, small black law firm practice background. This eventually gets a number of major corporations to put money into providing legal services to minority law firms, which eventually helps to drive more black partners from major law firms to go work in small minority firms. The other major factor Ellie's already mentioned, which is the growing competitiveness of the legal services industry, price pressure, particularly beginning in the late 1980s, early 1990s. This leads to borrow Mark Galanter's always wonderful phrase, the golden age of the minority law firm, which happens, roughly speaking, in around 1990 or thereabouts. You have law firms, minority law firms that have almost 100 lawyers, that have branches in several cities. You have several cities that have developing minority corporate law firms. To jump ahead, by 2000, almost all of them have either shrunk or been eliminated. Why? Ellie's already suggested some of them. They were too big to be small, too small to be big. They couldn't compete with the really big firms, but they were too big to be boutiques at that size. They were the victims of their own success. Their lawyers were cherry-picked away. They had a harder time recruiting junior lawyers as the law firms opened up and became more willing to hire junior black lawyers. Also, in an interesting cultural issue, I wonder if it happened in Jewish law firms, that black lawyers who went to minority firms thought they were making a cultural choice in which they'd have to work less hard than if they were in the majority firms. That turned out to be a disaster for these firms. And a number of things about the economics of practicing law change. I could talk more about this and be happy to in question and answer. But let me say, so what's the takeaway for this group and for the relationship between blacks and Jews as we think about these issues? Well, today the largest minority law firms are Hispanic. Right? There's a law firm that has over 300 lawyers made up. What's driving this is Cubans in Miami, where Miami has been a very large growth in the legal sector, in part being fueled by the growth of Latin American practice. So there aren't that many black corporate law firms that are successful, which raises a question I think that you've been thinking about in your own context. What's the importance of preserving identity-based institutions in the legal profession and elsewhere? As we're here at Cardozo, as part of Yeshiva University, you could ask this question, but you could ask it about Howard University. You could ask it about, is it important to have minority or black law firms? Is that an important thing to preserve? How are the relationships between blacks and Jews evolving in the beginning of the 21st century? There was a very interesting article, some of you may have saw, in the Wall Street Journal. This was probably in the late 1990s, I'm almost done, called the New Black Jewish Alliance. It had to do with the fact that many leading blacks in corporate America have been mentored by Jews. Many Jews are now moving up to the very highest levels of success and achievement in corporate America. It raises a question whether or not we are going to see the Jewish lawyers and executives who've moved up to the very highest levels opening up the doors of opportunity for now the next set of groups that are going through in the same way that some of their predecessors did in the earlier period. And this raises, I think, a number of complexities about how Jews and blacks and other groups see each other, reading each other over time, right? So that one of the things that was said here is that law firms, as I encountered them, as Joseph said, it for me has been the ultimate meritocracy, and I see no prejudice. The question is, how does that affect next level groups coming through? where issues of prejudice, as Larry and others have started us to say, are much more subtle, in which Ellie says, in which the set of stereotypes against which people are working against are much different. How do we think about what the next phase of what has been a long and very fruitful for both sides interaction between blacks and Jews will move in this much more complicated world of the 21st century? Thank you.
Thanks very much. And now to make a compendium of all the history and contemporary knowledge we've gotten from all the preceding speakers, and batting on his home ground, Professor Arthur Jacobson, the Max Freund Professor of Litigation and Advocacy at Cardozo Law School, will give us his commentary.
I actually want to apologize to Ken and Professor Wilkins. I'm not going to say much.
Don't
except
worry.
I love what you did. Thank you. So I'm going to talk about Ellie. But first, I'd like to take a minute to remember Max Freund of the Rosenman firm. Max was one of the great litigators of his day. He practiced law from the early 1930s, when he graduated from Harvard Law School, until shortly before his death, recently, in his mid-90s. Max and I taught pretrial practice together here at Cardozo for several years, and I have the honor of holding a chair donated by a grateful client in Max's name. Not many lawyers can brag of such client loyalty, especially after the client gets the bill. Max's career exactly tracked the story that Ellie Wald tells in his paper, The Rise and Fall of the Jewish Law Firm. Even though Max was a Sears Prize winner, which meant that he was first in his class at Harvard Law School, he had trouble finding a job. When he did find one, it was to do matrimonial work. Eventually, he wound up representing CBS amongst a glittering array of other establishment clients. I could tell you 100 Max stories. I'll ration myself one. Max represented Alan Klein, the manager of the Beatles, in their litigation against Klein for improper management. Cleary Gottlieb, where I was an associate at the time, represented the Beatles. I even worked on the matter a little. Well, the time came for Max to take John Lennon's deposition. He was Max, tough, unrelenting, a mind like a bed of nails. After a day or two of this agony, John returned to Max's office the next day. He was wearing a T-shirt. On it was printed, "I love Max." At another point in the deposition, Max went out for a minute. When he returned, John was lying on the floor of Max's office. John looked at Max and said, "Now you can say John Lennon slept here." Reading Professor Wald's paper was a strange experience. I worked at Cleary Gottlieb, one of the firms he discusses. I also summered at a prototypical WASP firm, Dewey Ballantine, where there were indeed close to no Jews. I also knew the man who invented the term WASP, the University of Pennsylvania sociologist E. Digby Baltzell, a class traitor if there ever was one. I knew many people who lived Professor Wald's story, including several of the greats, like Max. It really was, as Professor Wald describes. The WASP firms really did have a very different culture than Cleary, which was a mixed firm, or the more Jewish firms like Rosenman. It's still true that these firms have very different cultures. If you go to a meeting at Weil Gotshal or at Wachtel Lipton, invariably there is a lavish spread that the more waspish firms just don't put on. Hence, my first observation about Professor Wald's paper. He says, and I'm sorry that I'm focusing on this because you didn't emphasize it in your talk, but that the large New York City law firm, based on the organizational structure of the Cravath system, had a hidden religious and cultural identity, and that the Jewish firms were not Jewish in that sense, that the Jewish firms were just firms, where a bunch of Jews who had been excluded from the WASP firms by discrimination happened to work. I wondered, reading Professor Wald's arguments, just what it means for a firm to have a religious and cultural identity, such that the WASP firms had one and the Jewish firms did not. Certainly the Jewish firms were and are very Jewish in the superficial, trivial sense one uses these terms: food, demeanor, dress, atmosphere, etc. Just as the WASP firms were and are very WASP in the same superficial, trivial sense. I believe the major difference between the two is that the WASP firms were doing the rejecting on a religious basis, and the Jewish firms were the firms of the rejected. But then Professor Wald reports that the Jewish firms also did rejecting of WASPs. If so, that must also have been on a religious basis. So I really don't see the distinction Professor Wald is making, that the Jewish firms didn't have a Jewish identity and the WASP firms did have a WASP identity. Second, Professor Wald does not make explicit the role of the Civil Rights Movement and Title VII of the 1964 Civil Rights Act. It's clear to me that the political, moral, and religious agitation that culminated in the passage of Title VII should be at the center of Professor Wald's story. After 1964, it simply became unlawful for any even modestly large law firm to discriminate on the basis of religion in the hiring of any personnel, including associates. It didn't become unlawful. Clearly, the Supreme Court didn't hold the partnership decision in Heishon against King and Spalding in 1984. But you could see it coming. And Heishon is actually an easy case. I believe that the mechanism for change on which Professor Wald focuses, the dramatic growth in firm size, rendering discrimination economically unviable, is a more complex and nuanced contributor to the dynamic than Title VII. I say this because I don't see why WASP firms would have to hire Jews as an economic matter, and Jewish firms would have to hire non-Jews as an economic matter. Everybody, it seems to me, just could have kept on hiring their own, assuming level distributions of talent and adequate numbers on both sides. I'd also like to point out that in one of the venues of life left untouched by the Civil Rights Act, private clubs, there is to this day just as much discrimination as there was in the 1950s. I was astonished recently to spend a day at one of the Jewish golf clubs in Westchester County. There was not a single non-Jewish member. The WASP golf clubs, I was assured, similarly had few Jewish members or none. I teach our employment discrimination course. The WASP clubs would be violating Title VII if they discriminated against Jews in hiring, but not any law if they discriminated against Jews in choosing members. What this tells me is that the motives for separateness are extremely powerful, and that without Title VII, WASP law firms might very well have been willing to pay the price in order to gratify their taste for discrimination, or at least the contrary case remains to me unproven. Finally, I'd like to ask Professor Wald a question. Another trend in the period he discusses, the 1950s and 60s, was the gradual turn of the mainline Protestant denominations toward the political left. If it is so that religion provided the large WASP firms with a positive as well as an exclusionary dimension, then is it possible that what Protestant lawyers were hearing on Sunday had some effect on what they thought and did on Monday? Of course, the persistence of discrimination in golf clubs argues against any influence. Nonetheless, I think that what people do at play is held to a different standard than the world of work. Play does not trigger thoughts of justice. Work does. I think it perfectly possible that a congregant could interpret his minister's sermons about justice and discrimination as applying to his office, but not his club. And I want to thank Suzanne and Ari for making it possible for me to give this comment, and thank you all.
Suzanne, we've arrived at the advertised lunchtime of 1:45, right on the dot. We had a question period in the middle, but can we take a few questions?
That's the way it is, and that there are there's an elevator in the front here, there's people elevators in the back, which definitely the viewers are watching. It's just a question of getting up to the 10th floor and away. And that also means that since we've staggered the elevators, stagger out of this
Okay, the floor is open for questions. Yes.
And also, I haven't heard anything about labor law and the attorneys that will represent the labor union and some leftist line groups. And I wonder, did they see the activities of the African-American Activities Committee and the McCarthy Committee as affecting in some way choice of the attorneys, bearing in mind that many of the Jewish lawyers came from both the metropolitan areas, not from the Midwest, where many of the lawyers they had finally ground up
Well, we lived through that period, that is the so-called McCarthy period. We all remember Ed Welch's Have You No Decency, cross-examination of McCarthy. I don't know how that transmitted itself to law firm and lawyer hiring. That is, the House Un-American Activities Committee was looking at the conduct of people back in the 30s and 40s. Their interrogations, were inquiry into possible communist affiliations, and it was something that was very interesting and compelling and important. It had a lot to do with the formation of our attitudes, but I don't believe that it correlates to hiring practices. I don't think questions were not asked of applicants of whether or not they had left-wing activities in their past in general in law schools. I do believe, however, that if an applicant came along who was thought to have those connections, most law firms would find a way to avoid interviewing or hiring. You may remember when we were at law school, the name of the Lubell twins. There were two highly qualified, intelligent young men who I believe were denied admission to the New York State Bar because the Committee on Character and Fitness, when they interviewed them, at least one of them, I don't remember which one, had joined a group thought to be a Communist Front organization, and they were not, or this person was not admitted to the bar, and that resulted in a good deal of litigation and divisiveness. I do believe law firms would discriminate knowingly if they knew of the background of people, but it never came up, so far as I know, in any time when I became involved in the hiring practices. It's not something you would ask anybody or would come to your attention, and there was never any discussion on that subject that I can recall. Maybe your experience is different.
A question in the back from my old classmate, Alan Dershowitz.
Hey, Alan.
Question to my dear friend and colleague, David Wilkins. Would it be helpful if you could explain a little bit more the source of the tensions between Jews and African Americans? You mentioned two sources, affirmative action and the Middle East. On affirmative action, as you know, a higher percentage of Jews have always supported affirmative action than any other group in society other than blacks. For example, when the recent election took place in California, Jews overwhelmingly voted for affirmative action. And I wonder if it's not that some African Americans expect more of Jews than they do of others. On the Middle East, it's always been my view that there is no good explanation for why so many African Americans, not all, many African Americans, but the obsessive focus of the world on Israel, the greatest victims of that are blacks in Africa, particularly, and has taken the world's focus off of Sudan or other places where blacks are victimized, and Israel not getting our country. So I don't understand on the merits of tensions unless it's that blacks expect more of Jews, and therefore it's a function of disappointment. And that's the case, it seems to me, there's at least sufficient fault on both sides.
Well, I wasn't meaning to say fault, actually. That wasn't my point. It was to say that tensions have developed. And I think it's sort of objectively clear that tensions have developed. I think on affirmative action, Alan, I think you yourself, your views have evolved on this issue over time. And I think that in 1978, particularly, many Jews, I think quite understandably, felt that, test scores and grades had been their ticket. We've heard this over and over again here, that, they had gotten in and achieved and excelled inside of schools, and that they had actually, quotas had held them back. I mean, my own school, our own school, as we know, had quotas for many years. And I think that initially, many people felt that that affirmative action and that the claim that it was about quotas was something that would hurt Jews. And I think that there was certainly discussion about that. Now, it's also true, as Ann Southworth tells us, that Jews are much more liberal than one would expect given their demographic profile in the classic Robert Dahl view that, as you go up the economic ladder, you become more conservative. That hasn't happened with Jews. And I think there's been a much more sophisticated discussion about affirmative action over the last several years, and it doesn't surprise me that Jews did vote in greater numbers against the propositions in California, as you suggest. The Middle East is very complicated, and I think, I'm no expert on this, certainly no more of an expert than you. I will say another point of tension, which I didn't raise, is South Africa and what was perceived to be the support of Israel for selling arms to South Africa. That was a major point of tension. What are the particular merits of these things are? I think that it has certainly made the relationship more complicated. I think your point about expecting more is an interesting one. I do think, precisely because of the kind of history that I've talked about, and because of the kind of history that many people at this conference have talked about in terms of an experience with discrimination, that people, that blacks, I think, do expect a lot from Jews. I think it's a complicated, again, feedback mechanism because many Jews have said to many blacks, we understand discrimination, and therefore raising an expectation that they will understand their plight more. So I do think raised expectations are a part of it. And one more footnote to the present reality, the success of Jews
in overcoming discrimination has complicated ramifications for those people who are still not doing as well and who claim that the meritocracy may not be as open and fair as it seems from the perspective of people who have succeeded over the last 30 years. And there's complicated reasons one could suggest about why that's true, which don't have to involve either fault or blame, but are perfectly reasonable given the perspectives of which people approach the issues. Yeah. Right. 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 So it was a complicated. That's my point.
That's a subject for a different symposium, I think.
Yeah.
Professor Wall, did you want to respond to the question the commentator put to you?
Well, I actually want to respond to the point that Professor Dershowitz made, if only because the excellent points that the commentator made have to do with the part of the paper I did not introduce. So perhaps we will take it in an email exchange. But I'm curious as to why today the black community would expect more of the Jewish community. I think there's a generational gap. I mean, I certainly see perhaps why 40 years ago there would be the perception of expectation. But I'm not exactly sure why, as David pointed out, as the generation of people of Jewish lawyers who experience direct discrimination retires, and there's a new generation, and Joe perhaps was the best example. He said here that he did not experience any discrimination whatsoever, did not have the perception of it. I'm not exactly sure if you're an African American lawyer today, why you would even expect someone in Joe's position to do more. So I share with you the curiosity as to what informs or what more contributes to the tension, if there is such a tension between the communities. But I'm not sure that higher expectations on part of the black community is a factor today.
I lived through a lot of that during the days when I was the head of the ADL and involved, and I presided it during the time of the Bakke decision, when we supported the Bakke decision, which dealt with the acceptance to some extent of preferences, but our position was that there is no room in a constitutional framework for quotas or litmus tests, and we were perceived, I think, as receding somewhat from a fulsome support of the anti-discrimination policies. You can't ignore the fact that statistically the black community had in it and has in it and has had in it a very significant level of anti-Semitism. The origins may involve to some extent the Middle East and Israel, but they involve a lot of other sociological explanations. That shouldn't obscure the fact that blacks and Jews have many, many areas of cooperation where they get together. I think it would be wrong to say that our community is arrayed against the blacks, other than to say there are blacks with whom there are issues, and those issues are always the subject of discussion and some progress, and maybe not so much progress.
We have time for one more question before we make our way to 10:08. So one more? Yes. Couldn't see through the poll.
Yeah, it's hard to see. So I'm curious, if they were here, what would you say to them is significant about what we're discussing, about the paper, and what would be the thing you want them to take away?
Professor Jacobson, as the Cardozo representative, would you respond to the question? What would you like your students to take away from what they will read when they read in their assignments all today's papers.
Yes, that's very good.
It's very complicated.
I would tell a student, I think it's important to know that we live in a country and a society of which there has never been an equal. Opportunities abound, the protections abound. This country and this society is wide open, and any law student who works hard, studies hard, is intelligent enough to qualify in the competition, which is very difficult and very vicious, will succeed and should not worry very much about issues of discrimination, except in perhaps some atavistic corners that still exist. There is always going to be a certain amount of that, but I think in general the system is working, meritocracy is here, and opportunities abound.
I want to thank all our panelists for a truly extraordinary presentation of views and of history.
John returned to Max's office the next day. He was wearing a T-shirt. On it was printed, "I love Max." At another point in the deposition, Max went out for a minute. When he returned, John was lying on the floor of Max's office. John looked at Max and said, "Now you can say John Lennon slept here." Reading Professor Wald's paper was a strange experience. I worked at Cleary Gottlieb, one of the firms he discusses. I also summered at a prototypical WASP firm, Dewey Ballantine, where there were indeed close to no Jews. I also knew the man who invented the term WASP, the University of Pennsylvania sociologist E. Digby Baltzell, a class traitor if there ever was one. I knew many people who lived Professor Wald's story, including several of the greats, like Max. It really was as Professor Wald describes. The WASP firms really did have a very different culture than Cleary, which was a mixed firm, or the more Jewish firms like Rosenman. It's still true that these firms have very different cultures. If you go to a meeting at Weil Gotshal or at Wachtel Lipton, invariably there is a lavish spread that the more waspish firms just don't put on. Hence, my first observation about Professor Wald's paper. He says, and I'm sorry that I'm focusing on this because you didn't emphasize it in your talk, but that the large New York City law firm, based on the organizational structure of the Cravath system, had a hidden religious and cultural identity, and that the Jewish firms were not Jewish in that sense, that the Jewish firms were just firms, where a bunch of Jews who had been excluded from the WASP firms by discrimination happened to work. I wondered, reading Professor Wald's arguments, just what it means for a firm to have a religious and cultural identity, such that the WASP firms had one and the Jewish firms did not. Certainly the Jewish firms were and are very Jewish in the superficial, trivial sense one uses these terms: food, demeanor, dress, atmosphere, etc. Just as the WASP firms were and are very WASP in the same superficial, trivial sense. I believe the major difference between the two is that the WASP firms were doing the rejecting on a religious basis, and the Jewish firms were the firms of the rejected. But then Professor Wald reports that the Jewish firms also did rejecting of WASPs. If so, that must also have been on a religious basis. So I really don't see the distinction Professor Wald is making, that the Jewish firms didn't have a Jewish identity and the WASP firms did have a WASP identity. Second, Professor Wald does not make explicit the role of the Civil Rights Movement and Title VII of the 1964 Civil Rights Act. It's clear to me that the political, moral, and religious agitation that culminated in the passage of Title VII should be at the center of Professor Wald's story. After 1964, it simply became unlawful for any even modestly large law firm to discriminate on the basis of religion in the hiring of any personnel, including associates. It didn't become unlawful. Clearly, the Supreme Court didn't hold the partnership decision Haishan against King and Spalding in 1984, but you could see it coming. And Haishan is actually an easy case. I believe that the mechanism for change on which Professor Wald focuses, the dramatic growth in firm size, rendering discrimination economically unviable, is a more complex and nuanced contributor to the dynamic than Title VII. I say this because I don't see why WASP firms would have to hire Jews as an economic matter, and Jewish firms would have to hire non-Jews as an economic matter. Everybody, it seems to me, just could have kept on hiring their own, assuming level distributions of talent and adequate numbers on both sides. I'd also like to point out that in one of the venues of life left untouched by the Civil Rights Act, private clubs, there is to this day just as much discrimination as there was in the 1950s. I was astonished recently to spend a day at one of the Jewish golf clubs in Westchester County. There was not a single non-Jewish member. The WASP golf clubs, I was assured, similarly had few Jewish members or none. I teach our employment discrimination course. The WASP clubs would be violating Title VII if they discriminated against Jews in hiring, but not any law if they discriminated against Jews in choosing members. What this tells me is that the motives for separateness are extremely powerful, and that without Title VII, WASP law firms might very well have been willing to pay the price in order to gratify their taste for discrimination, or at least the contrary case remains to me unproven. Finally, I'd like to ask Professor Wald a question. Another trend in the period he discusses, the 1950s and 60s, was the gradual turn of the mainline Protestant denominations toward the political left. If it is so that religion provided the large WASP firms with a positive as well as an exclusionary dimension, then is it possible that what Protestant lawyers were hearing on Sunday had some effect on what they thought and did on Monday? Of course, the persistence of discrimination in golf clubs argues against any influence. Nonetheless, I think that what people do at play is held to a different standard than the world of work. Play does not trigger thoughts of justice. Work does. I think it perfectly possible that a congregant could interpret his minister's sermons about justice and discrimination as applying to his office, but not his club. And I want to thank Suzanne and Ari for making it possible for me to give this comment, and thank you all.
Suzanne, we've arrived at the advertised lunchtime of 1:45, right on the dot. We had a question period in the middle, but can we take a few questions?
That's the way it is, and that there's an elevator in the front here, there's people elevators in the back, definitely the here, the cars are watching, it's just a question of getting up to the 10th floor and away. And that also means that since we've staggered the elevators, stagger out of this
Hey, the floor is open for questions. Yes.
And also, I haven't heard anything about labor law and the attorneys that will represent the labor union and some leftist inclined groups
Well, we lived through that period, that is the so-called McCarthy period. We all remember Ed Welch's Have You No Decency cross-examination of McCarthy. I don't know how that transmitted itself to law firm and lawyer hiring. That is, the House Un-American Activities Committee was looking at the conduct of people back in the 30s and 40s. Their interrogations, were inquiry into possible communist affiliations. And it was something that was very interesting and compelling and important. It had a lot to do with the formation of our attitudes, but I don't believe that it correlates to hiring practices. I don't think questions were not asked of applicants of whether or not they had left-wing activities in their past in general in law schools. I do believe, however, that if an applicant came along who was thought to have those connections, most law firms would find a way to avoid interviewing or hiring. You may remember when we were at law school, the name of the Lubell twins. There were two highly qualified, intelligent young men who I believe were denied admission to the New York State Bar because the Committee on Character and Fitness, when they interviewed them, at least one of them, I don't remember which one, had joined a group thought to be a Communist Front organization, and they were not, or this person was not admitted to the bar, and that resulted in a good deal of litigation and divisiveness. I do believe law firms would discriminate knowingly if they knew of the background of people, but it never came up, so far as I know, in any time when I became involved in the hiring practices. It's not something you would ask anybody or would come to your attention, and there was never any discussion on that subject that I can recall. Maybe your experience is different.
A question in the back from my old classmate, Alan Dershowitz.
Hey, Alan.
Question to my dear friend and colleague, David Wilkins. It would be helpful if you could explain a little bit more the source of the tensions between Jews and African Americans. You mentioned two sources, affirmative action and police. On affirmative action, as you know, a higher percentage of Jews have fully supported affirmative action than any other group in society other than blacks. For example, when the recent election took place in California, Jews overwhelmingly voted for affirmative action. And I wonder if it's not that some African Americans expect more of Jews than they do of others. On the Middle East, it's always been my view that there is no good explanation for why so many African Americans, not all, many African Americans, but the obsessive focus of the program of Israel, the greatest victims of that, blacks in Africa, particularly, has taken the world's focus off of Sudan or other places where blacks victimized and Israel not getting our country. So I don't understand on the merits of tensions unless it's that blacks expect more of Jews, and therefore it's a function of disappointment. And if that's the case, it seems to me there's at least sufficient fault on both sides.
Well, I wasn't meaning to say fault, actually. That wasn't my point. It was to say that tensions have developed. And I think it's sort of objectively clear that tensions have developed. I think on affirmative action, Alan, I think you yourself, your views have evolved on this issue over time. And I think that in 1978, particularly, many Jews, I think quite understandably, felt that
test scores and grades had been their ticket. We've heard this over and over again here, that, they had gotten in and achieved and excelled inside of schools, and that they had actually, quotas had held them back. I mean, my own school, our own school, as we know, had quotas for many years. And I think that initially, many people felt that that affirmative action and that the claim that it was about quotas was something that would hurt Jews. And I think that there was certainly discussion about that. Now, it's also true, as Ann Southworth tells us, that Jews are much more liberal than one would expect given their demographic profile in the classic Robert Dahl view that, as you go up the economic ladder, you become more conservative. That hasn't happened with Jews. And I think there's been a much more sophisticated discussion about affirmative action over the last several years, and it doesn't surprise me that Jews did vote in greater numbers against the propositions in California, as you suggest. The Middle East is very complicated, and I think, I'm no expert on this, certainly no more of an expert than you. I will say another point of tension, which I didn't raise, is South Africa and what was perceived to be the support of Israel for selling arms to South Africa. That was a major point of tension. What are the particular merits of these things are? I think that it has certainly made the relationship more complicated. I think your point about expecting more is an interesting one. I do think, precisely because of the kind of history that I've talked about, and because of the kind of history that many people at this conference have talked about in terms of an experience with discrimination, that people, that blacks, I think, do expect a lot from Jews. I think it's a complicated, again, feedback mechanism, because many Jews have said to many blacks, we understand discrimination, and therefore raising an expectation that they will understand their plight more. So I do think raised expectations are a part of it. And one more footnote to the present reality, the success of Jews in overcoming discrimination has complicated ramifications for those people who are still not doing as well and who claim that the meritocracy may not be as open and fair as it seems from the perspective of people who have succeeded over the last 30 years. And there's complicated reasons one could suggest about why that's true, which don't have to involve either fault or blame, but are perfectly reasonable given the perspectives of which people approach the issues. Yeah. Right. 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 So it was a complicated. That's my point.
That's a subject for a different symposium, I think.
Yeah.
Professor Wall, did you want to respond to the question the commentator put to you?
Well, I actually want to respond to the point that Professor Dershowitz made, if only because the excellent points that the commentator made have to do with the part of the paper I did not introduce. So perhaps we will take it in an email exchange. But I'm curious as to why today the black community would expect more of the Jewish community. I think there's a generational gap. I mean, I certainly see perhaps why 40 years ago there would be the perception of expectation. But I'm not exactly sure why, as David pointed out, as the generation of people of Jewish lawyers who experience direct discrimination retires, and there's a new generation, and Joe perhaps was the best example. He said here that he did not experience any discrimination whatsoever, did not have the perception of it. I'm not exactly sure if you're an African-American lawyer today, why you would even expect someone in Joe's position to do more. So I share with you the curiosity as to what informs or what more contributes to the tension, if there is such a tension between the communities, but I'm not sure that higher expectations on part of the black community is a factor today.
I lived through a lot of that during the days when I was the head of the ADL and involved. And I presided it during the time of the Bakke decision, when we supported the Bakke decision, which dealt with the acceptance to some extent of preferences, but our position was that there is no room in a constitutional framework for quotas or litmus tests, and we were perceived, I think, as receding somewhat from a fulsome support of the anti-discrimination policies. You can't ignore the fact that statistically the black community had in it and has in it and has had in it a very significant level of anti-Semitism. The origins may involve to some extent the Middle East and Israel, but they involve a lot of other sociological explanations. That shouldn't obscure the fact that blacks and Jews have many, many areas of cooperation where they get together. I think it would be wrong to say that our community is arrayed against the blacks, other than to say there are blacks with whom there are issues, and those issues are always the subject of discussion and some progress and maybe not so much progress.
We have time for one more question before we make our way to 10:08. So one more? Yes. Can see through the poll.
Yeah, it's hard to see. So I'm curious, if they were here, what would you say to them significant about what we're discussing about the papers and what would be the thing you want them to take away?
Professor Jacobson, as the Cardozo representative, would you respond to the question? What would you like your students to take away from what they will read when they read in their assignments all today's papers?
Yes, that's very good. It's very complicated.
I would tell a student, I think it's important to know that we live in a country and a society of which there has never been an equal. Opportunities abound, the protections abound. This country and this society is wide open, and any law student who works hard, studies hard, is intelligent enough to qualify in the competition, which is very difficult and very vicious, will succeed and should not worry very much about issues of discrimination, except in perhaps some atavistic corners that still exist. There is always going to be a certain amount of that, but I think in general the system is working, meritocracy is here, and opportunities abound.
I want to thank all our panelists for a truly extraordinary presentation of views and of history.
Comparative perspectives on the distinctiveness of American Jewish experience. The central theme of the diverse issues that we will discuss in this session is the experience of Jews in the legal profession outside the U.S. I should note that notwithstanding the title of this panel, and I repeat, comparative perspectives on the distinctiveness of American Jewish experience, we will focus mainly on simply comparative perspectives on Jews and the legal profession, and the distinctiveness of American Jewish experience will be only a possible byproduct of our discussion. As we have already heard in earlier discussions in this conference, an essential element in discussing the issue of Jews and the legal profession is the question, what does Jew mean in this context? And as in, for instance, arts and culture, the basic question is, in what sense, if at all, one's Jewishness is relevant, just as we can ask, is there a Jewish art or a Jewish literature, and if so, in what senses
other than the mere fact that the artists happen to be Jewish, we should also inquire what is distinctive, if at all, in Jewish lawyering. The effect of one's Jewishness can clearly be explored from individualistic perspectives, such as the effects of distinctively Jewish religious, cultural, and moral perspectives on Jewish persons' legal practice. However, our focus in this session will be mainly in collective elements of one's Jewishness, such as one's actual or presumed alliance with the interests of the Jewish people and those of the Jewish state. In this panel, we will explore some of these many phases of what Jewish lawyering means. We will slightly change the order of the presentations, and we will start with two talks that address the general theme of this conference from the perspective of the Jewish state. In the first lecture, Pnina Lahav will talk about the dilemmas of foreign policy of the State of Israel when it deals with issues that relate to the Jewish people. This talk will be followed by Asaf Lichovsky discussion on the relationship between Israeli law and Jewish law. And then the next two talks will focus on the experience of Jews in the legal profession in two different countries. Kent Ledford will talk about Jews in German legal professions, and Mitra Sharafi will talk about Parsi lawyers in colonial India. Unfortunately, David Sugarman could not be with us in this session. Ruti Teitel has agreed to shoulder the really difficult task of commenting on all these issues together and finding a common theme. Each speaker will present for about 20 minutes, and I hope we will have some time for a discussion at the end. Our first speaker is Professor Pnina Lahav from Boston University School of Law. Professor Lahav is a graduate of the Hebrew University Law Faculty and the Yale Law School. Professor Lahav has won several prizes and academic awards. She is the leading expert in the field of Israeli legal history and historiography. She is an expert also in Israeli constitutional law, American legal history, and American journalism. Among Professor Lahav's very long and impressive list of publications, I'll mention just her award-winning book, Judgment in Jerusalem, on Chief Justice Agranat and the Zionist Century, and the book that Professor Lahav co-edited with our next speaker, Asaf Lichovsky, and with Ron Haris and Nir Kedar, on the history of law in Israel. Professor Lahav will share with us her thoughts on the issue of the State of Israel and the Jewish people in general. This is clearly a delicate and highly sensitive issue that affects a broad spectrum of issues. Among these, one can think of, for instance, about the law of return and the ongoing controversies about who is a Jew, or the role of the State of Israel in representing the Jewish people in recovering and restoring assets that were taken from Jews during the Holocaust, so-called the Jewish assets, and concerns about possible conflicts between the interest of the country of citizenship of Jews who live in the diaspora and the interests of the Jewish state. Professor Lahav will discuss some of these issues by addressing primarily two affairs, the Eichmann abduction and the Jonathan Pollard affair. Nina, please.
Thank you very much. I want to join the division of those who thanked Mark and Suzanne for this fabulous conference. It's really a wonderful event, and thank you. I also want to say that, in my opinion, Asaf Lichovsky has surpassed me as the leading legal historian in Israel. In this paper, I consider Israeli foreign policy and its impact on diaspora Jewry. I do so through two historical examples: the abduction of Adolf Eichmann and the employment of Jonathan Pollard in the service of Israel's intelligence community. On May 11, 1960, in Buenos Aires, Argentina, Adolf Eichmann was abducted by a team of the Israeli Mossad. He was smuggled out of the country in an El Al airplane and landed at Lod Airport on May 22nd. The rest is history. A public trial was held. Even Hannah Arendt agreed that it was conducted fairly and decently. In hindsight, there appears to be a consensus that the Eichmann trial was a watershed in the vindication of justice. Much has been written about the trial. Less attention has been paid to the Jewish community of Argentina. This history has only emerged in 2003 in a book by Ra'anan Rein, a professor of history at Tel Aviv University. Rein described in detail the turmoil into which Argentina's 300,000 Jews were thrown following Eichmann's abduction. In his view, these violent events were as severe as the 1919 pogroms against Jews in Argentina, known as the Semana Tragica. Following Eichmann's abduction, Molotov cocktails and incendiary bombs were thrown at schools attended by Jewish students, at synagogues, and at other institutions in Argentina. Swastikas, anti-Semitic slogans, and accusations of Jewish disloyalty towards the homeland were rampant. Israel was denounced as a rogue state, and Argentinian Jews were accused of being collaborators in undermining Argentine sovereignty and national pride. Fast forward. Israel before 1967 was not Israel after 1967. It is safe to say that its relationship with diaspora Jewry has been upgraded and revamped. After the Six-Day War, Israel began to see itself as a mini superpower. Its defense forces performed brilliantly, and its generals were admired as the new brand of the fearless Jewish hero. The mystique of the Mossad also grew exponentially. Now Israel could have its cake and eat it too. On the one hand, a precious national home established on the ashes of the Holocaust, surrounded by enemies. On the other hand, a military power on a par with the most sufficient, resourceful, and even feared of states. This combination of at once wolf and lamb proved and proves irresistible to diaspora Jews. And in all probability, it is what motivated Jonathan J. Pollard, an American Jew employed by the Navy's Anti-Terrorism Alert Center, who enjoyed access to many U.S. security databases, to seek contact with Israeli security agents. We now know that he fantasized himself a Mossad agent and a savior of the Jewish state way before he came to work for the Navy. Like the somewhat unstable Donna Elvira, drawn to Don Giovanni in Mozart's opera Don Giovanni, Pollard was drawn to the charismatic, mysterious, and macho members of the Israeli security community. Like Don Giovanni, these Israeli representatives spoke the language of love and commitment. Like the Don, they cared less for the feelings of the vulnerable Pollard and more for the quick rewards of the intercourse. Pollard was caught and convicted and is still in federal prison. U.S. intelligence and defense professionals claim that, quote, it is difficult to conceive of a greater harm to national security than that caused by Pollard, end of quote. We now come to Israeli foreign affairs. We can start with a classical distinction between moralism and realism. Moralism, some call it idealism, posits that a state's foreign policy is guided by its moral values. Realism, on the other hand, guides decision makers to pursue the nation's cold, objective self-interests, mostly independent of historical and cultural values. To give a well-known example, if current U.S. policy towards Israel is motivated by moralism, then America's support for Israel is based on a shared democratic form of government or on an identification with another beleaguered city on the hill. If current U.S. policy is based on realism, then its support for Israel is motivated by the cold-blooded calculation that Israel is a useful ally in the fight against terrorism or in the conflict with Iran or a variation thereof. Back to Israel. Israel is a Jewish state, the one and only Jewish state. It doesn't expect to have a relationship with Jewish community outside its borders. When Israeli foreign policy is rooted in moralism, then one of its central objectives is the welfare of diasporic Jewish communities. When it pursues realism, its main objectives are security or economic interests, regardless of the Jewish condition in diaspora. The seeds of this duality lie deeply in Zionist ideology. Historically, there were Zionists who aspired to, quote, return the Jewish people to history and the exilic existence, galut, and established a normal state. Normal is the key word here. A normal state, just like France or Switzerland. They wanted Israel to form a normal foreign policy based on Israeli national interests, nothing less and nothing more. The welfare of the Jewish diaspora would matter only if it happened to coalesce with national interests. For example, the welfare of the American Jewish community, under this theory, would matter because of the significant financial support coming from this country, or because of the political power of the Jewish community to influence U.S. foreign policy. By contrast, Zionists who ascribed a quintessential value to Jewishness, to the Jewishness of the Jewish state, felt that the welfare of the Jewish communities abroad was a priority, an integral part of foreign affairs, and which should trump other considerations. For example, it is said that in 1982, when Palestinian terrorists belonging to the Abu Nidal group attacked the Jewish restaurant Goldenberg in Paris, causing the death of 6 persons, then Prime Minister Begin warned the French government that, quote, if it will not protect its Jewish citizens, Israel will have to take over, end of quote. Thus, under this theory, Israel is committed to Jewish communities in diaspora regardless of how onerous the commitment is. Israel will clash with a foreign government that does not protect its Jews, presumably even if it means going to war or suffering some economic sanctions. Of course, the distinction is crude, and we are talking about ideal types. Foreign affairs are complex, and discerning the moral from the realistic is not always easy. My historical examples, however, show that the bright lines are often quite clear. Let me begin with the Eichmann abduction. The decision to go to any length in order to bring Eichmann to justice was, of course, rooted in the Holocaust and in the determination to begin the process of healing through the practice of justice. It was a very noble and daring decision based on considerations of morality. It was rooted in Israel's perception of itself as the representative of the Jewish people, at that time prior to the Six-Day War, against the better judgment of many Jews in diaspora, I should add, and the notion experienced by Israel's leadership that Israel was the correct answer to the Holocaust. It was, of course, a unilateral decision. We may call it unilateral moralism. Israel decided and Israel executed a plan without consulting any foreign government, international law, or any Jewish community. Argentina's Jews had no clue about what was coming. Here is the pertinent question from internal governance. Was there any consideration in the deliberation preceding the abduction about the impact of the abduction on the Argentinian Jewry? It appears that the decision was taken after consultations between 2 men, Prime Minister David Ben-Gurion and head of the Mossad, Issar Harel. They saw themselves as representing the state of Israel and therefore as representing the Jewish people and Jewish conscience. The question of Argentinian Jewry was neither raised nor considered. The 300,000 Argentinian Jews were not a factor. If you wish, they were hostage to the larger demands of the Jewish conscience as understood by these 2 men. Contrast it with the aftermath of the abduction. Israeli public opinion, delirious with its government's tenacious pursuit of justice, was unpleasantly surprised by Argentina's reaction, declaring Israel's ambassador a persona non grata, filing a complaint in the Security Council, the wave of anti-Semitic violence. This was not what Israelis expected. How did the government and the people of Israel rationalize Argentina's response? They attributed the aftermath to the deep anti-Semitic nature of Argentina, and if you wish, of the Goyim in general. Here, Zionist morality and ideology played an important role. The response to the fact, which nobody could deny, that there were pockets of anti-Semitism in Argentina, was not the argument that maybe it would have been better not to exacerbate it. The argument that from prudence, that the trial of an evil man, a master murderer, is not worth risking the welfare of 300,000 innocent human beings, was not on the table. Nor was there any empathy for Argentina's sensitivity to its sovereignty or to its historic commitment to grant political asylum. Israel's response, in hindsight, was a vindication of the central truth of Zionism, that the only place safe from anti-Semitism is Israel. The law of return was put in place to facilitate aliyah, immigration, and that's what Argentine Jews should do. Israel's responsibility was to facilitate the rescue of diaspora Jews from anti-Semitism, not to worry about the welfare of the Jewish community if it chooses to continue living in diaspora. Indeed, when one studies the official commentaries by Israelis about their commitment to diaspora Jewry, one sees a focus on dying communities, communities that pack and live, preferably to Israel. When it comes to Jews, Israel perceives itself as a rescuer and forms its foreign policy accordingly. The question of how to address a settled Jewish community that does not wish to be uprooted is mostly not on the decision makers' radar screen. From the perspective of foreign policy, what happened after the abduction? As we know, the deliberations in the Security Council ended with the Israeli apology to Argentina. Diplomatic relations were soon restored and commercial ties resumed. Matters of national pride and morality were put aside with US encouragement, and imports and export of foreign frozen meat and agricultural know-how resumed as before. Healthy realism has pushed to the sidelines policy based on unilateral moralism. Lost in the happy resolution of the crisis were Argentinian Jews, who continue to experience recurrent waves of violence all through the Eichmann trial and the Eichmann execution. In the chronicles of Argentinian Jews, many of them Holocaust survivors, these events brought about two major developments. First, an accelerated pace of Judaization, where Jewish education became more central. Secondly, and I don't have time to go into this, secondly, a process of migration either to Israel or to the United States. The link between the Eichmann affair and the Pollard affair, from the perspective of Israeli foreign policy, is American Jewry. And not only because American Jewry was enlarged by the arrival of Argentinian Jews. It turned out that the American Jewish Committee was a player in the Eichmann drama. Not only did representatives of the American Jewish Committee monitor the conditions of Argentinian Jewry during the period between Eichmann's abduction and execution, but they also prevailed on Washington to lean on both Argentina and Israel to resume normal relations. In the mid-1980s, 20 years after the Eichmann trial, the US government had developed a cozy and friendly relations with Israel. President Reagan was quite sympathetic to Israel and its interests, and a formal classified memorandum laid the ground for a strategic US cooperation with Israel. By then, the Mossad man who had jumped on Eichmann as he was walking in the street, shoved him into the rented car, and took him to the safe house in Buenos Aires, became head of an obscure intelligence agency in Israel's Ministry of Defense known as LACAM. Today, he is a minister in Ehud Olmert's government. Now, it appears that the Israeli intelligence community in general follows the guideline that local Jews, however strategically placed in their domestic government operations, will not be employed in the service of Israel against their own government. That's a general rule. But as we know, necessity knows no law, and rules enjoy exceptions. The information, particularly satellite photos, unavailable to Israel through regular channels or through this memorandum that I alluded to before, was too delicious to be ignored for the sake of principle. Rafi Eitan, head of LACAM, was a security professional. It would not be surprising to learn that he thought that this was a matter of survival for Israel. Again, the question arises, was there any internal deliberation before the decision to hire Pollard went into effect? Was the question of whether hiring an American Jew, of how hiring an American Jew affect the welfare of American Jewry ever raised? Did anybody think about the possibility that the old specter of double loyalty might be raised and revived and perhaps affect the well-being of the entire community? Again, it appears that the answer is no. The plot thickens because whereas in the case of Argentina, Israel could simply expect Argentinian Jews to pack and make aliyah, the case of US Jewry is more complicated. Recall that US Jewry was influential in resolving the Israeli-Argentine crisis. It has played an important role in many other occasions. The story is told that the CIA operative advised an Israeli politician that Israel is much better off without formally becoming the 51st state of the Union. If it were a state, it would have 2 senators. As is, it has 60 senators. If US Jewry either makes aliyah or loses its political influence, who will lobby for Israel in Washington? Thus, both arguments for moralism and for realism could and should have influenced Israeli foreign policy in the Pollard affair. But the fact is that only arguments based on a very narrow conception of realism played a part. It was deemed useful to get the information Pollard could bring. Other considerations were ignored. The Pollard affair is still an open wound in Israel-US relations. So far, the US government has resisted any leniency with regard to Pollard, who many argued was neither fairly nor even-handedly treated by the federal justice system. The high-level effort periodically made by Israel to prevail on US presidents to let Pollard go attests to the commitment for moralism that animate Israeli decision-makers in the matter of Jonathan Pollard. At the same time, in the United States, American Jews have not significantly suffered from the Pollard affair. Even in the midst of the Pollard affair, the prominent American Jewish attorney Abraham Sofer headed a team of professionals sent to Israel to study the extent of the damage done to the U.S. by Pollard. The professional appointed by Israel to deal with Sofer was Avraham Shalom, Mossad veteran and member in the Eichmann kidnapping team in Argentina. Sofer returned to the U.S. feeling that Shalom did not cooperate in the effort and that the damage to U.S. interests by Pollard could not be wholly assessed. American Jews could explain the Pollard affair as an aberration and Pollard as an exception. The vast majority of American Jews, the argument is, are loyal to the United States and would not violate this loyalty even if Israel's interests are at stake. In the land of the free, they feel brave enough to encourage and deepen the identification between U.S. and Israeli interests. But one may pause to ask, should anyone consider the remote possibility that the rule of 3 strikes and you are out may apply? I mean to say, if Israel again and then again repeats the Pollard pattern, would U.S. public opinion experience a shift? Should professionals, lawyers, security officials, foreign affairs experts consider such a scenario and its ramifications? Again, the question arises, if Israel considers itself a representative of the Jewish people, the only state of the Jewish people, what does it owe the communities of diaspora? Let me summarize. The question is not whether Israel has a commitment to world Jewry. Of course it does. Rather, we may ask, what does Israel mean when it invites us to ask, but it is good for the Jews? Does she mean Jews in Israel? Does she mean Jews everywhere? Does she mean that what is good for Israel must also be good for Jews? Or that what is good for diaspora Jews must also be good for Israel? Does she differentiate between considerations of moralism and realism? And does it do so unilaterally? In other words, Israel's commitment to world Jewry is ridden by ambiguity. The nature and contours of this commitment is the larger framework of Israeli foreign policy are neither evident nor clear. The nature of the commitment revolves around such questions as Israel's self-understanding vis-à-vis diasporic Jewish communities. Is Israel the principal leader, or is it an equal partner, seeking and extending respect to the needs and values of the other? Is it a rescuer, primarily a deliverer of the exiled back to the homeland? Is it merely working to get support for its own agenda, be it commercial, scientific, or military, and uses the local community as a convenient vehicle to pursue these goals? This self-understanding is complicated by the self-understanding of the diasporic communities. Are they all the same? Do they have different needs and worldviews? Is Israel their priority, or do they prefer their own country? And then there is the question of who counts as a reliable spokesperson for the community. Who should Israel contact to find out what American Jews want and need? All of these questions are further complicated by the fact that foreign affairs at any given time are not monolithic. In any government at any time, there are many actors, professionals and non-professionals, competing for influence and sometimes making contradictory decisions. Thus, there has been for a very long time a fundamental disagreement and tension between the Israeli Foreign Ministry and the security establishment about activities in foreign countries. Note that professionals at the Ministry of Foreign Affairs were not consulted either in the Eichmann or the Pollard affair. There is enough literature to show that Israeli foreign affairs are dominated by the security professionals. Security formed and minded professionals tend to be unilateralists, amoral, and pessimistic. Hardcore Zionists they are, they see Israel's interest as supreme and Jewish life in diaspora as exilic, a historical relic of the past, inferior to life in Israel. Here comes the bind. As anyone in Argentina will tell you, it takes two to tango. Israel does not operate in a vacuum. Its behavior is influenced and shaped by diasporic communities with which it interacts. Don Giovanni and Donna Elvira may shed some light on this relationship. As a Don Giovanni, Israel is exceedingly charismatic and seductive, bold, self-reliant, capable of fantastic adventures. Remember the Eichmann abduction or Antebbe. It's hard not to fall in love with, especially if you are a Donna Elvira, somewhat insecure and not free of self-doubt. Each partner then fits the other and a neurotic relationship thrives. The question then is whether professionals on both sides are willing to pause, reflect on their neurosis, and maybe even let some of it go in favor of a more sober, less charismatic arrangements. The Jewish communities abroad will not be able to overcome their neurotic dependence unless they overcome their uncritical attraction to the image of Israel as at once the handsome hero and the victim about to be thrown into the sea. Israel will only be able to overcome its sometimes callous, unilateralist, even reckless attitude if it curbs its machismo in favor of the recognition of the other, the diasporic communities, as equal and autonomous partners. The old Jewish principle that all of Israel, the Jewish people, are arevim ze lase, needs reinterpretation, maybe even restoration. Looking at Eichmann's abduction and Pollard's hiring, I have tried to show that the current ambiguity has resulted in much denied and ignored misery and pain. Maybe it's a civilian input, person in great suit and uncharismatic professionalism, deploying more deliberation and less unilateralism, could help interject a measure of sober morality, maturity, to this delicate and important relationship. Thank you.
Thank you very much, Professor Lahav, for a very interesting presentation. We'll save our comments and the reactions to the end of the presentations. And we'll move now to our second speaker. Our second speaker is Asaf Lachovsky from Tel Aviv University Faculty of Law. Professor Lachovsky is a graduate of Tel Aviv University Law Faculty and the School of History and of Harvard Law School. Currently he serves as the director of the Zegla Center for Interdisciplinary Research of the Law. His research interests include the intellectual history of law and the history of taxation. Professor Lachovsky published articles on taxation, legal history, and sociology of law and comparative law, including a book on the legal history of British-ruled Palestine. Professor Lachovsky is, as we heard, a leading scholar on Israeli legal history, and he is one of the founders of the Israeli Legal History Association. Professor Lachovsky's talk deals with a long and intense debate in Israeli legal history, the relationship between Israeli law and Jewish law, or as it's called in Hebrew, Hebrew law, Mishpat Ivri. And on the one hand, Jewish law is an essential element, one may say the essential element of the Jewish legal heritage, one that a Jewish state must incorporate into its system. I may share you an incident I had a few days ago when I participated in a workshop at the Columbia Law School in which Suzanne Stone presented a work of her on a Talmudic issue, and several faculty members have approached me before Suzanne's talk saying, well, as an Israeli law professor, you are obviously an expert in such issues. This is clearly not the case. In fact, most Israeli legal scholars and practitioners, as well as judges, know the American legal system much better than they know the Jewish law. Professor Lachovsky's talk traces back the roots of this debate by addressing an unknown affair that took place shortly after the foundation of the State of Israel in 1948. 1948, which relates not only to the role of Jewish law of Mishpat Ivri in the Jewish state, but also to the content of what should be the content, the relevant content of this body of law. In his talk, Why Isn't Israeli Law Jewish? The Failed Legal Revolution of 1948.
Okay, thank you. I should also say thank you to the organizers of this wonderful conference. And I thought that I'd start, like some of the speakers early this morning, like Stephen Flanders and David Wilkins, by saying that I'm also an outsider. I'm also, unlike most people here, not a Jewish lawyer. In my case, I'm an Israeli one. Okay, and Israeli and Jewish, as I'll try to show, are not the same. Actually, this is kind of a bigger question, which maybe we should have discussed more in this conference. What exactly is Jewish? Who is a Jew? And obviously, there are different definitions of the term. It's a cultural, religious, ethnic term, also maybe related to food, as we learned this morning. Okay, and my talk, as Barak said, is about Israeli law and Jewish law and its relationship. The conference generally is about Jewish lawyers, and we can analyze this term, Jewish lawyers, in various ways. One way to do so, and some of the panelists today talked about it, is to look at Jewish lawyers and compare them to lawyers coming from other ethnic backgrounds, WASP lawyers or African American lawyers. But one can also look at the term Jewish lawyers and try to analyze its two parts, Jewish and lawyer. What happens when there's a conflict between the two parts? One can think of a conflict between, say, the professional interests of lawyers on the one hand and a commitment to Jewish ethical values. And I'd like to analyze a second kind of conflict, one between the professional interests of lawyers and a commitment to Jewish culture, to nationalist ideology. What happens when lawyers are committed to the narrow professional interest of their specific professional group on the one hand, but also to, in my case, cultural Zionism. I want to look at Israel in 1948 and see what happened when Israeli lawyers were faced with this dilemma, with this problem. And 1948 is merely one example of a conflict that actually existed for most of the 20th century in Palestine and then in Israel. So my paper has three parts. I'll focus on the third and last part. The first part of the paper is basically an overview of the legal history of mandatory Palestine, talking a bit about the process in which the law of mandatory Palestine became was linked to English law. Then I talk in the paper about failed attempts to create a legal system based on Jewish law in mandatory Palestine and also in post-1948 Israel. And actually, Ruti Gabizon talked yesterday about 1980 and the Foundations of Law Act, but 1980 was only the last episode in something that began in the early 20th century, and I talk a bit about the history of the failed attempts to link Israeli and Jewish law. And then the paper asks what are the reasons that these attempts failed. And I talk about several reasons. First of all, I talk about practical reasons that prevented the linkage between Israeli and Jewish law. Then, because this is a conference about lawyers and the legal profession, I talk about professional lawyers and their opposition to Jewish law, some professional lawyers and their opposition to Jewish law. And then I ask, why did this opposition succeed? And I offer a cultural explanation. I talk about cultural images that lawyers shared with the wider Israeli population, and I argue that some lawyers successfully manipulated these images in order to prevent a linkage between Israeli law and maintain the linkage between Israeli and Western, mainly English law. And I focus on one specific cultural image, an image of Israeli society as what what people call the desert generation, a society which is in a process of transition, which has not reached perfection yet, and therefore does not really need the perfect law, can live with a legal status quo which was based on English law. Okay. So first, the first part of the paper, as I said, is about the law of British-ruled Palestine. This is just a quick overview. In the 19th century, Palestine was part of the Ottoman Empire, and the law of the Ottoman Empire at the time was a mixture of Islamic norms and practices and courts, and also Western, mainly French, norms, courts, and practices. The British came to Palestine in 1917, and they ruled the country for 31 years. And in these 31 years, they anglicized the legal system, or partially anglicized the legal system, that is, imported English procedures, norms, practices into the law of Palestine. So basically they changed the basic features of the legal system, importing an adversarial mode of litigation, a conception that judges have a major role to play in creating legal norms, a unitary court system, and many other basic features. They also imported a lot of English law, and so a lot of fields of the law of mandatory Palestine became anglicized. So criminal law, tax law, evidence, procedure, a lot of these areas there was legislation enacted based on English law, and they became English. The most important thing the English did, from my perspective, is that they changed the identity of the legal system. Ruti Gabizon mentioned this yesterday. In 1922, the British enacted the Constitution, something like a constitution of mandatory Palestine. It was the Palestine Order in Council of 1922, and Article 46 provision, or Section 46 of the Palestine Order in Council, said that when judges encounter new legal questions, when there are gaps in existing legislation, they should turn to the doctrines of common law and the principles of equity. So the identity of the legal system, the default rule became an English default rule. English law was supposed to fill in gaps in the legal system of mandatory Palestine. The British left in 1948. Israeli independence is 1948. And what they left was a legal system which was partly Ottoman, that is Islamic and French, and partly English. And Israelis, surprisingly enough, retained this legal system. It's still, in many senses, the legal system of Israel in 2006. This is why Barak doesn't know a lot about Jewish law, but knows more about English or American law, and me too, actually. Large parts of the mandatory legal inheritance are still in existence. So our tax code, for example, is still based on a British enactment from 1941. Our criminal law code is still, of course, with many changes, still based on a British code from 1936. And I can go on and on talking about specific areas of law. There was, as Ruti Gabizon said yesterday, there was a formal attempt to decouple Israeli and English law, but this didn't happen in 1948. It happened in 1980 with the Foundations of Law Act of 1980, which said that Article 46 is abolished, and that Israeli judges should, from now on, turn to, the law said, to the principles of freedom, justice, equity, and peace of Jewish tradition, whatever that may mean. And actually, nobody knows what this means, and the Foundations of Law Act actually had very little effect on the law of Israel today. If you look at it statistically, or if you do a kind of a Hartian rule of recognition, asking lawyers what do they think the legal system that is closest to Israeli law, I think most people would say that, most lawyers would say that Israeli law is closer to American or English law than it is to Jewish law. And there's a question here. And the question is, why isn't Israeli law Jewish? How come that in 1948 a Jewish legal revolution did not occur? Why wasn't Israeli law in 48 in this constitutional moment when things could have been otherwise? Why wasn't it linked in some way to Jewish law? It's only natural. And it's even more natural once you realize, and now moving to talking a bit about the Jewish Legal Revival Project, it's even more natural when you realize that there were lots of efforts to create a legal system based on a modernized version of Jewish law. Actually, the history begins in the early 20th century, even before the British occupation of Palestine, and the roots go back to the 19th century, to nationalist conceptions of law associated with the German Historical School in Germany, and also to cultural Zionism of the early 20th century. And as you probably know, the cultural Zionism was very successful in some respects. For example, the revival of Hebrew, taking the language which was religious and only used in prayer and turning it into a living language of Jews in Palestine and later in Israel. But the legal revival project was not a success. At some point in time, in the 1920s, it actually seemed as if it would succeed. In the 1920s, the Jews of Palestine had an autonomous system of courts, unrelated to the government courts governed by the British. And there was a lot of interesting academic activity of comparative law, an attempt to codify Jewish law and modernize it. Very interesting also because it was jurisprudentially very sophisticated. The notions used by the Jewish lawyers in Palestine who belong to this movement are very similar to what we find in American legal realism or the German free law movement. So at one point in time in the 1920s, it seemed as if the Jews of Palestine and later the future Jewish state would have a legal system based on Jewish law. The project in some senses failed in the early 1930s, but as Israeli independence was approaching in 1948, it seemed as if calls for legal revival reappeared, and it seemed as if indeed Israeli law would be linked in some way to Jewish law. Now, there are obviously various ways of doing so. Nobody expected Jewish law to be modernized overnight and replace English law as the legal system of the Jews in Israel. People made far more realistic demands. If you look at periodical articles from that period, people said, let's integrate Jewish law into new Israeli legislation, for example. Let's enact a constitution, and the constitution would include the declaration that the basic law of Israel is Jewish law. Let's abolish Article 46 of the Palestine Order in Council and decouple Israeli and English law, and instead have a provision which would require Israeli judges to turn to Jewish law when they encounter gaps in the existing legal system. But that didn't happen. In May 1948, Israel declared its independence, and the first act of legislation after Israeli independence in May is the Law and Administration Ordinance of 1948, which basically said the legal status quo, including Article 46, will remain. There will be very little change in the legal system of Palestine. We basically inherit this legal system, we Israelis. And there's a question here, why did this happen? And a lot of people have wrote about it. Obviously, there were a lot of practical reasons for the failure of this Jewish legal revolution of 1948. There were institutional barriers to the use of Jewish law. There's a wonderful article by my colleague Ron Harris of Tel Aviv University discussing how the committee that was supposed to determined the use of Jewish law in the new state was divided between Jerusalem and Tel Aviv, and people could not move, and it was too big, and the head of the committee died in an attack on a Jewish convoy, and a lot of accidental events that prevented the use of Jewish law. Also, law obviously is very conservative. Even countries that kick the rulers out often retain their law. America is obviously one example, but we also know in legal history of examples where legal revolutions do occur. We can think of Turkey, we can think of Turkey after the First World War, we can think of Japan in the 19th century, and if we think about a Jewish legal revolution in a minimal sense, in not enacting Jewish law, a full-blown system based on Jewish law, but rather having a small provision instructing judges from now on to turn to Jewish law, it's really not obvious why this didn't happen apart from practical explanations. There's another sort of explanation. This is a conference about the legal profession, so I want to talk about another sort of explanation, and this is about an explanation linking the failure of the revolution to Jewish lawyers. So one can say that Jewish lawyers were responsible, in part at least, for the prevention of a linkage between Israeli and Jewish law, because they saw Jewish law as a threat to their professional monopoly. This argument was first made by my colleague, another colleague of mine at Tel Aviv, Ronen Shamir, who wrote a book about the autonomous court system that existed in Palestine in the 1920s. And what Shamir argued, I think quite convincingly, was that some professional Jewish lawyers in Palestine enjoyed a monopoly on access to the legal system because they knew English and they were familiar with English case law and English legislation, and they were basically uninterested in Jewish law because it was a threat to their professional interests. Now, the same argument can be made about 1948. One can see, indeed, some Jewish lawyers being opposed to Jewish law in 1948 because it threatened their professional interests. And again, there are other examples in other places. Mark Galante wrote about India in 1947, and actually the same thing that happened in Palestine also happened there. There was an attempt to create a legal system based on Hindu law in India after independence in 1947, and the attempt failed mainly because of the opposition of professional lawyers. But the failure of the Jewish legal revolution in Israel in 1948 cannot be explained merely by the fact that some professional Jewish lawyers were opposed to Jewish law, because the Jewish profession in Palestine was not homogeneous. There were many lawyers who were familiar with English case law, English legislation, and knew English, but a lot of the Jewish lawyers in Palestine and post-48 Israel actually came from Central and Eastern Europe and were less familiar with English law. Some of the leaders of the Jewish powers were really committed to the revival of Jewish law, including the editor of the very influential journal of the Bar Association, Hapraklit. There was a system of Jewish legal education in Palestine, actually two law schools. One, the Tel Aviv School of Law and Economics, which is kind of the forefather of Tel Aviv University, and also there was a program on Jewish law at the Hebrew University in Jerusalem, and both the Hebrew University and also the Tel Aviv School of Law and Economics were really committed to the Jewish legal revival project, and there were also important political actors, mainly from the religious parties, who were committed to Jewish law. So saying that lawyers, their professional interests led to the failure of the Jewish legal revolution is not enough. One has to ask, why did these lawyers succeed? And I think their success has to do with culture, with very sophisticated manipulation of cultural images that lawyers shared with the wider population, the lay Jewish population in Palestine. So in my article I talk about images that Jewish lawyers used of Jewish law as religious and archaic and unfit to serve as a legal system of modern secular Zionist Israelis, of something connected, Jewish law is connected to the diaspora, something that Nina talked maybe a bit about. We Zionist, secular Zionist Jews are not, we are macho Jews, not related to the weak, thin, white, pale Jews of the diaspora. And also, and that's what I want to focus on in my talk here, not just images of Jewish law, but also images of Israeli society. Israeli society is a desert generation, an imperfect society that does not deserve a perfect law because it still has to change to reach a state of perfection before a perfect law based on Jewish law would be enacted. Okay, so as many of you probably know, Israel really went a massive social and demographic transformation in 48 and in the 1950s. In a decade, Israel's population more than doubled. The country absorbed huge waves of immigration from the Middle East and from post-Holocaust Europe. And many people observing this massive transformation said that defined Israel as a society which is in transition, whose identity hasn't crystallized yet. It's a desert generation similar to the Israelites who wandered in the desert for 40 years before they could reach the promised land. And people use this argument, for example, in debates about the Israeli constitution. Israel still doesn't have a constitution almost 60 years after its independence. And the reason it doesn't have a constitution was that when Israel was supposed to enact one in 1948, people said, we don't need a constitution or can't have a constitution because not all the people who are supposed to agree on this constitution are here. Not everybody, not all the Jews are supposed to come have arrived. So in the debates in the Knesset about the enactment of the constitution, one of the Knesset members said the constitution is created, and I quote, not at the beginning of a revolution, but at its end, whereas we are not at the end of our revolution, but at its beginning, because our revolution is not the establishment of the state, but the gathering of the exiles, and obviously everybody will come here in 2 or 3 years' time. Okay, and one can see the same argument, the desert generation argument, also used in debates about the replacement of mandatory law. So, for example, Eliezer Malchi, who was a judge and a prominent lawyer in Israel in the 1950s, wrote an article about a proposal for the replacement of the criminal law of mandatory Palestine based on English law with a unique criminal code which will be based on the principles of Jewish law to the greatest extent possible. And what Malchi said, he said the character of Israeli society is still not crystallized, it's still undergoing a process that could take an entire generation until a new generation will replace the desert generation of the present. Therefore, he said we should adopt a conservative approach, preserving the legal status quo, because, as he said, and this is a quotation actually from Jewish prayer, the time has not yet come to repair the world in the kingdom of God, tikkun olam. Okay, we can't really reform or repair the world or create the perfect society. Now we have to wait, and therefore we also have to wait and retain the mandatory legacy, because law, the perfect law, will only be enacted once we have a perfect society. Okay, so in conclusion, I think the story that I'm telling is interesting for several reasons. One reason is that it shows that lawyers think about the identity of the legal system, but they are not free to determine it on their own, even if their professional interests demand that they move the system in one way or the other. They have to justify their positions in ways that resonate with wider cultural perceptions. And some Israeli lawyers succeeded in preventing a Jewish legal revolution in Israel after 1948 because they made a very smart use of widely held cultural images of law and society that supported the retention of the legal status quo. The second reason I think my story is interesting is that I think it is interesting in a comparative way, because one can think of comparing this story, and I haven't written about it in the paper yet, but maybe if there'll be a final version, I'll write it in a final version. You can think about comparing the Israeli story of 1948 with, say, what's happening today with Islam. Okay, in the Islamic case, at least some Islamic fundamentalists see law as a vehicle to be used in order to reach perfection. So law is, if we enact Sharia, we'll also have the perfect Islamic state. Sharia will lead us to the perfect Islamic state, whether this is Iran or Saudi Arabia or maybe the caliphate that bin Laden is talking about. But utopian or messianic urges, non-religious in my case, secular, but it may be very similar in many senses, can also lead the other way. In the Israeli case, people said we don't have a perfect society, therefore we can't have a perfect law. We'll retain the English status quo until our society changes. So kind of utopian or messianic urges can work both ways. Okay, so I haven't done the comparison yet, but I think it's interesting. The last thing I want to say is that this is kind of an anecdote and related to what's happening in Israel now. In 2006, as I was preparing to depart from New York, I came across a newspaper article from last week, actually, which says that apparently, I didn't know about it, but apparently there's some sort of group who attempted to create or has created 9 courts dealing with civil law matters, which according to Jewish law, and they had just had their first conference, these courts are supposed to serve as a convenient alternative to secular Israeli law, which is not based on Jewish law. And apparently, even in 2006, this urge to, which we can talk about maybe in the Q&A, whether it's really important to do so, whether Ruti was right yesterday in the normative argument that it's important to link Israeli and Jewish law, this urge to link Israeli and Jewish law still exists even in 2006 as kind of a side issue, not the major, this is not the major identity of the legal system, but people are still interested in it even today. Thank you.
Thanks, Asaf. Again, we will have a discussion about this talk later. But first, we'll move to the second part of our panel by discussing the experience of lawyering of Jews in two other countries. Our third speaker is Professor Kenneth Ledford from the Department of History at Case Western Reserve University in Cleveland. Professor Ledford earned his PhD from Johns Hopkins University. He is an expert in the fields of German legal system and German legal history, as well as in European history. He has published numerous articles and books. Amongst his publications, the book From General State to Special Interest, German Lawyers, 1878-1933. Professor Ledford will talk on the Jews in the legal profession in Germany from a historical perspective. He will focus on 3 stages in this context, from the emancipation in the mid-19th century to assimilation in the first decades of the 20th century until the exclusion in the Third Reich. Professor Ledford, please.
I too would like to thank the organizers for including me. It's been a stimulating conference for me, and I hope that my entry in the competition for who's the most outside doesn't seem too remote, although I suspect that Mitra will best me very shortly and supplant my claim to be the most remote from the main topic of the conference. This paper is not something that I've focused my primary research on, but it's something that, after having spent a good part of 2 decades working on various legal professions, I've done the book on private practitioners, and I'm writing a book about the Prussian judiciary now. It was clear to me that I had a lot of information about this, and it was just a question of synthesizing it. So that's what I've tried to do here in a survey for people whom I take to be non-German specialists. If anyone here is a specialist in Germany, I apologize to you. In June 1905, District Court Judge Franz Paul Rosenthal in the Neubrandenburg Prussian provincial town of Landsberg an der Wartha was frustrated that his career advancement had ground to a halt in such a minor place. So at the age of 57, he applied to retire. His application was endorsed by his supervising judge, forwarded to the Ministry of Justice. He was awarded the typical medal one got upon retirement, given his pension, retired, and moved to Berlin. But he apparently wasn't ready for repose. 2 years later, he wrote the Prussian Minister of Justice to seek reappointment as a judge at some district or superior court near Berlin, so he could be near his adult children. And the Justice Minister turned to the presiding court of the presiding judge of the regional court, the Kammergericht in Berlin, for his opinion of this petition, and the judge responded in a most revealing fashion. In the opening recitation of Rosenthal's vital statistics, the presiding judge included not only his date of birth, but his religious confession, Mosaisch, polite terminology for Jewish, a datum that had been entirely missing in the transaction 2 years before. The Kammergericht president expressed skepticism that after only 2 years of retirement, his health could have recovered. But then he added, regardless of his health, I cannot support his reinstatement in view of his frequent unsatisfactory conduct during his career, as indicated on pages 116, 131, 161, 183, 193, 232, 233, 258 of Volume 1 of his personnel records, and pages 4 and 16 of Volume 2, as well as pages 85 and 109 of his disciplinary case record. This was a happy day in the archive. Acting upon this recommendation, the Justice Minister declined to restore Rosenthal to the bench. Rosenthal, it turns out, was that relative rarity in the German Empire, a Jew appointed to the Prussian judiciary. Clearly a talented, intelligent, and able man, he had pursued his study to the point of obtaining a Juris Doctor degree, not something that very few did. Rosenthal's career was marred not only by personal failings of arrogance and laziness, but by the frustrating dilemmas of 19th century German Jews who sought careers in the legal professions. Many talented Jewish lawyers triumphed over these frustrations, but Rosenthal succumbed. And in many ways, his story of failure illustrates these other stories of triumph. In this talk, I'm going to return to Rosenthal at least once as sort of an example of the dilemmas of Jewish experience in the German legal professions from the 19th into the 20th century. But embedded in the larger history of Jewish presence in German culture and society, intertwined with the history of the rise and fall of liberal, political, economic, social, and especially legal ideology in Germany, Jewish lawyers and judges provide a study in microcosm of the emancipation, assimilation, and exclusion or extermination that all German Jews experienced in Germany's transition to modernity and to postmodernity. And I will argue that Jews in the German legal profession were in many ways the miners' canaries of German liberalism, and that their fate cannot be understood apart from an inquiry into the fate of liberalism and its supporting legal ideology in the 19th and 20th centuries. Now, first to emancipation. The politically fragmented nature of 18th century Germany had led to a similar fragmentation in the legal regulation of Jewish life. The absolutist regimes of the German kingdoms, duchies, and principalities within the Holy Roman Empire of the German nation. Come on, say it with Voltaire, which was neither holy nor Roman nor an empire, right? Hardly provided any guarantees of rights for any Christian subjects before the promulgation of the Prussian General Law Code of 1794. Not to mention any guarantees for Jews who were barely tolerated residents. Everywhere, Jews lived in Germany subject to significant civil disabilities as tolerated subjects of the state who indeed enjoy its protection but are in no way members of civil society. In such circumstances, the question of Jews studying law and entering into legal professions was simply not raised. But in the course of the 17th and 18th centuries, a small segment of the Jewish population, often under the direct protection of one or another of the German royal or ducal courts as Hofjuden, emerged as financiers and entrepreneurs and entered life outside the Jewish community. By the mid-1700s, a group of Jewish intellectuals coalesced in Berlin around the monumental figure of Moses Mendelssohn, perhaps the leading figure of the entire German Enlightenment, and in conversation with non-Jewish Germans, such as Friedrich Lessing, began to contemplate the civil emancipation of Jews. All envisioned a period of civil improvement, bürgerliche Verbesserung, for most Jews, meaning the opportunity for poor, insular Jews to attain the benefits of cosmopolitan and German culture before being fully admitted to the rights of citizens. Alongside this emancipatory civil improvement, and as an essential part of it, Jews began, very gradually at first, to pursue both the neo-humanistic classical secondary education at the Gymnasium that was a precondition to admission to university study, and to study in small numbers at German universities. Now, there's a big literature about this, most of it in German, and I'm going to go through the numbers pretty quickly. The first 4 German Jewish law students entered the University of Königsberg in 1788, and the small numbers followed. The problem was that under the prevailing system, all law-related careers remained closed to Jews, no doubt deterring many who would otherwise have pursued the study of law. Conversion to Christianity immediately opened the door to entry into legal careers, although social discrimination often extended to converts. For example, in 1799, Isaac Elias Itzig, a member of a prominent Berlin banking family who had studied law at university and had himself been baptized, sought admission to the period of practical legal training required before becoming a judge or advocate. The Minister of Justice objected, arguing that Itzig's family connections to his still Jewish family should disqualify him. But the King of Prussia decided, quote, that a Jew who has converted to the Christian religion, even if he remains still connected to his Jewish family, nevertheless can be admitted to the justice service in accordance with his qualifications. In and out. Civil emancipation of Jews in France, as a result of the French Revolution, formed the background against which we have to view the beginning of the emancipation in Germany. In 1798, France extended its emancipation to the German regions on the left bank of the Rhine, which it had absorbed, guaranteeing to the Jews there free choice of careers and eligibility for appointment to all state offices. This was later extended east of the Rhine as well. So in competition with the French, even before 1815, major German powers, particularly Prussia, had to respond to this emancipatory appeal, not only for Jews, but for their own Christian subjects. And with regard to Jews, the Prussian response was the Edict of Emancipation in March 1812. Paragraph 7 made Jews citizens of Prussia with the same civil rights and liberties as Christians, insofar as the edict didn't explicitly provide otherwise. Great drafting. Section 8 opened to Jews all university teaching, school teaching, and local offices, but Section 9 expressly postponed to a later date decision on opening other public posts, including judicial posts and the private practice of law. Now, the Congress of Vienna in 1814-15 greatly expanded Prussian territory as a reward for its important role in the defeat of the French Revolution. Prussia regained its former territories in the Rhineland and new territories that constituted all of the part of Germany that had been absorbed into France for 20 years. French law was preserved by the Congress of Vienna in this territory. But preservation of that law presented Prussian authorities with a difficult decision with regard to Jews in the legal profession. For 3 Jews had entered state service under French rule, including one, Heinrich Marx of Trier, who was practicing law. Despite that the fact that the local chief judge evaluated him positively and recommended that Marx be retained, the Minister of Justice in 1816 refused to retain him. Heinrich Marx, father of Karl, converted to Christianity and continued to practice law. Although other German states followed more generous policies, Prussia, until after 1848 for private practitioners and until after 1870 for judges, insisted on conversion as a condition for Jews to enter the legal professions. Nonetheless, during the period of the Restoration from 1815 to 1848, Jewish students began to study in slightly larger numbers at university. The problem was that in Prussia in particular, even the private practice of law remained a state office, subject to appointment by the Minister of Justice. In general, the interwar period, the period of Restoration was a period of reaction, which climaxed in Prussia with the so-called Jew Law of July 23, 1847, whose aim was to unify within the Prussian kingdom the manifold laws regulating the rights of Jews. And it represented a general retreat from the Emancipation Edict, admitting Jews to state offices only if their powers, the offices' powers, did not include the exercise of judicial, police, or executive authority. Now, the constitutions of the Revolution of 1848, including that in Prussia, had emancipatory language. But in reality, the process of emancipation was not completed until the North German Confederation in July 1869, under Prussian, actually against Prussian resistance, but with Prussian acquiescence, passed the law concerning the equality of the confessions in civil and political relations and removed the final obstacles. This law carried over into the German Empire, which began the period of assimilation and inclusion. Indeed, the German Empire, 1871 to 1918, and the Weimar Republic, 1919 to 1933, were the age of success for Jews in the German legal profession. Although Jews had to continue to cope with widespread social discrimination, and in the 1880s and 90s, and again after during the Weimar Republic, with the rise of political anti-Semitic movements, although Jews had to cope with the rise of racialist anti-Semitic thinking, nonetheless, they moved into the legal life of Germany and seemed to establish solid foundations. Jews played an important role in the thriving German Rechtsstaat that ushered in the full flower of industrial capitalism and made the German economy thrive. The breaking point was a series of legal reforms in 1877 to 79, which changed the framework for the private practice of law. Under the new powers of the Constitution of 1871, the German Reichstag enacted codes of civil and criminal procedure, a new organization of the court, and a law governing legal practice that eliminated the old state-determined limit on the number of practitioners, expressly in the language of economic liberalism. The cry was free path to talent, open path to talent. Liberals, and among them Jews, were in the lead for this movement, which culminated in 1879 with the entry into effect of this package of 4 laws. At this point, the bar was opened to all who were qualified. Qualifications were high. 6-semester study at a German university, 4 years of practical legal education, surrounded by 2 bar exams, at which point one could become either a practitioner or a trainee judge. There were other career tracks as well that we can talk about in question time. But the opening of the bar to all who were qualified was of particular importance to Jews. No longer would the career prospects of a talented young German Jew depend entirely on the favor of a prejudiced minister of justice. Every German who had passed these qualifications was entitled to practice law. It was just a matter of where. I have lots of statistics in the paper. I'll leave them out in the interest of brevity. But Jews grew from essentially no portion of the bar in 1871 to about 28% by 1905, regionally higher, notably exceeding 50% in the city of Berlin. Progress was slower in the judiciary because of continued anti-Semitic appointment policies. There's actually a substantial German literature on this. But even there, Jews were overrepresented, rising to roughly 7% of the entire Prussian judiciary at a time when Jews were 1% of the Prussian and the German population. Now, the notable case of Albert Mosse serves as a telling illustration of the difficulties that Jews faced in the Prussian judiciary. Mosse's papers are down 14th Street at the Leo Baeck Institute archives. A member of a distinguished Jewish family whose brother Rudolf was one of the leading left-liberal newspaper and book publishers in Berlin, originally from the eastern province of Posen, but later based in Berlin, Albert Mosse was a brilliant student at the legal faculty at Berlin and became the protege of one of the leading law professors of the era, Rudolf von Gneist. A veteran of the Franco-Prussian War, Mosse aimed from the beginning for a career as a judge, and his initial career was very swift. His first judicial appointment in 1876 was in Spandau, an attractive location near Berlin. He transferred to the City Court of Berlin in 1878 at the tender age of 33, and widely recognized as a brilliant legal mind, even Gneist's patronage could not bring Mosse advancement beyond promotion in 1885 at the age of 40 to the Superior Court of Berlin. He was the first Jew appointed to a Superior Court, a Landgericht, in Prussia. This was a meteoric rise for a Jew, but he soon ran into roadblocks which led him to 5 years of service in Japan, drafting Meiji-era legal codes, at the end of which he returned to Germany with a recommendation that's all too familiar in the annals of anti-Semitism. The German ambassador there, anticipating difficulties for Mosse returning, wrote, "If I may permit myself in closing to add one final remark, that Herr Mosse's Jewish faith, as well as his family relationships with persons whose political opinions are not favorable to the government, are not unknown to me. The first characteristic, however, never manifests itself unpleasantly. And with regard to his political view, I can only assure you he stands politically at a great distance from those of his relatives mentioned above." His career remained thwarted Although twice recommended for appointment to the Imperial Supreme Court in Leipzig, he was passed over. He later became the first judge appointed to a court of appeal, but not in Berlin to the prestigious Kammergericht, as he would have expected, but to the remote Eastern Court of Königsberg. Now, Franz Rosenthal's disciplinary problem that held back his career also had its roots in this very complex of prejudice, assimilation, and honor. Early in his career, he had been a district court judge in another small town called Mittenwalde, where he had run into conflict with the court clerk named Günther, who was clearly an anti-Semite. In October 1882, the disciplinary panel of the Kammergericht convicted Rosenthal of having demonstrated himself by his conduct in office unworthy of the respect and honor that ought to be accorded to his post as judge, and sentenced him to a punitive transfer to a yet less attractive small town in Brandenburg. And the story was telling. Günther was an unreliable employee given to drink. There was one incident in the small town's tavern where it was impossible to avoid running into each other, in which Günther publicly insulted Rosenthal, and Rosenthal took no action privately or officially. In a second incident, Rosenthal overheard Günther complaining to a Jewish assessor or trainee judge about Jewish judges and Jewish assessoren, and when Rosenthal remonstrated with Günther, Günther replied, "Mr. Jew Judge, if you want to get me fired, that is fine with me. Bring me up on charges. It is no honorable occupation to work under a Jew district judge." But Rosenthal did not report this and brought no charges. Only later, when Günther brought charges against another employee and Rosenthal was asked for an evaluation, did he talk about all of this history, at which point his supervising court brought charges. The import of the complaint against Rosenthal was that his unwillingness to discipline the insubordinate Günther and his unwillingness to protect his honor as a Jew was a breach of the duties of his position that his position as district judge imposed upon him. As a Jew, Rosenthal had sullied the honor of the Prussian judiciary by failing to defend his honor as a Jew in the face of a coarse challenge from an inferior. This was, of course, an instantiation of the double bind of anti-Semitism on culturally assimilated Jews. Had Rosenthal insisted on the dignity of his office in the face of Günther's insults, he would have been accused of manifesting the very touchiness and pushiness ascribed by anti-Semites as a negative Jewish characteristic, but in not reacting, he was adjudged by his peers to have cravenly dishonored the entire judiciary, thus proving the cowardice that was an anti-Semitic ascribed characteristic of Jews. Now, although the experiences of Mosse and Rosenthal established the very real limits under which Jews in the judiciary operated during the German Empire and Weimar Republic, there was real room for success and prominence, and there is actually a large literature about this, very celebratory. Although the anti-Semitic charge against the Weimar Republic as a Jew republic was a resonant one, it doesn't correspond with the facts. There was no great influx of Jews into any branch of the legal profession disproportionate to what had occurred in the empire. Exclusion and extermination is the sad conclusion of this story that we know all too well. Both before and after the Reichstag fire in February 1933, Jewish judges and lawyers had to endure organized assaults, boycotts, and humiliation at the hands of the SA and other anti-Semites. April 7th saw the promulgation of the law for the restoration of the professional civil service and a separate law on admission to the practicing bar, which excluded all judges except those who fell under the saving clause of front veterans or children of those who died at the front or those who were already admitted before August 4th of 1914. The same sort of thing took place with regard to the private bar. The Nuremberg laws of 1935 tightened this up more closely and began the erosion of this Hindenburg insisted upon acceptance, which disappeared entirely after the Kristallnacht pogrom of 1938. I want to end with two vignettes in summary. Now, Jewish jurists who remained in Germany after 1938 after 1933 responded to these developments in a number of ways. Many had immigrated, others remained and suffered a spectrum of fates. A remarkable outcome is the story of Horst Berkowitz of Hanover. Born in Königsberg in East Prussia, he had volunteered for service in the First World War, where he was severely wounded and partially disabled. After the war, he had completed his university study, been admitted to the bar, practiced in Hanover with two established Gentile lawyers, one of whom was a strident member of the conservative and later anti-Semitic German National People's Party. He enjoyed a remunerative and satisfying practice until 1933. But on July 1st, 1933, with 3 days' notice, his partners terminated the partnership. Because he was a wounded war veteran, he practiced until 1938. He was arrested and engaged in forced labor through the balance of the after the outbreak of the First World War, which he survived. And upon being released, he was rehabilitated by the British Occupation Army and embarked upon a successful post-war career as a practitioner, culminating in many honors and distinctions, including the Bundesverdienstkreuz. More typical is the sad story of Hermann Reis of Marburg. Born in a small village in Hessen, outside of Marburg, to an observant Orthodox Jewish family, he studied law in Marburg and Frankfurt, socialized mainly with other Jews, married a relatively well-to-do Jewish woman, and set up practice in Marburg with a partner, Willi Wertheim, who was also Jewish, and they were both front veterans. They enjoyed a prosperous practice and comfortable bourgeois existence, but they were immediately disbarred in 1933 because Wertheim had once represented a Communist Party legal aid organization and had enclosed a friendly note when he sent his bill for his fee. Reis, disbarred, chose to remain in Marburg rather than emigrate, living from his investments and his work as a Jew counselor representing Jewish clients. And when war came, he became an administrator of the Marburg Jewish community, shrunk to 100 members until he was imported to Auschwitz, where he perished. After the war, some Jews returned to Germany, but in remarkably small numbers. The Jewish population of Germany, out of 82.5 million, is now 108,000, 30,000 of whom have arrived from Russia in the last 15 years. Now, to conclude very quickly, although Horst Göppinger, one of the leading scholars on this, bravely lists the names of pre-1933 Jewish law professors, judges, and practitioners who returned, the prominent Jewish presence in the German legal professions was at an end after 1945. Indeed, the only study of legal professionals that spans the caesura of the 0-hour Stunde Null of 1945 traces the continuity not of the Jewish presence in the bar, but of lawyers in the Federal Republic who had been implicated in the National Socialist Party, but had nevertheless reestablished themselves in post-war practice. Now, the relationship of German Jews to the legal professions in Germany always had at its core a close connection to liberal politics and liberal notions of meritocracy and the value of individual achievement. The heyday of this connection came in the liberal legal reforms of 1869 to 79, which not only emancipated Jews from civil disabilities with greater clarity than before, but by opening the private legal profession to market forces, guaranteed Jews an opportunity to claim for themselves a niche within the legal profession, determined only by their hard work and competence. Some Jews pursued legal careers in the judiciary and the academy, but there the process of state control of appointment and advancement limited their opportunities to advance to the full extent of their talent and hard work. so most entered private practice, where they thrived, advanced, and seemed by the Weimar Republic to be fully integrated and respected. But the values of liberalism had been under assault from the 1890s in Germany, both within and without the legal profession. And by the crisis at the end of Weimar, the liberal value of judgment based on an individual's merit was under widespread assault. Liberalism had reached its limits in political, economic, and social crisis, and frustrated Germans abandoned liberalism, and Jews in the legal profession and elsewhere fell victim to profoundly illiberal schemes that rejected the universalism of emancipation, suspected the aims and prospects for assimilation, and ultimately sought a solution for crisis by excluding Jews first from state service, then the private legal profession, then the national community by law, and finally from the national community by persecution and murder. The entire presupposition of the involvement of German Jews in the legal professions was the context of liberalism. And when liberalism lost its support, German Jews irreparably lost their place, both in the German legal professions and in German society as a whole.
Thank you very much. That was well within the boundaries of this conference. Our fourth speaker is Mitra Sharafi from Cambridge University. Professor Sharafi earned her PhD at Princeton University Department of History. She specializes in colonial South Asian legal history with a focus on an interdisciplinary study of the Indian legal system during the British colonial. Professor Sharafi will present her research on Parsi lawyers in colonial India.
Thanks. Well, we've just heard indirectly an allusion to some very interesting statistics compiled by Ingo Müller on German-speaking Jewish lawyers in the 1930s. And I'm referring specifically to the fact that 60% of Berlin's lawyers in 1933 were Jewish, as were 80% of Vienna's lawyers in private practice in 1938. There's only one community I can think of that compares, and that's the community that I work on, the Parsis or Zoroastrians of colonial India. As a member of one Bombay law firm said in 1911, the Parsis are the life and soul of litigation in Bombay, and in one shape or the other, they're connected with the majority of suits in the Bombay High Court. Now, the Parsis were originally Persian refugees who came to India after the 7th century invasion of Persia by Arab Muslims. They brought with them the ancient Persian religion of Zoroastrianism, and they maintained a distinct ethno-religious identity in their community over 1,300 years, largely through endogamous marriage and the absence of conversion into the religion. Under British rule, the Parsis became an elite of intermediary traders and professionals. And if you've heard of the conductor Zubin Mehta, the post-colonial theorist Homi Bhabha, the author Rohinton Mistry, or the rock star Freddie Mercury, then you know of some famous Parsis. Well, the Parsis are an example of a community that went for law in the same way as did the Jewish German-speaking populations of Berlin and Vienna in the 1930s. So today I want to offer the Parsis as a comparative case study. My research is on the late colonial period, so I'll confine my remarks to the last 50 years of colonial rule in India, that is, from the turn of the 20th century until 1947. In the British colonial world, I've not come across another community that bought into the myths of colonial legalism and used law to the same degree as did the Parsis, and that is speaking of Parsis as lawyers, judges, and litigants. Now, what's particularly interesting about the Parsis is that there were so many internal Parsi disputes that were resolved through litigation. And this is really the heart of my talk today, that there's this link between litigating and lawyering within this minority community. disputes over whether non-Parsis could be admitted into the community through intermarriage, adoption, and conversion, and disputes over theological points like proper death rite rituals and fire temple practices. All of these were resolved not by priests within the community or even in some internal community forum. These were resolved in the courts. Now, equally telling is the fact that a good number of Parsi lawyers and judges were the ones steering these disputes through the courts. So I want to start today by giving you a sense of the Parsi presence in the legal system of Bombay, and it was really in Bombay that the community concentrated. After it first came from Persia, the migration was directly to Gujarat, which is a state in western India, just north and west of Bombay. And then when Bombay rose to prominence, when the British took over from the Portuguese and made it a big trading center, then the Parsis also migrated from Gujarat to Bombay. But it's really Bombay that I'm talking about especially today. Then I want to suggest 6 factors that seem to have contributed to Parsi legalism, comparing the Parsi case study with other colonies and communities in the British Empire. By way of conclusion, I'll make some comparative remarks linking the Parsi and the Jewish case studies. So first, the figures. Now, Muller's percentages are higher than the Parsi figures, but even so, the Parsi stats are quite remarkable. In the early 20th century, Parsis were about 6% of the population of Bombay City, but they were 40 to 45% of all the lawyers and about 11% of all the Bombay High Court judges. An equally important part of the picture is the high rate at which the Parsis litigated. And I did a survey of the Indian Law Reports Bombay series, which were the official law reports, between 1900 and 1930, and I found that in about 20% of these officially reported cases, there were Parsi litigants involved. In roughly a quarter of that 20%, the suits were between Parsis on both sides. And in over a half of the 20%, Parsis were either plaintiffs or appellants. Now, these included suits of an embarrassing nature, both to the individual litigants and to their families, but also potentially to the community at large. And there are allegations of adultery, incest, addiction to opium, morphine and alcohol, and imbecility. But the fact that there were so many Parsi lawyers and judges to manage these disputes means that perhaps it's wrong to even assume from the beginning that this was really an outside forum. And this leads me to the 6 factors that may explain how the courts became the arena of choice for the making of careers and the breaking of reputations amongst the Parsis. Now, the first factor is a combination of time under colonial rule and a collective acceptance of English language education. In colonies like Nyasaland and northern Rhodesia, now Malawi and Zambia, there was no early 20th century non-European legal profession, in large part because British colonial rule came so late, that is in the 1880s and 90s. But even when a certain number of generations had been exposed to the colonizers' language and school system, some colonial communities still resisted Anglicization. And a number of colonial Indian Islamic movements like the Deoband school, which was a movement in the north of India, immediately come to mind. In 1900, though, the Parsis of Bombay had been living in a territory that had been under British influence since the 17th century, and Bombay was handed over from Portuguese rule to British rule in 1661 as a wedding present from the Portuguese Princess Catherine of Braganza, who married the British monarch. The community had also taken on the role of intermediary traders between British and Indian merchants. So in many ways, the community had become highly anglicized. But there were limits. Neither intermarriage with Europeans nor a conversion to Christianity figured into the Parsi affinity for British culture in a major way. And I would argue that anthropologist Tanya Luhrmann misreads the community when she describes it as aspiring to perfect Europeanization. This made the Parsis quite unusual for an anglicized colonial community because many westernized colonial elites typically intermarried at some point and also adopted Christianity. And the 2 best examples that come to mind immediately are the Anglo-Indians, previously known as Eurasians, of colonial India, who were the offspring of British men and typically lower caste Indian women, late 18th century, early 19th century. So there was both intermarriage and Christianization there. And also the Luso-African population of colonial Angola, who were an intermixed population that was sort of intermediary class in the slave trade in Angola. Same story there, intermarriage and conversion to Christianity. But the Parsis did not go this route. Now, the second factor is the relative size of the European population. In colonial India, it was relatively small. The 1911 census recorded that there were 244 million people in British India, of whom only 200,000 were European. So that's a ratio roughly of 1 European to every 1,200 South Asians. Obviously, this was not a white settler colony. It was typically in the white settler colonies that racial barriers to entry were erected when it came to entering the legal profession. And I'm thinking of the Cape Colony, South Africa, Canada, and Australia. By contrast, you can take an area like southern Nigeria, which was referred to as the white man's grave, for the reason that in a certain period, 18th century at least, the death toll of Europeans in the area was about 27% per year. So the population of European administrators in southern Nigeria was so tiny that the colony operated with a handful of undertrained white officials and crucially depended on a large number of Africans for essential services. As a consequence, there was a real African legal profession in southern Nigeria in the colonial period. The third factor is the community's wealth. And the joke is, and Mark Galanter will appreciate this, that there's no such thing as a poor or a thin Parsi. That joke is referring to the fact that the community was and is incredibly affluent. It made its wealth as shippers of opium in the opium trade, when that was a legal trade. And the opium trade, of course, also financed a major part of colonial rule in India. The Parsi community took the proceeds of that opium trade and invested it in industrial enterprise. And the man who is seen as the industrializer of India, a man named J.N. Tata, was a Parsi. So with all these interests in heavy industry and trade, it would seem that a familiarity with law would be vital to community success. A fourth factor has to do with internal hierarchies and structures in place for resolving disputes within the community. Parsi priestly authority was very decentralized. The western Indian state of Gujarat, as I mentioned, was the first place that the Parsis came to in India. And around the year 1290, the Parsi areas of Gujarat were divided into 5 dioceses called pantaks. And within each of those dioceses, there was a clear priestly family that would hold the final say when it came to any sorts of ritual questions. The problem was that between the pantaks, there was no single supreme authority. There was also the fact that there was no clear hierarchy of priestly authority in Bombay itself. And the reason for that was that when the pantaks were established, Bombay was a tiny fishing village. It didn't become a city, as I mentioned, until Portuguese and then British rule. But there was never a clear priestly family that was put in authority for Bombay. So you would have the situation where Parsi families would look to their ancestral pantak as the authority in any kind of disagreement. And potentially you could have a disagreement between Parsi families, each of which came from a different pantak, and then you would have a deadlock. There was also a body called the Bombay Parsi Panchayat, and Panchayat means traditional council of elders, and Mark Galanter has done a lot of work on this area. And the Bombay Parsi Panchayat was created and supported by the British government, in part to settle disputes within the community. But a mid-19th century crisis over polygamy led to erosion of its general authority in the community, and the large number of lawsuits against trustees of the panchayat and between trustees attest to that loss of authority. So the absence of a single strong authority, whether priestly or secular, within the community meant that there was a vacuum, and this was where the colonial legal system comfortably stepped in. There were other trading elites in Bombay that had heavily hierarchical internal chains of command and a single all-powerful head. The Bori and Khoja, or Ismaili Muslims, are 2 affluent communities of Shiite traders originally based in Gujarat, who also migrated to Bombay with the rise of colonial rule. They too must have had major commercial deals that occasionally went wrong between community members and required effective dispute resolution, but they also had a single head of the community whose authority was unchallengeable. For the Khojas, the Aga Khan enjoyed nearly divine status. And as the jolly third Aga Khan once confessed in the early 20th century, it's no beer and Skittles being a god. The ritual head of the Boris was called the Dai, and he resided for most of over the centuries in Yemen. And he also sat at the top of a clear pyramid of authority. So in both communities, effective excommunication was the penalty for anyone who took a dispute with another member of the community to an outside forum. The outcome was that most of these internal disputes never made it to the courts, unlike the Parsi situation. A fifth factor relates to the willingness of the Parsi community to share theological and ethnographic information about itself with the colonial state. And the absence of any sort of philosophical lock on the community's esoteric knowledge base meant that questions of theology and ritual pollution were made accessible to the colonial courts, letting the legal system into disputes that in other communities would have been reserved for the ritually privileged. Now, it's certainly true that Zoroastrian fire temples are strictly off limits to outsiders. The presence of any outsider defiles the temple's inner space, and reconsecration involves very costly and time-consuming procedures, increasing with the level of the ritual fire that's burning inside, and there are 3 basic levels. So Zoroastrianism certainly has a highly developed set of norms when it comes to spatial privacy. But when it comes to informational secrecy, things are different. Now, there was initial resistance to sharing the ancient and Middle Persian languages and texts of the Zoroastrians with Europeans, but this quickly dissolved in the early 19th century, and with it, the informational gates of Zoroastrianism were thrown open to the West. Compare this to communities with elaborate traditions of secrecy. Hugh Urban's work on tantric asceticism documents the many ways that that body of knowledge was kept out of reach of Europeans and other non-initiates for a good part of the colonial period. Tantra is a Hindu tradition of left-handed asceticism, as it's called. It offers its followers a fast track to enlightenment through the hazardous dark arts of Kali, who is the Hindu goddess of destruction. Now, the contents of the tantric belief system is accessible to initiates only. The Boris, whom I just mentioned, adopted a similar approach. Borishiyes were required to take an oath of secrecy deriving from earlier periods of persecution in both Yemen and India. Both Bori and Khoja Ismaili communities also endorsed a doctrine of dissimulation called a taqiyya. This Shiite doctrine required a person to lie to protect the faith, and this could include fending off outsiders' data probes. Theosophists in colonial India also limited access to their beliefs for outsiders. Theosophy was a universalist spiritual movement that was fashionable worldwide in the late 19th, early 20th century. It was a New Age religion of its day, and it fused elements of Eastern religions, especially Hinduism and Buddhism, with a belief in communicating with the spirit world. Followers had to take a vow of secrecy that was binding even in the courtroom. And I came across a great example of this in my own research. There was a major solicitor amongst the Parsi community in Bombay, early 20th century, named Jahangir Bhima Dalal. And he was one of the most important solicitors in the city at the time, as well as being a theosophical leader and a big eugenicist. And he refused to testify on theosophy in proceedings without first being released explicitly by the leaders of the movement, namely a woman named Annie Besant at that time. By contrast, I found the same solicitor interrogating scores of Parsi witnesses on ritual practice and fire temple procedures during cross-examination in other suits in the exact same court. Now, this point relates more to Parsis as litigants than as lawyers, but as I said earlier, I'm convinced that the high rates of Parsi litigating and lawyering were closely linked. The sixth and last factor is a set of internal cultural traditions that made Parsis intellectually compatible with an adversarial common law system. Legal anthropologist Bernard Cohen has looked at traditional modes of South Asian dispute resolution, and he's found them to be highly conciliatory and face-saving in their style of interaction. British colonial courts, by contrast, were struck, or seemed to many South Asian communities at least, as not just baffling and opaque for their obsessive proceduralism, but also as confrontational and aggressive in style. When I asked Parsis in Mumbai about the Parsi passion for law, many say that every Parsi child is taught to develop a strong sense of independence of mind, and then to also learn how to be willing to fight for the truth, no matter how many people may disagree with his or her opinion. What they're referring to is a Zoroastrian doctrine called Asha, and Asha means truth and moral righteousness. Zoroastrian theology is riddled with martial imagery associated with the good Zoroastrian's duty to decide for him or herself what is right, and then to fight for it militantly. And this tradition, I think, dovetails very nicely with an adversarial mode of colonial law. And it may have made the colonial legal system a good fit with many Parsis. So just to recap these 6 factors behind Parsi legalism, the first was time under colonial rule and a willingness to anglicize. The second was having a small European population, in other words, not living in a white settler population. The third was having major commercial interests as a community. The fourth was having decentralized and discredited internal systems of dispute resolution. Fifthly, having really no protection of esoteric knowledge, that is, having a strong sense of spatial privacy but not of informational secrecy. And sixthly, having an internal tradition of confrontational intellectual exchange. So finally, some comparative conclusions. How does the Parsi lawyering tradition align with the Jewish case study? Muller's work suggests that Jews in the German-speaking world in the early 20th century were excluded from the civil service and went into law instead. Similarly, in India, the Indian civil service was made so accessible to South Asians, at least at the upper covenant level, that very few Parsis were actually able to gain access. What's interesting is that even after independence in 1947, Parsis continued to concentrate on the legal profession. In the run-up to 1947, they were markedly absent from political negotiations surrounding independence. The Parsis did not lobby for separate electorates or for a reserved portion of state positions, unlike many other Indian minorities, amongst them the Muslims and the scheduled castes and tribes. After independence, many of India's top constitutional legal figures have been Parsi. So both Parsi and German-speaking Jewish communities focused upon the legal profession at a time when they're effectively excluded from governmental careers, it seems. And in the Parsi case, this continued even after those restrictions had been lifted. Applying these factors to the Jewish example, the big question for me is whether there is also a close link between lawyering and litigating. Did many disputes between members of the Jewish community in the German-speaking world land in court? And if so, was this in part because the community's internal organs for dispute resolution were decentralized or somehow discredited? If any of these disputes turned upon questions of ritual and religion, was this because, as for the Parsis, there was no protection of the community's esoteric knowledge base? And finally, would it be fair to say that there was an intellectual compatibility between Jewish traditions and German-speaking legal culture in the 1930s? To close, I just want to leave you with the comments of a British judge named Frank Beeman, who is actually blind, who ruled in 1908 on a very important case in the Bombay High Court on whether Zoroastrianism permitted conversion. And it was decided in part by him in that case that it did not. Beeman himself had Jewish ancestry, which only became apparent to me through oral history. I managed to find his great-grandson who lives in Dublin. And the great-grandson told me that on Beeman's mother's side, the mother's side of the family were descendants of the Gomberts family, which was an illustrious British Jewish family that converted to Anglicanism in the mid-19th century. Beeman's family background made one of his comments in this judgment quite intriguing. According to Beeman, the Parsis of India were much the same as the Jews. And I'm quoting here, a peculiar people with no country of their own, no separate national life of their own. Both communities were guests on sufferance of races, of peoples who had nothing whatsoever in common with their religious organization. Now, of course, Beeman might have added that there was another parallel trait between the two communities, and one presumably very close to his own heart, and that is that both were minorities that flourished in the law.
Thanks a lot. It was really illuminating comparison. We will conclude our presentations with a comment by Ruti Teitel, who is Ernst C. Staffel Professor of Comparative Law at the New York Law School. She is a graduate of Georgetown University and the Cornell Law School. Professor Teitel is a nationally recognized authority on international law, international human rights, and constitutional law. She is also an expert on Eastern European and Latin American post-totalitarian societies. Among her many publications is her path-breaking book, Transitional Justice, which examines the 20th century transitions from authoritarian to democratic regimes in many countries. Professor Teitel will comment on the various ideas and presentations that we heard in this panel. Please.
Let me add to the thanks to the organizers of this very interesting conference, and in particular the last set of very rich papers. The diverse papers we heard cross country lines and historical periods. They go as far back as Zoroastrianism and as far forward as the contemporary Pollard affair, to transnational, around the world, Germany and Argentina, diasporas, to Israel since its founding. All of them engage with the conference topic regarding Jews and the law and the legal profession. They also build, interestingly, on the first panel on legalism yesterday morning. Now, I thought it was interesting that each author wanted to get the prize of the most outside of the subject of the conference. Oh, that's very Jewish, okay? And actually, that's the theme. That's the theme of my comment, and that is that they all share they resonate with a certain distinctive engagement of Jews and the law, which is an identification of law, a distinct conception of law that relates to a rule of law that stands outside of politics, that has this outsider conception, outside of a law that remains disengaged and apolitical. So I want to talk about these very rich and diverse papers from that perspective. So Mitra Sharafi's paper approaches this theme through the analogy to the Parsi in the Indian legal system. And I thought she began and ended her paper with very interesting comparisons of the Parsi's status and treatment within the law with Jews, in particular the high percentage of lawyers in Germany and in Austria. In comparing with the Parsi in India, she ended her comments with this quote about how they were a peculiar people with no country of their own, no separate national life, but also simultaneously minorities who flourish in the law. And the real question is, what is the coherence of this comment, of the possibility of being a group that flourishes in the law but remains curiously without a national or political aspiration? So that's what I want to explore, is this potentially paradoxical phenomenon. How does it coexist? What view of law does this position represent? And how coherent is it, this conception of a law that is somehow autonomous or independent from politics? What's the legitimacy of it? And I want to say that a lot of the tensions and contradictions that this conception of the law represents are raised interestingly in this panel. So we might go next to the paper by Kenneth Ledford, which delves deeply into this phenomenon as it arose regarding the Jews in Germany. And I thought this paper was a haunting story. In general, we're quite used to a narrative of destruction that commences with the law. The destruction of German and Austrian Jewry beginning in the Nuremberg laws. But his paper traces a haunting cyclical story of exclusion, then inclusion, assimilation, and then exclusion again. So if you will, a fall, a rise, and a fall. And this is the story of the Jewish status and treatment under the law in Germany. And it has at the heart of it a culture war in Germany that was also played out over the law, which would lead to the simultaneous demise of both Jews and liberalism. This account, the account he gives, raises a lot of questions about Jewish involvement in the legal profession. In many ways, we can see how control of the law and the courts are a paradigm of public life and became a battleground for the fate of liberalism. It's evident in the jurisprudential debates over formalism in legal interpretation at the time. As I mentioned, the narrative that the Ledford paper tells about the creation of Germany and how there was exclusion at the time, he traces the continuity in exclusions, first how Jews found themselves outside civil society, and then the opening of the law through the 19th century, so that the closing of the law becomes a sign of the persecution and, in fact, paradigmatic of it, and always is the first indication of liberalism, and then again, the return of discrimination and persecution, and ultimately exclusion from humankind. Now, we are used to thinking about these uses of the law And he gives us and illuminates a historical provenance which sheds some light on the social acceptability of discriminatory law, its thinkability. As Arendt observed in her claim about banality, almost all of it had happened before, almost all of it short of the genocide. So this is what makes it acceptable. And so a very illuminating part of his story is this historical continuity. But the historical continuity also sheds some light on this interpretive question about the meaning of the law and how these persecutory laws were treated as law. And it takes us to the famous Hart-Fuller debate, the question of whether immoral laws, such as the ones that were being enacted at the time in Germany, should be treated as law. To what extent should law, which is conceitedly immoral in its racially discriminatory character, be treated as having the authority of law? Or is bringing this sort of interpretation, a moral interpretation, to bear wild and chaotic, depriving the law of rule of law? Now, in this debate over interpretation, Jewish lawyers took a very clear position. And this gets back to the central theme that I want to explore, and that is that in the battleground over the courts and the law, the Jewish view of this debate was constructed in part as a result of the challenge posed at the time by Carl Schmitt, theorist for the Reich, who as early as the late 1920s, in the concept of the political, expressed the friend-foe distinction as a conception of politics that was necessarily outside of any structure or framework of the law. And he positions himself with respect to the Jewish lawyers, and in particular Hans Kelsen, the influential proponent of formalism. So in engaging with this theorist and his ideas, Germany's Jewish lawyers took a certain pride in positivism. The fear was that the legal lens would become subject to politicization to their certain detriment. Hard to say which of the reasons predate Schmitt, but in this culture war context, what stands in relief is a view of rule of law seen in formalist positive terms. Likewise, Schmitt in this debate becomes known as the anti-legalist and later anti-Semite. Jewish lawyering becomes identified with a distinctive legal liberalism, which is characterized in terms of a legalism distinctive and disengaged from politics. The harder question is, to what extent is this formalism a Jewish phenomenon, itself a protective reaction against law as representing the will of a majority community and oppressive politics? That is, law conceived as a product of others' politics. Let us now move from the ashes of the Holocaust, where Ledford's paper ends, to Asaf Likovsky's paper, to where Asaf Likovsky's paper picks up. Turning now to the way these themes regarding the characterization of the law resonates in his paper on Jewish lawyers and the failed Jewish Revolution of 1948. Now, to some degree, there are dimensions of the narrative that involve a story of transition, something I've explored, rather than revolution. And when the term revolution is used, this imaginary, the imaginary is a distinct break. As Likovsky says, it's a shift to what was imagined was a broad-scale change of Jewish law, which would have involved a new political identity, a new Hebrew, juxtaposed to the pale, thin diaspora Jew. Now, it was clear from his story that the desert generation, with all of the Sinaitic metaphors of the 40 years of waiting, wasn't ready for that new identity. And to be sure, there are clear context of transition which suggests that expectation was overstated. It's very rare to have a complete legal change in periods of political flux when there aren't consolidated institutions. And in terms of the transition, it's the absence of significant transformation is to be expected. So I would say that from the beginning, we would think that this idea of a legal revolution, full legal reform, was probably overstated, and any change would fall short. And in fact, this story is rather common. The story in Israel is more common than not, and that in general there's at the very least partial legal continuity, and that it's rare to have complete discontinuity. Usually the line of legal change is symbolic. But I think that there are also interesting dimensions that relate to the theme of this apolitical law that helps us understand even more particularly why the founding fathers in Israel rejected the appeal of legal revolution. And that is, if you think back to the way we were considering the diasporic histories of how Jews had related to the law, we can better understand why the founders don't embrace a certain political potential transformation to Jewish law that would have related to the political founding of the state. Now, I want to explore a number of reasons that tie into how they favor a view of law that's disconnected from majoritarian politics and national identity, and in fact have a distinct skepticism and fear of this identity. The prevailing lawyers, as Asaf tells us, opposed ostensibly on self-serving grounds, preferring mandate law as a professional elite, and also conceiving for years English law as rule of law. So it's a puzzle. Why is the law that's retained associated with England, even though that's the law associated with the mandate and not with the new freedom and democratization? But as we can also see, by the mid-20th century and the founding of the state, there's already an established view of the law and a fear of the law understood in precisely the new terms that the state would have contemplated, and that is law is the product of the will of a majority. And as in all prior historical instances, this was persisted as being viewed as other people's law. What's interesting is that the skepticism didn't go away even when we were running, when Jews were running the political institutions. Because insofar as law is involved, it was seen as inevitably connected with politics, fear of that, and as representing a somehow oppression of the majority. Despite the establishment of the state, this view persisted. The narrative is that they weren't ready. That's how they call it. The same way as Germany reflects on its absence of a post-war constitution. It wasn't ready to entrench a constitutional identity or legal system, and they would remain transitional in this kind of limbo state. And there are very interesting parallels with Germany and Israel in that regard. Very often they would say that it had to do with demographics, that there were missing people that weren't there yet. So Germany refers to the East that way, that there wasn't unification with the East, and Israel would say that its diaspora was missing. But that's, this myth of unity, that unity would make them feel that that this wasn't going to be a law as a product of oppressive majority politics. So it's very, very interesting that way. Now, in terms of the appeal of halakha, halakhic law would have had to contend with two problems. One is the controversy over its provenance, and that is that it wouldn't get the new Israeli away from the history in the diaspora. It would seem to run into some of the many concerns relating to diaspora, but also because it would have involved a very arduous and difficult political struggle between conceptions of political and religious Zionism. So again, it would involve a legal identity that was tied up with a difficult political battle, and that was not to be contemplated. So in many regards, this was overdetermined. Many factors why at the founding of the state there was no sense of of bringing together the legal identity with the political, but rather inheriting the law and retaining a conception of law that remains outside of contemporary politics. Which brings me to the last paper by Pnina Lahav, which is the more recent chapter. And that is From Argentina to Pollard. She writes of two affairs which reflect an ambivalent relationship which I've been tracing now of Israel to the law, and in particular, I want to say international law. I found this paper of particular interest since my own family was bound up in the affair, and I learned something about why certain members of the family left at the time. But let me zero in on an ambivalent engagement with the law. And that is that by the time we reach the contemporary moment that she's describing, Israel's attitude on international law, and I hear this a lot because I'm involved in human rights, is being compared to American unilateralism and indeed American exceptionalism. And Pnina refers to the shared military commitments that might explain that. But I want to say that it's that the attitude and stance that Israel has adopted with respect to international law actually reflects
litigants and to their families, but also potentially to the community at large. And there are allegations of adultery, incest, addiction to opium, morphine and alcohol, and imbecility. But the fact that there were so many Parsi lawyers and judges to manage these disputes means that perhaps it's wrong to even assume from the beginning that this was really an outside forum. And this leads me to the 6 factors that may explain how the courts became the arena of choice for the making of careers and the breaking of reputations amongst the Parsis. Now, the first factor is a combination of time under colonial rule and a collective acceptance of English language education. In colonies like Nyasaland and northern Rhodesia, now Malawi and Zambia, there was no early 20th century non-European legal profession, in large part because British colonial rule came so late, that is in the 1880s and 90s. But even when a certain number of generations had been exposed to the colonizers' language and school system, some colonial communities still resisted Anglicization. And a number of colonial Indian Islamic movements, like the Deoband school, which was a movement in the north of India, immediately come to mind. In 1900, though, the Parsis of Bombay had been living in a territory that had been under British influence since the 17th century, and Bombay was handed over from Portuguese rule to British rule in 1661 as a wedding present from the Portuguese Princess Catherine of Braganza, who married the British monarch. The community had also taken on the role of intermediary traders between British and Indian merchants. So in many ways, the community had become highly anglicized. But there were limits. Neither intermarriage with Europeans nor conversion to Christianity figured into the Parsi affinity for British culture in a major way. And I would argue that anthropologist Tanya Luhrmann misreads the community when she describes it as aspiring to perfect Europeanization. This made the Parsis quite unusual for an anglicized colonial community because many westernized colonial elites typically intermarried at some point and also adopted Christianity. And the two best examples that come to mind immediately are the Anglo-Indians, previously known as Eurasians, of colonial India, who were the offspring of British men and typically lower caste Indian women, late 18th century, early 19th century. So there was both intermarriage and Christianization there. And also the Luso-African population of colonial Angola, who were an intermixed population that was sort of intermediary class in the slave trade in Angola. Same story there, intermarriage and conversion to Christianity. But the Parsis did not go this route. Now, the second factor is the relative size of the European population. In colonial India, it was relatively small. The 1911 census recorded that there were 244 million people in British India, of whom only 200,000 were European. So that's a ratio roughly of 1 European to every 1,200 South Asians. Obviously, this was not a white settler colony. It was typically in the white settler colonies that racial barriers to entry were erected when it came to entering the legal profession. And I'm thinking of the Cape Colony, South Africa, Canada, and Australia. By contrast, you can take an area like southern Nigeria, which was referred to as the white man's grave, for the reason that in a certain period, 18th century at least, the death toll of Europeans in the area was about 27% per year. So the population of European administrators in southern Nigeria was so tiny that the colony operated with a handful of undertrained white officials and crucially depended on a large number of Africans for essential services. As a consequence, there was a real African legal profession in southern Nigeria in the colonial period. The third factor is the community's wealth. And the joke is, and Mark Galanter will appreciate this, that there's no such thing as a poor or a thin Parsi. That joke is referring to the fact that the community was and is incredibly affluent. It made its wealth as shippers of opium in the opium trade, when that was a legal trade. And the opium trade, of course, also financed a major part of colonial rule in India. The Parsi community took the proceeds of that opium trade and invested it in industrial enterprise. And the man who is seen as the industrializer of India, a man named J.N. Tata, was a Parsi. So with all these interests in heavy industry and trade, it would seem that a familiarity with law would be vital to community success. A fourth factor has to do with internal hierarchies and structures in place for resolving disputes within the community. Parsi priestly authority was very decentralized. The western Indian state of Gujarat, as I mentioned, was the first place that the Parsis came to in India. And around the year 1290, the Parsi areas of Gujarat were divided into 5 dioceses called pantaks. And within each of those dioceses, there was a clear priestly family that would hold the final say when it came to any sorts of ritual questions. The problem was that between the pantaks, there was no single supreme authority. There was also the fact that there was no clear hierarchy of priestly authority in Bombay itself. And the reason for that was that when the Pantaks were established, Bombay was a tiny fishing village. It didn't become a city, as I mentioned, until Portuguese and then British rule. But there was never a clear priestly family that was put in authority for Bombay. So you would have the situation where Parsi families would look to their ancestral Pantak as the authority in any kind of disagreement. And potentially you could have a disagreement between Parsi families, each of which came from a different Pantak, and then you would have a deadlock. There was also a body called the Bombay Parsi Panchayat, and Panchayat means traditional council of elders, and Mark Galanter has done a lot of work on this area. And the Bombay Parsi Panchayat was created and supported by the British government, in part to settle disputes within the community. But a mid-19th century crisis over polygamy led to erosion of its general authority in the community, and the large number of lawsuits against trustees of the Panchayat and between trustees attest to that loss of authority. So the absence of a single strong authority, whether priestly or secular, within the community meant that there was a vacuum, and this was where the colonial legal system comfortably stepped in. There were other trading elites in Bombay that had heavily hierarchical internal chains of command and a single all-powerful head. The Bori and Khoja, or Ismaili Muslims, are two affluent communities of Shiite traders originally based in Gujarat, who also migrated to Bombay with the rise of colonial rule. They too must have had major commercial deals that occasionally went wrong between community members and required effective dispute resolution, but they also had a single head of the community whose authority was unchallengeable. For the Khojas, the Aga Khan enjoyed nearly divine status. And as the jolly third Aga Khan once confessed in the early 20th century, it's no beer and Skittles being a god. The ritual head of the Boris was called the Dai, and he resided for most of over the centuries in Yemen. And he also sat at the top of a clear pyramid of authority. So in both communities, effective excommunication was the penalty for anyone who took a dispute with another member of the community to an outside forum. The outcome was that most of these internal disputes never made it to the courts, unlike the Parsi situation. A fifth factor relates to the willingness of the Parsi community to share theological and ethnographic information about itself with the colonial state. And the absence of any sort of philosophical lock on the community's esoteric knowledge base meant that questions of theology and ritual pollution were made accessible to the colonial courts, letting the legal system into disputes that in other communities would have been reserved for the ritually privileged. Now, it's certainly true that Zoroastrian fire temples are strictly off limits to outsiders. The presence of any outsider defiles the temple's inner space, and reconsecration involves very costly and time-consuming procedures, increasing with the level of the ritual fire that's burning inside, and there are three basic levels. So Zoroastrianism certainly has a highly developed set of norms when it comes to spatial privacy. But when it comes to informational secrecy, things are different. Now, there was initial resistance to sharing the ancient and Middle Persian languages and texts of the Zoroastrians with Europeans, but this quickly dissolved in the early 19th century, and with it, the informational gates of Zoroastrianism were thrown open to the West. Compare this to communities with elaborate traditions of secrecy. Hugh Urban's work on tantric asceticism documents the many ways that that body of knowledge was kept out of reach of Europeans and other non-initiates for a good part of the colonial period. Tantra is a Hindu tradition of left-handed asceticism, as it's called. It offers its followers a fast track to enlightenment through the hazardous dark arts of Kali, who is the Hindu goddess of destruction. Now, the contents of the tantric belief system is accessible to initiates only. The Boris, whom I just mentioned, adopted a similar approach. Bori Shiites were required to take an oath of secrecy deriving from earlier periods of persecution in both Yemen and India. Both Bori and Khoja Ismaili communities also endorsed a doctrine of dissimulation called a taqiyya. This Shiite doctrine required a person to lie to protect the faith, and this could include fending off outsiders' data probes. Theosophists in colonial India also limited access to their beliefs for outsiders. Theosophy was a universalist spiritual movement that was fashionable worldwide in the late 19th, early 20th century. It was a New Age religion of its day. and it fused elements of Eastern religions, especially Hinduism and Buddhism, with a belief in communicating with the spirit world. Followers had to take a vow of secrecy that was binding even in the courtroom. And I came across a great example of this in my own research. There was a major solicitor amongst the Parsi community in Bombay, early 20th century, named Jahangir Bhima Dalal. And he was one of the most important solicitors in the city at the time, as well as being a theosophical leader and a big eugenicist. And he refused to testify on theosophy in proceedings without first being released explicitly by the leaders of the movement, namely a woman named Annie Besant at that time. By contrast, I found the same solicitor interrogating scores of Parsi witnesses on ritual practice and fire temple procedures during cross-examination in other suits in the exact same court. Now, this point relates more to Parsis as litigants than as lawyers, but as I said earlier, I'm convinced that the high rates of Parsi litigating and lawyering were closely linked. The sixth and last factor is a set of internal cultural traditions that made Parsis intellectually compatible with an adversarial common law system. Legal anthropologist Bernard Cohen has looked at traditional modes of South Asian dispute resolution, and he's found them to be highly conciliatory and face-saving in their style of interaction. British colonial courts, by contrast, were struck, or seemed to many South Asian communities at least, as not just baffling and opaque for their obsessive proceduralism, but also as confrontational and aggressive in style. When I asked Parsis in Mumbai about the Parsi passion for law, many say that every Parsi child is taught to develop a strong sense of independence of mind, and then to also learn how to be willing to fight for the truth, no matter how many people may disagree with his or her opinion. What they're referring to is a Zoroastrian doctrine called Asha, and Asha means truth and moral righteousness. Zoroastrian theology is riddled with martial imagery associated with the good Zoroastrian's duty to decide for him or herself what is right, and then to fight for it militantly. And this tradition, I think, dovetails very nicely with an adversarial mode of colonial law, and it may have made the colonial legal system a good fit with many Parsis. So just to recap these 6 factors behind Parsi legalism, the first was time under colonial rule and a willingness to anglicize. The second was having a small European population, in other words, not living in a white settler population. The third was having major commercial interests as a community. The fourth was having decentralized and discredited internal systems of dispute resolution. Fifthly, having really no protection of esoteric knowledge, that is, having a strong sense of spatial privacy but not of informational secrecy. And sixthly, having an internal tradition of confrontational intellectual exchange. So finally, some comparative conclusions. How does the Parsi lawyering tradition align with the Jewish case study? Muller's work suggests that Jews in the German-speaking world in the early 20th century were excluded from the civil service and went into law instead. Similarly, in India, the Indian civil service was made so accessible to South Asians, at least at the upper covenant level, that very few Parsis were actually able to gain access. What's interesting is that even after independence in 1947, Parsis continued to concentrate on the legal profession. In the run-up to 1947, they were markedly absent from political negotiations surrounding independence. The Parsis did not lobby for separate electorates or for a reserved portion of state positions, unlike many other Indian minorities, amongst them the Muslims and the scheduled castes and tribes. After independence, many of India's top constitutional legal figures have been Parsi. So both Parsi and German-speaking Jewish communities focused upon the legal profession at a time when they're effectively excluded from governmental careers, it seems. And in the Parsi case, this continued even after those restrictions had been lifted. Applying these factors to the Jewish example, the big question for me is whether there is also a close link between lawyering and litigating. Did many disputes between members of the Jewish community in the German-speaking world land in court? And if so, was this in part because the community's internal organs for dispute resolution were decentralized or somehow discredited? If any of these disputes turned upon questions of ritual and religion, was this because, as for the Parsis, there was no protection of the community's esoteric knowledge base? And finally, would it be fair to say that there was an intellectual compatibility between Jewish traditions and German-speaking legal culture in the 1930s? To close, I just want to leave you with the comments of a British judge named Frank Beeman, who is actually blind, who ruled in 1908 on a very important case in the Bombay High Court on whether Zoroastrianism permitted conversion. And it was decided in part by him in that case that it did not. Beeman himself had Jewish ancestry, which only became apparent to me through oral history. I managed to find his great-grandson who lives in Dublin. And the great-grandson told me that on Beeman's mother's side, the mother's side of the family were descendants of the Gomberts family, which was an illustrious British Jewish family that converted to Anglicanism in the mid-19th century. Beeman's family background made one of his comments in this judgment quite intriguing. According to Beeman, the Parsis of India were much the same as the Jews. And I'm quoting here, a peculiar people with no country of their own, no separate national life of their own. Both communities were guests on sufferance of races, of peoples who had nothing whatsoever in common with their religious organization. Now, of course, Beeman might have added that there was another parallel trait between the two communities, and one presumably very close to his own heart, and that is that both were minorities that flourished in the law.
Thanks a lot. It was really illuminating comparison. We will conclude our presentations with a comment by Ruti Teitel, who is Ernst C. Staffel Professor of Comparative Law at the New York Law School. She is a graduate of Georgetown University and the Cornell Law School. Professor Teitel is a nationally recognized authority on international law, international human rights, and constitutional law. She is also an expert on Eastern European and Latin American post-totalitarian societies. Among her many publications is her path-breaking book, Transitional Justice, which examines the 20th century transitions from authoritarian to democratic regimes in many countries. Professor Teitel will comment on the various ideas and presentations that we heard in this panel. Please.
Let me add to the thanks to the organizers of this very interesting conference, and in particular the last set of very rich papers. The diverse papers we heard cross country lines and historical periods. They go as far back as Zoroastrianism and as far forward as the contemporary Pollard affair, to transnational, around the world, Germany and Argentina, diasporas, to Israel since its founding. All of them engage with the conference topic regarding Jews and the law and the legal profession. They also build, interestingly, on the first panel on legalism yesterday morning. Now, I thought it was interesting that each author wanted to get the prize of the most outside of the subject of the conference. Oh, that's very Jewish, okay? And actually, that's the theme. That's the theme of my comment, and that is that they all share that they resonate with a certain distinctive engagement of Jews and the law, which is an identification of law, a distinct conception of law that relates to a rule of law that stands outside of politics, that has this outsider conception, outside of a law that remains disengaged and apolitical. So I want to talk about these very rich and diverse papers from that perspective. So Mitra Sharafi's paper approaches this theme through the analogy to the Parsi in the Indian legal system. And I thought she began and ended her paper with very interesting comparisons of the Parsi's status and treatment within the law with Jews, in particular the high percentage of lawyers in Germany and in Austria. In comparing with the Parsi in India, she ended her comments with this quote about how they were a peculiar people with no country of their own, no separate national life, but also simultaneously minorities who flourish in the law. And the real question is, what is the coherence of this this comment of the possibility of being a group that flourishes in the law but remains curiously without a national or political aspiration. So that's what I want to explore, is this potentially paradoxical phenomenon. How does it coexist? What view of law does this position represent? And how coherent is it, this conception of a law that is somehow autonomous or independent from politics? What's the legitimacy of it? And I want to say that a lot of the tensions and contradictions that this conception of the law represents are raised interestingly in this panel. So we might go next to the paper by Kenneth Ledford, which delves deeply into this phenomenon as it arose regarding the Jews in Germany. And I thought this paper was a haunting story. In general, we're quite used to a narrative of destruction that commences with the law. The destruction of German and Austrian Jewry beginning in the Nuremberg laws. But his paper traces a haunting cyclical story of exclusion, then inclusion, assimilation, and then exclusion again. So if you will, a fall, a rise, and a fall. And this is the story of the Jewish status and treatment under the law in Germany. And it has at the heart of it a culture war in Germany that was also played out over the law, which would lead to the simultaneous demise of both Jews and liberalism. This account, the account he gives, raises a lot of questions about Jewish involvement in the legal profession. In many ways, we can see how control of the law and the courts are a paradigm of public life and became a battleground for the fate of liberalism. It's evident in the jurisprudential debates over formalism in legal interpretation at the time. As I mentioned, the narrative that the Ledford paper tells about the creation of Germany and how there was exclusion at the time, he traces the continuity in exclusions, first how Jews found themselves outside civil society, and then the opening of the law through the 19th century, so that the closing of the law becomes a sign of the persecution, and in fact paradigmatic of it, and always is the first indication of liberalism, and then again, the return of discrimination and persecution, and ultimately exclusion from humankind. Now, we are used to, thinking about these uses of the law. And he gives us and illuminates a historical provenance which sheds some light on the social acceptability of discriminatory law, its thinkability. As Arendt observed in her claim about banality, almost all of it had happened before, almost all of it short of the genocide. So this is what makes it acceptable. And so a very illuminating part of his story is this historical continuity. But the historical continuity also sheds some light on this interpretive question about the meaning of the law and how these persecutory laws were treated as law. And it takes us to the famous Hart-Fuller debate, the question of whether immoral laws, such as the ones that were being enacted at the time in Germany, should be treated as law. To what extent should law, which is conceitedly immoral in its racially discriminatory character, be treated as having the authority of law, or is bringing this sort of interpretation, a moral interpretation, to bear wild and chaotic, depriving the law of rule of law? Now, in this debate over interpretation, Jewish lawyers took a very clear position. And this gets back to the central theme that I want to explore, and that is that in the battleground over the courts and the law, the Jewish view of this debate was constructed in part as a result of the challenge posed at the time by Carl Schmitt, theorist for the Reich, who as early as the late 1920s, in the concept of the political, expressed the friend-foe distinction as a conception of politics that was necessarily outside of any structure or framework of the law. And he positions himself with respect to the Jewish lawyers, and in particular Hans Kelsen, the influential proponent of formalism. So in engaging with this theorist and his ideas, Germany's Jewish lawyers took a certain pride in positivism. The fear was that the legal lens would become subject to politicization to their certain detriment. Hard to say which of the reasons predate Schmitt, but in this culture war context, what stands in relief is a view of rule of law seen in formalist positive terms. Likewise, Schmitt in this debate becomes known as the anti-legalist and later anti-Semite. Jewish lawyering becomes identified with a distinctive legal liberalism, which is characterized in terms of a legalism distinctive and disengaged from politics. The harder question is, to what extent is this formalism a Jewish phenomenon, itself a protective reaction against law as representing the will of a majority community and oppressive politics? That is, law conceived as a product of others' politics. Let us now move from the ashes of the Holocaust, where Ledford's paper ends, to Asaf Likovsky's paper, to where Asaf Likovsky's paper picks up. Turning now to the way these themes regarding the characterization of the law resonates in his paper on Jewish lawyers and the failed Jewish Revolution of 1948. Now, to some degree, there are dimensions of the narrative that involve a story of transition, something I've explored, rather than revolution. And when the term revolution is used, this imaginary, the imaginary is a distinct break. As Likovsky says, it's a shift to what was imagined was a broad-scale change of Jewish law, which would have involved a new political identity, a new Hebrew, juxtaposed to the pale, thin diaspora Jew. Now, it was clear from his story that the desert generation, with all of the Sinaitic metaphors of the 40 years of waiting, wasn't ready for that new identity. And to be sure, there are clear context of transition which suggests that that expectation was overstated. It's very rare to have a complete legal change in periods of political flux when there aren't consolidated institutions. And in terms of the transition, it's the absence of significant transformation is to be expected. So I would say that from the beginning, we would think that this idea of a legal revolution, full legal reform, was probably overstated, and any change would fall short. And in fact, this story is rather common. The story in Israel is more common than not, and that in general there's at the very least partial legal continuity, and that it's rare to have complete discontinuity. Usually the line of legal change is symbolic. But I think that there are also interesting dimensions that relate to the theme of this apolitical law that helps us understand even more particularly why the founding fathers in Israel rejected the appeal of legal revolution. And that is, if you think back to the way we were considering the diasporic histories of how Jews had related to the law, we can better understand why the founders don't embrace a certain political potential transformation to Jewish law that would have related to the political founding of the state. Now, I want to explore a number of reasons that tie into how they favor a view of law that's disconnected from majoritarian politics and national identity, and in fact have a distinct skepticism and fear of this identity. The prevailing lawyers, as Asaf tells us, opposed ostensibly on self-serving grounds, preferring mandate law as a professional elite, and also conceiving for years English law as rule of law. So it's a puzzle. Why is the law that's retained associated with England, even though that's the law associated with the mandate and not with the new freedom and democratization? But as we can also see, by the mid-20th century and the founding of the state, there's already an established view of the law and a fear of the law understood in precisely the new terms that the state would have contemplated, and that is law is the product of the will of a majority. And as in all prior historical instances, this was persisted as being viewed as other people's law. What's interesting is that the skepticism didn't go away even when we were running, when Jews were running the political institutions. Because insofar as law is involved, it was seen as inevitably connected with politics, fear of that, and as representing a somehow oppression of the majority. Despite the establishment of the state, this view persisted. The narrative is that they weren't ready. That's how they call it. The same way as Germany reflects on its absence of a post-war constitution. It wasn't ready to entrench a constitutional identity or legal system, and they would remain transitional in this kind of limbo state. And there are very interesting parallels with Germany and Israel in that regard. Very often they would say that it had to do with demographics, that there were missing people that weren't there yet. So Germany refers to the East that way, that there wasn't unification with the East, and Israel would say that its diaspora was missing. But that's, this this myth of unity, that unity would make them feel that that this wasn't going to be a law as a product of oppressive majority politics. So it's very, very interesting that way. Now, in terms of the appeal of halakhic law would have had to contend with two problems. One is the controversy over its provenance, and that is that it wouldn't get the new Israeli away from the history in the diaspora. It would seem to run into some of the many concerns relating to diaspora, but also because it would have involved a very arduous and difficult political struggle between conceptions of political and religious Zionism. So again, it would involve a legal identity that was tied up with a difficult political battle, and that was not to be contemplated. So in many regards, this was overdetermined. Many factors why at the founding of the state there was no sense of of bringing together the legal identity with the political, but rather inheriting the law and retaining a conception of law that remains outside of contemporary politics. Which brings me to the last paper by Pnina Lahav, which is the more recent chapter. And that is, from Argentina to Pollard, she writes of two affairs which reflect an ambivalent relationship which I've been tracing now of Israel to the law, and in particular, I want to say international law. I found this paper of particular interest since my own family was bound up in the affair, and I learned something about why certain members of the family left at the time. But let me zero in on an ambivalent engagement with the law. And that is that by the time we reach the contemporary moment that she's describing, Israel's attitude on international law, and I hear this a lot because I'm involved in human rights, is being compared to American unilateralism and indeed American exceptionalism. And Pnina refers to the shared military commitments that might explain that. But I want to say that it's that the attitude and stance that Israel has adopted with respect to international law actually reflects